board business for today. We have some new members today, so I think what would be appropriate for us to go around the room. Tell us your name, what firm you're with, where you're from, just so kind of everybody can get an introduction, especially with all the new members here. So, Henry, could you start us off?
Yes, I'm Henry Haas, from Chattanooga, with the firm of Bartow, Haas & Company.
I'm Vic Alexander, practice CPAs here in Nashville.
Gabe Roberts, the attorney member. I'm at the Sherrard Murray Law Firm here in Nashville.
Steve Meldridge, I'm with Alexander Thompson Arnold, New Jackson, Tennessee.
Corey Brewer,
Here in Tennessee.
I'm Casey Stewart with Hazel Wilson Beaver, Chattanooga, Tennessee.
I'm Trey Watkins. I'm with Watkins Uberall CPA firm in Memphis.
Bill Bloffus. I was with KPMG for 37 years. In recent years, corporate director.
Stan Sawyer from Bankston and Waco, Memphis.
I'm Jennifer Brendan. I'm a public member and I work at a law firm here in Nashville for the law group.
Don Royston, East Tennessee, Kingsport, Cape Associates,
Okay. Vic is a returning member to the board, so we'd like to have that experience back here with us. And all the new members, thank you. Secondly, we just want to recognize Lisa Stickle and Shannon Rabone for their work on the board as they rotated off this past time. They served the board well for 6 years and gave a lot of support. They'll be missed. So, that is in a waiting mode. Feel free to talk.
Sure is pretty outside.
It's cooler here than it is. A meeting on the board's website and on the department's website on Tuesday, October 9th, 2012. I'll turn it over to the judge.
Good afternoon, members of the board. This is a hearing before the Tennessee Department of Commerce and Insurance to consider the matter of the Tennessee Board of Accountancy in the matter of Robert E. Bell, CPA, license number 3250, doing business as Springfield Tax Service, CPA firm permit number 1966, 4450 Mount Zion Road, Springfield, Tennessee, 37172. Docket number 12.19-1176858A. Today is October the 18th, 2012. I am Lynn England, and I've been assigned by the Secretary of State to preside over the hearing of this matter as administrative judge. As administrative judge, I will not participate in the hearing on the merits of this matter today. The members of the board that are present will make that decision. However, I will make all rulings of law, evidence, and procedure under the authority granted to me by the Administrative Procedures Act. Will the members of the board that are present this morning please identify yourself for the record?
Start over here with
Don Royston,
Jennifer Brendan.
Stan Sawyer.
Bill Bloffus.
Trey Watkins.
Casey Stewart.
Steve Meldridge.
Gabe Roberts, Vic Alexander.
Henry Haas.
Mr. Chairman, do you have a quorum?
We do have a quorum.
Thank you. Members of the board, you are reminded that during the course of this hearing, no discussion may take place between each other, between board members and witnesses, board members and attorney, or any other persons outside of this hearing. At this time, I will ask if any member of the board has any prior knowledge of this matter or has received any ex parte communication, either written or oral, concerning the matter that you're about to hear today. We'll show it to them. Okay. Members of the board, the department is represented today by Mr. Jesse Joseph, and the respondent is not here, nor is he represented by counsel. Mr. Joseph, what proof of notice of this hearing, of service of notice of this hearing do you have to the respondent?
signed by the respondent reflecting that the respondent was served with a copy of the notice of hearing and charges on August the 11th, and we got that marked with our first exhibit number 1, Brian.
May I have that?
That's Commissioner's comments. And by the way, the same certified mail number is the certified mail number that was referred to in our certificate of service.
I do find that you have good proof of notice of service at the hearing today by signature of the respondent, date of delivery, August the 11th, 2012. Mr. Joseph, I will enter this into the record and identify it as Exhibit 1. Do you have a motion?
Well, Your Honor, based upon the respondent's failure to appear or to defend after being properly served with a copy of the notice of hearing and charges, the state would respectfully request that the court declare the respondent in default pursuant to Tennessee Code annotated 45309 and allow the state to proceed in this matter as if the matter were uncontested.
Thank you, Mr. Joseph. Mr. Chairman, pursuant to the Secretary of State's Rules of Procedure for Contested Case 1360-4-1-.15, the board may now decide whether to grant the state's motion for a default.
We grant the motion.
You have to do that by vote. Yes, sir.
This is my first meeting.
That's quite all right.
Point that out. We'll do that with a roll call, I guess. Is that appropriate?
You may, someone needs to make a motion and have it second.
I'll second. Okay, we'll get a proper motion, a proper second. Is there any discussion? Hearing none, proceed with the roll call vote starting with Mr. Holmes.
Do it.
Could you repeat the question? The question
Yes,
is
you're
whether
going
it's
to
default,
decide
right?
whether or not to grant the motion, the
Motion
state's
that is in
motion for
default.
default.
I
And
grant. Okay. I say
Okay.
yes.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Yes.
Yes.
thank you. Now, members of the board, you will decide whether or not to conduct the hearing today in absence, because the state does carry the burden of proof in this matter. You may also choose to consider this matter and set it for hearing on another day. You will now determine which you would rather do.
Have a motion for hearing the case.
Make a motion to go ahead and hear the case today as scheduled.
Have a second.
Second.
Any discussion? Hearing none, let's go with the vote.
Yes.
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 Thank you. The technical record in this matter consists of the notice of hearing and charges filed on August the 1st, 2012, a pre-hearing order issued on August the 20th, a notice of the deposition of Mr. Roth filed October the 4th, the state's notice of service filed October the 4th, an order on a pre-hearing conference filed by the state October 7th, the state's witness and exhibit list filed October the 11th, an amended witness and exhibit list filed October the 11th, and an order on a pre-hearing conference was issued on October the 12th. Without objection, I'll enter this as the technical record up until this point. Now, members of the board, during the hearing, you will sit as a jury. You will only consider the evidence that is introduced during the hearing. You're further reminded that your decision in this matter will be based only on the record that is produced during the course of the proceedings today. The Sunshine Law requires that all discussions of the board and all deliberations of the board be made in public before the parties. Failure to abide by these instructions could result in the matter being reversed upon appeal or the matter being remanded to the board for further consideration and further hearing. During the course of this hearing, there will be an opportunity for each of you to question each witness that testifies under oath. You should reserve any expression of opinions you may have on the facts until the portion of the hearing which is set aside for your deliberations once the state has presented all the proof in this matter. Unless there are any questions at this time, I will ask Mr. Joseph, are you ready to proceed?
Yes.
Yes, Your Honor.
Would you like to make an opening statement?
I would like to distribute the notice of hearing and charges first.
You may do so at this time. Thank you. members of the board, Mr. Joseph, proceed at this time. Thank you.
Good morning, members of the board. My name is Jesse D. Joseph, Assistant General Counsel for the Tennessee Department of Commerce and Insurance. I'm one of the litigation attorneys for the department. As the board can ascertain, this matter involves what the state believes is to have been a Ponzi scheme operated by this respondent and the late William Edward Hood, who is called Ed Hood, a former Edward Jones broker from Springfield, Tennessee, who committed suicide on September the 18th, 2007. The state believes that the proof in this matter will show that the respondent knowingly participated in this scheme along with Mr. Hood, which was designed to separate these depositors from their money. These depositors were in many instances some of the respondent's own tax clients and Mr. Hood's Edward Jones clients. We believe that the proof will show that before 2002, the respondent was utilizing the Robert E. Bell escrow account at Volunteer State Bank, and that at sometimes in late 2005, he closed that account and opened another escrow account at Regions Bank. The state's investigator has performed an analysis and an accounting of both of these escrow accounts from January of 2002 through November the 30th of 2006 to the best of his ability based upon documentation consisting of more than 10,000 bank records obtained by the Office of the Attorney General. The proof will document and demonstrate that the respondent opened these escrow accounts upon the request of Mr. Hood, and that the majority of the deposits into these accounts over this time period were brought to the respondent by Mr. Hood or were wire transfers from Edward Jones' clients into the respondent's escrow account. In many instances, as we've already noted, these were also the respondent's own tax clients. To summarize, the evidence reflects that as to both of these accounts, the respondent's own personal withdrawals and personal transfers to him to benefit himself or other businesses which he owned or had an ownership interest in exceeded his personal deposits by over $748,000 between January of 2002 and the end of November of 2006. The proof will also show that more than 1 million of these depositors' funds were misappropriated by Mr. Hood to his own benefit during this time period. The first major depositor involved in this proceeding was Florence M. Wilkinson. The proof will show that Mrs. Wilkinson deposited over $1,300,000 between August of 2004 and September of 2006 into both of these escrow accounts, and that only approximately $45,000 of these total deposits were returned to her benefit by the respondent. It will also be shown that this individual was one of the respondent's tax clients from 1995 through 2005 roughly, and was also one of Mr. Hood's Edward Jones clients. She was 98 years old when deposits from her funds began to be made into the respondent's accounts. And she executed a durable power of attorney for financial management, appointing the respondent as her attorney-in-fact to handle any and all business or financial matters for her in January of 2006. The proof will also show that after Mrs. Wilkinson's death in December of 2006, on August the 15th of 2007, her estate, through her executor, filed suit in Davidson County Circuit Court against the respondent, Ed Hood, and Edward Jones, alleging conversion of Mrs. Wilkinson's funds for an accounting and for the defendants to return any monies wrongfully misappropriated. On September the 17th of 2007, the respondent's deposition was taken in this circuit court suit. And on the next day, September the 18th, 2007, Ed Hood committed suicide. The proof will also show that the respondent testified in deposition in 2007 that he had kept no ledger of the receipts and disbursements in these escrow accounts, that he had performed no accounting, and that he always kept it in his head whose money was whose regarding these escrow accounts, and that he always put his own money back into the escrow accounts if he wrote checks from these accounts for his own use and benefit, and that he believed the net effect on the accounts was zero. The second major depositor involved in this matter was Richard and Ruby Rowe. Richard Rowe was one of the respondent's tax clients, and both the respondent and Ed Hood borrowed money from the Rowes. The proof will show that the Rowes deposited over $527,000 into these escrow accounts and only received back a little over $179,000 for their own benefit during the applicable time period. Incidentally, going back to the circuit court lawsuit involving Mrs. Wilkerson, the record before the circuit court also reflects further that a third-party lawsuit was filed against the respondent by Edward Jones for indemnity or contribution and for an accounting in 2011. That the respondent did not answer this suit and a judgment by default was entered against him in circuit court as prayed for by Edward Jones, and that the amount of damages would be determined later pursuant to a further court hearing. Edward Jones has certified in his default certificate filed in the Davis County Circuit Court that it seeks $2 million in indemnity against the respondent. Going now to the third major depositor, we have Carney and Bonnie Bell and the company named Carrot Patch Incorporated. The Carrot Patch is a costume and collegiate jewelry business in Springfield, Tennessee, and Bonnie Bell and Dick Rolfe, her son, are the owners. The proof will show in this regard that the respondent received over $880,000 from these depositors over the pertinent time period and only returned a little over $413,000 for their benefit. Proof will also show that the respondent was responsible for advising the Carrot Patch on the compensation numbers and the projected contributions to the Carrot Patch defined benefit plan in the early 2000s and through the approximately 2006, and particularly during 2001 and 2002, the respondent received several communications from the pension administrator in Illinois for the plan. This individual's name was Jerry Davis, who had problems about the respondent's failure to return phone calls or faxes, for the respondents taking a $50,000 deduction for the plan on a 2001 tax return without providing any backup or any documentation that that deduction was appropriate, and because there were substantial funding deficiencies for the plan. The pension administrator threatened to contact the respondent's clients directly, Carrot Patch, and on October 1st, 2002, he explained that he could not do the work on the plan tax forms if the respondent continued to fail to respond. The proof will also show that the respondent advised Carrot Patch to terminate the services of Jerry Davis as pension administrator in September of 2003, which Mr. Rolfe did, and that the respondent and Ed Hood recommended to Carrot Patch that it terminate its defined benefit plan, all without the respondent disclosing to the client that such a termination would subject Carrot Patch to severe tax penalties and interest from both the IRS and the United States Department of Labor for ERISA violations. The state's proof will also show that the respondent issued at least 8 promissory notes to clients dated back to 1998, which were unregistered securities, and his actions are inconsistent with the requirements of the Tennessee Securities Act of 1980, since he's not a registered broker or agent in the state of Tennessee. At least for 2 or 3 years after 2008, the respondent has admitted that he was investigated by the TBI, the Office of the Attorney General, and a local district attorney for possible criminal action. However, no criminal charges were ever filed against him. The state has also been made aware of such an investigation and was in communication with the Tennessee Attorney General's office over the past several years, and we acted in what we consider to be a prudent fashion by choosing to await the outcome of a criminal investigation before going forward with the formal charges herein. At the conclusion of all of the proof, we submit that we will have proven all of the allegations which are set forth in our notice of hearing charges. We will have proposed findings of fact and conclusions of law separately set out for you all after the board has heard all of the proof. We believe that these will have been proven at least by a preponderance of credible evidence. And based upon this record and the consistent pattern of egregious behavior by the respondent and his fraud and misappropriation, we would request that the board revoke the respondent's CPA license at least for a 5-year period and assess at least a civil penalty of $110,000. This would represent a civil penalty of $2,000 per month for 55 months between April of 2002 through November of 2006, for which we have evidence that the respondent consistently misappropriated funds out of the escrow account for his personal use and benefit. We would also note that the board's rules and the board's statutes permit the board to assess a civil penalty of up to $1,000 for each day of a continued violation, and that the state could very well seek a much more severe civil penalty if it chose. We would request that the board, at the conclusion of all the proof, assess the investigatory and hearing cost of this cause against the respondent and rule that the respondent would be required to pay any civil penalty imposed by this board, as well as all of the costs imposed in this proceeding, before he is eligible to file any petition for reactivation of his license or any application for a new license. Thank you very much.
You may call your first witness.
Your Honor, for the record, could we distribute to the board copies of Exhibit 1? We made copies for them, and that was the certified mail return.
You may.
Thank you. The state would call as its first witness Mr. Don Mills.
Can I ask a question?
Yes, sir.
Is he still practicing?
You'll have to wait until at the end of the, unless that's brought in. Raise your right hand. Do you solemnly swear or affirm the testimony you might give today will be the truth, the whole truth, and nothing but the truth? Thank you very much.
Good afternoon. Could you please state your full name for the record, sir?
Donald A. Mills,
And what is your business address, Mr. Mills?
500 James Robinson Parkway, Nashville.
And you are an employee of the Tennessee Board of Accountancy, correct?
Yes.
And what is your position?
I'm one of the investigators
And how long have you served in that capacity, sir?
since January of 2009.
Have you prepared a curriculum vitae which you have provided me which sets forth your experience, training, and professional membership?
Yes.
Is a copy of the document which I'm showing you now a copy of that curriculum vitae?
It is.
And does it accurately set forth your professional memberships, your accomplishments, your education, and your training?
Yes.
Your Honor, we would ask that Mr. Mills' curriculum vitae be admitted into the record as exhibit number 2.
I will enter Mr. Mills' CV into the record, identifying it as exhibit number 2.
You are licensed as a CPA in Tennessee, correct, Mr. Mills?
Yes, sir.
And how long have you been so licensed, sir?
I was first licensed in 1988.
Are you licensed as a CPA in any other states?
No, sir.
Do you have a bachelor's degree?
Yes, I did.
From where did you obtain it, and what did you obtain it in?
My bachelor's degree is from the University of Tennessee, Knoxville. It's in microbiology.
And when did you obtain your bachelor's?
1975.
Did you do any other undergraduate work after obtaining your bachelor's degree?
I did.
And what did you do?
I majored in accounting and business at Middle Tennessee State University.
You are currently one of the investigators regarding complaints brought before this board.
Yes.
And you've done that for 3 years?
Yes, sir.
According to your curriculum vitae, immediately before you came to work for this board, what did you do?
I was the internal auditor for Hamilton County Board of Education.
How long?
7 years.
How many fraud investigations did you conduct for Hamilton County for the Department of Education?
Approximately 15, 18.
What types of fraud were you finding while working for Hamilton County?
Primarily, we had fraud with in the student activity funds, some general purpose school funds. We also had a case of a principal who was taking PTA monies, and we had a federal case involving the school nutrition program and a federal program through the city of Chattanooga.
Can you describe what a special investigation entailed while you were working with the Hamilton County Department of Education?
My special investigations would come about basically as an assignment from the superintendent of schools, where there was a question. We didn't always find fraud. In fact, sometimes we vindicated the person who had been accused.
Now, before you worked for Hamilton County, you were a staff accountant for Deborah Davidson between 2000 and 2002, correct?
That's correct.
What did you do while working for Ms. Davidson?
Basically, staff accountant matters, bookkeeping, payroll, tax returns, compilation review service.
Before working for Ms. Davidson, you ran your own CPA firm, did you not?
I did.
And the name of that firm was Mills & Company CPAs? And this was between 1996 and 2000?
That's correct.
What was the nature of your work when you owned your own CPA firm?
Well, we did have general write-up work, tax returns, partnerships, corporate, that sort of thing. But primarily we start out with governmental account auditing firm under contract with the Division of Municipal Audit, doing cities, school districts, certain not-for-profits, and utilities.
And immediately before you opened your own CPA firm, you performed government audits with the Division of Municipal Audit?
I was actually with the firm in Chattanooga between that and being with the comptroller's office.
And that was Jackson, Johnson, and Murphy?
That's correct.
How long did you work for Jackson, Johnson, and Murphy?
Approximately 5 years.
What did you do for them?
I started out as a staff accountant, and after 2 years with the firm, I was made a partner. I was the primary engagement partner for all governmental audits and performed a single audit.
And before you came to Jackson, Johnson, and Murphy, you worked for the Division of Municipal Audit for the State Controller's Office, correct?
That's correct.
For how long?
4 years.
What type of work did you do while there?
We were assigned review work of the contract audits that came in from the various CPA firms throughout the state. We also performed fraud audits and special audits as they came up within our own assigned territory. We did working paper reviews for those CPA firms that performed yellow book audits for municipal audit.
You are a member, according to your curriculum vitae, of the Tennessee Society of CPAs, correct?
Yes, I am.
What is the Tennessee Society of CPAs?
The Tennessee Society of CPAs, I would say it's an organization that is primarily concerned with the enhancement of the profession of public accounting here in Tennessee. In my opinion, they provide probably the best CPE in the state. They oversee our peer review program. They also keep the members up with what's going on within the legislature, other things that might have an effect on the practice of accounting in Tennessee.
All right. You're also a member of the American Institute of CPAs, correct?
I am.
What is the purpose of the American Institute of CPAs?
Well, the American Institute is in some ways like the Tennessee Society, only on a national scale. And the American Institute really is much more technically skewed in its relationship with the practitioner, in that all of our auditing standards, or other attestation services, even tax, valuation, consulting services. The American Institute is responsible for the formulation and adoption of those standards for all the CPAs in practice. And primarily, they also, I shouldn't say primarily, but in addition, they have the professional ethics, which we all promise to abide by.
All right. Okay. The American Institute of CPAs is referred to as AICPA, correct?
That's correct.
You are also, according to your curriculum vitae, a certified fraud examiner, which is a CFE, correct?
Yes.
What is a CFE?
A CFE is merely a designation of someone who has met the criteria of the Association of Certified Fraud Examiners. You have to pass a 500-question test. You have to have an education history and a work history that shows your background in fraud auditing. And you have to have recommendations from people that are already in the industry.
What organization grants this certification?
It is the Association of Certified Fraud Examiners.
How long have you been a CFE?
Just over a year.
And what are the requirements in order to keep this certification?
I'm required to do a continuing professional education specifically related to fraud auditing and fraud in general.
Have you ever taught any continuing education courses offered for credit to Tennessee CPAs?
For the past 3 years, I have taught the state-specific ethics course on behalf of the board.
Have you ever written any articles published in any professional journals in the field of accounting?
The executive director and I co-authored an article in the Tennessee Society Journal of, I guess about a year ago, regarding upcoming changes in the rules that were going to be adopted by the Board of Accountancy.
Have you ever received any other professional awards as a CPA?
I did receive the Certificate of Achievement in Governmental Accounting and Auditing. It was given by the American Institute, I think back in '93.
Has there ever been a judgment entered against you in a court case where you were a party wherein you were adjudged to have committed professional malpractice or breach of professional standards?
No.
How many fraud investigations have you performed while you were employed by Hamilton County Department of Education?
I would say 15, probably maybe as many as 20.
How many such investigations did you perform while employed by the Division of Municipal Audit?
Probably 8 to 10.
How many total accounting investigations have you performed in complaints which have arisen before this board?
Complaints before this board. Well, let's see, I've had total investigative reports of just over 200 cases, specifically related to fraud.
I've asked you how many total investigations you performed.
Just over 200.
How many of those complaint investigations have involved fraud allegations?
I would say 4.
Have you ever been accepted as an expert witness in any court cases in Tennessee or in any other states?
Yes.
How many times?
Once in Tennessee and once in Georgia.
And what were the types of cases?
The one in Georgia was a civil suit based on non-acceptance of a single audit by a firm. I testified that the firm, based on the review of the working papers, met the criteria. There was not an audit failure. In Tennessee, I was an expert witness in a grand jury hearing. This is going back to the principal in the school system who was subsequently convicted of failing from the PTA.
Have you ever been accepted as an expert witness in administrative proceedings before this board?
Yes.
How many times?
Once.
Your Honor, on the basis of this witness's education, training, and experience, we would tender him to the board as an expert in accounting and in the field of auditing for fraud.
I'll recognize this witness as an expert witness.
Do you know the respondent in this case, Mr. Mills, Robert E. Bell, CPA?
Yes, I do.
And how do you know him?
I have met with him on at least 2 occasions with regard to this case.
Do you have any bias or prejudice against him, sir?
I do not.
Tell the board how the matters involved in this notice of hearing and charges came before your office.
When I started in 2009, in January 2009, the case had already been opened, I think, as of 2007. However, there had been no action taken as far as the investigation because we were waiting on, I guess, the Securities Division as well as the TBI. We even had heard IRS, AAG's or the Office of the Attorney General. Historically, our investigations have waited until all civil and criminal actions have been concluded before we start up. So,
And when were the matters that involved these complaints submitted to your office?
The first complaint was actually opened, I think, in November of 2007.
And were there additional complaints that came in?
There were. In March of 2009, we received, within a period of 30 days, 4 additional complaints.
During your investigation of this matter, did you obtain documents to assist you in your investigation from the Tennessee Attorney General's office?
I did.
Please give the board a description of the documents which you received, sir.
The Attorney General's office gave me a list containing, a disc containing a list of several bank accounts of Mr. Bell's, including the 2 escrow accounts at Volunteer State and Regions, several related business bank accounts. There were just over 14,000 pages of documents. We had documents related to Ed Hood specifically that had been obtained in the search of his office. As I said, we had all the bank statements, bank records. We had the civil suit that had been entered on behalf of Ms. Wilkinson. We had copies of promissory notes allegedly issued by Mr. Bell. Like I said, 15,000 pages.
And did you review all these pages of the documentation that you received from the Office of the Attorney General?
I actually did look at all 15,000.
And did you receive any bank records regarding any other business or personal accounts which were controlled by the respondent?
I think there were in total 8 bank accounts related to Bob Bell. So there were 2 of the escrow accounts, one at Regent, one at Volunteer State, and then there would have been 6 other bank accounts, including his personal account, that the AG's office had obtained the bank records.
And have you received copies of any documents from attorneys representing the estate of Florence Wilkinson?
Yes, I did.
And what generally were those documents?
I was given the deposition that Mr. Bell made in September of 2007, and all the related documents that had been obtained at that time, the exhibits, I should say, related to that deposition.
Who was Florence Wilkinson?
Miss Wilkinson was a lady who had evidently come into some money, I guess through saving or whatever. I'm not aware of her history, but she did have substantial savings. She was getting up in years, and it appears that she wanted to have someone to look after her affairs. For this reason, she signed a power of attorney with Mr. Bell and basically handed him the reins of her financial duties. He was filing her tax return. If you look at my report, you'll see that he was paying for her stay when she was finally put into a nursing facility, which I think was probably at the age of 98. He paid for that. He paid for storage fees for her household goods. So he was acting in some ways as a trustee should act in taking care of Miss Wilkinson. Unfortunately, Miss Wilkinson never really needed her money, and it appears that she never had any questions of either Mr. Hood or Mr. Bell regarding her balances or where her money was.
Do you recall, based upon your recollection of the respondent's testimony and his deposition transcript, what the respondent's statement was regarding whether or not he had ever prepared any written accounting of both of these escrow accounts?
He did admit in his deposition that he had no written records whatsoever. He stated to me in our very first meeting, I obtained an affidavit from him. If I wanted to look at the bank statements, come on in and get them. But that was all he ever alluded to, is that there were bank statements.
Do you remember any testimony from Mr. Bell contained within his deposition regarding approximately how many years he prepared income tax returns for Ms. Wilkinson?
I think he actually stated that he had been preparing her tax returns early, I would say mid-90s, so at least 10 years, if I'm not mistaken.
Until approximately when?
I think the last one he actually admitted to filing would have been 2004.
All right. Do you remember any testimony of Mr. Bell that's contained within his deposition transcript regarding why he did not file a 2005 income tax return for this client?
Mr. Bell stated that he was unable to file a tax return for Ms. Wilkinson because she had not provided him with the necessary records that he needed to finish the return.
What was your understanding of the power of attorney, or the power that was given to Mr. Bell within the power of attorney which Ms. Wilkinson was executed and given him?
Mr. Bell should have had access to any and all of Ms. Wilkinson's financial records. He certainly could have obtained the 1099s. The lady was living on interest, Social Security, that sort of thing. There's no reason he could not have obtained those records.
What was your understanding from the testimony of Mr. Bell at deposition regarding how Mr. Bell kept track of whose money was whose?
I think he actually was quoted as saying he kept it in his head. Except that I reviewed over $8 million in deposits and withdrawals within those 2 accounts. That was pretty rough.
Have you received from the Attorney General's office any copies of any promissory notes prepared and signed by the respondent?
I did.
And who did the respondent promise to pay within these promissory notes?
I believe that there were 4 different individuals. Richard and Ruby Rowe was a married couple. There was Ms. Wilkes, if I'm not mistaken, or Ms. Gibbons. And there was one other person, I can't recall the name right now. But there were 4 individuals who were given promissory note signed by Mr. Bell.
Did you receive a copy of any other legal documents, such as this power of attorney we just discussed that was executed by Ms. Wilkes?
I did. It was an exhibit to Mr. Bell's deposition.
Are you aware of any articles in the Nashville, Tennessee, or any other newspapers regarding the respondents' involvement in this alleged Ponzi scheme, along with former Springfield Edward Jones agent William Hood?
Yes. As a matter of fact, I think I noted in my report, when I received the original complaint, there were 2 articles, one from the Tennessean and one from the Springfield, Robertson County paper, outlining the allegations that had been brought by Ms. Wilkinson regarding both Mr. Hood and Mr. Bell.
In conducting your investigation in this matter, did you review all of the documentation you just testified about?
I did.
How long did it take you, sir, to review all these documents?
In excess of 60 hours.
How long did it take you, I'm sorry, strike that. Were you asked to prepare your own investigative report summarizing your findings in this matter?
Yes, I was.
And you did that?
Yes, I did.
Please describe for the board what task you performed in preparing your investigative report in this matter.
I think my original assignment in this report was to, first of all, identify all the transactions in the both of the escrow accounts, classify them, get them into a spreadsheet, reconcile the bank statement, and then, secondly, to determine which of those transactions could be attributed to Mr. Bell as far as incoming funds and also outgoing funds. Thirdly, to determine if Mr. Bell took out more money from the escrow account than he put in. I was also asked to examine the promissory notes, determine if they were indeed Mr. Bell's, had been issued to clients. I was asked to determine what role Mr. Bell played in the termination of the Carrot Tax Defined Benefit Plan, and also to quantify the amounts of money that had been put in and taken out or received on behalf of the complainants in this original case.
Is the bound document, which I'm showing you now, a full copy of your investigative report dated July the 27th, 2012, along with your 10 tabs constituting your attachments as well as your appendices?
It is.
And was this report prepared by you in the ordinary course of your duties as an investigator for this board?
Yes, it was.
Are the matters referred to within this investigative report matters which you would have had a business duty to report in your capacity as a state employee and as an investigator for this board?
Yes.
Do you maintain a true and correct copy of this investigative report for your own files as an investigator?
I do.
Do you have a business duty to do so, sir?
Yes.
Is all of the documentation which comprises this investigative report documentation which you have received in the official course of your duties as an investigator for this board?
Yes, it is.
And are any findings and opinions as contained in this investigative report your own work product?
Yes.
Your Honor, we move admission as collective, not collective, but as exhibit number 3, a copy of Mr. Mills' investigative report in this matter with his appendices and with his 10 attachments, 1 through 10.
And this also.
Hand me that.
Okay. so I will enter into evidence as Exhibit Number 3, the investigative report of Mr. Mills, submitted July 27th, 2012, along with the 10 tabs associated.
Thank you. Please explain, as the board gets an opportunity to read through your entire investigative report, please explain for the board, Mr. Mills, the components of your investigative report.
I basically used a format that is recommended by the American Institute for Justice Reports. I try to stick within that framework. I've given you an introduction to the case, the assignment we just talked about, the items that I was asked to either determine or identify. The third part of my report is the work that I actually performed. I listed each one of those. I think most importantly, item 5, under that heading, gives you the criteria that I used in listing and making up the summary spreadsheets and determining what went where. I tried to form a solid basis for this classification and stick to it within the bank accounts. I had, in the volunteer state bank, I had over 1,400 transactions and over 400 transactions in the Regions Bank. You can see my summary spreadsheets. I have broken those out into, I guess, 6 major categories. Each one of these categories does have its own spreadsheet, and you can see within that report how I determine the classifications. I also have a section on my conclusions based on my work, and I have the basis for my conclusions in the report. I also deal with the promissory notes, and then I wrap up with the law and rules as it applies to this particular complaint.
What does tab 1 within your investigative report comprise, Mr. Mills?
Tab 1 is the volunteer state bank account deposits and withdrawals from January of 2002 until it was closed in November of 2005.
And what is the time period covered by your investigative report?
The investigative report on the whole goes between January 2002 through the last Regions bank statement, which is November of 2006, on the financial checks and deposits.
How many pages is tab 1?
Tab 1 is 22 pages.
Explain for the board what each line of these schedules represents.
Well, basically, I started with the bank statement, reconciled the bank statement, and started to go to source documents. I took the source documents for deposits, as far as being a deposit slip, and in most instances had a copy of the check that was representative of the deposit slip. That's how I determine my source, and I put that in there. You can see the deposits. Now, I did not include any bank fees, overdraft fees, that sort of thing, simply for clarity. So there's nothing in there that reflects those. Now, my withdrawals or checks also consist of transfers out, and in some cases transfers in. The transfers can go both ways. I use those based on the check, the payee name, the payor name, and any notation made by the payee on the memo line. And as a backup, I also use my history and knowledge of the various accounts that the respondent had.
Do the schedules contained within tab 1 to your report list any deposits from Richard Rowe or Evie Rowe?
Yes, they do.
Who was Richard Rowe?
Richard Rowe is one of the complainants in this case. He is a businessman in Springfield, Tennessee.
And Ruby Rowe, his wife?
She is.
And did the respondent issue promissory notes to the Rowes?
There were promissory notes issued to the Rowes.
Do the schedules contained within tab 1 to your report list any deposits from Florence Wilkerson?
Yes, it does.
And where will those be found?
They are throughout the first tab. I think we look at page 4. Yeah, let's look at page 18. You'll see several there that were deposited by Ms. Wilkinson or on behalf of Ms. Wilkinson or using Ms. Wilkinson's check. Right in the middle of the page there, you can see $30,000 and $20,000.
Do these schedules within tab 1 to your report list any deposits from Karen Patch and Carney and Bonnie Bell?
They do. Got October 14th of 03, you've got $40,000. I believe that's the first one.
Now let's move on to tab 2, Mr. Mills. What does tab 2 of your report comprise?
Tab 2 is basically the same as tab 1, only with the Regions Bank account. It was much smaller. It was open for a much shorter period of time. I used the same criteria to determine classification of the deposits and withdrawals. Again, I did not use any bank overdraft fees, and I classified them to the best of my ability.
And do the schedules within tab 2 list any deposits from Florence Wilkinson?
Yes, they do.
What do you find on pages 1, 3, and 5 of tab 2?
November the 8th, 05 there on the first page, $67,000. Just 10 days later, another check for $67,000. I think over on page 5, these are, this is why I ran a summary and sorted these so we could kind of get an idea of what they were all together. I think you'll find that Ms. Wilkinson had $72,000 deposited down there at the bottom of page 5.
Do the schedules contained within tab 2 list any deposits from Carrot Patch and Connie and Bonnie Bell?
They do. There's a Carrot Patch check on the very first page down there, the 22nd of December. This is actually a cashier's check from F&M Bank that had been signed over to Mr. Bell. It was $195,000. You can see the payments going out to Richard Ruby Road. The notations on them sometimes would say interest or loan or whatever, but it was quite regular for those folks.
What does tab 3 to your report comprise?
Tab 3 is basically the volunteer state bank account with Mr. Bell's deposits and withdrawals that were from his personal accounts, his other business accounts, cash deposits on the deposit side. On the withdrawal side, I used any transfers or checks made out to him personally or into any of his known business accounts. I also determined that cash on both sides, cash deposits and cash withdrawals, I gave them to the owner of the account, who was Mr. Bell. And basically, based on my knowledge of the activities of Mr. Bell, you'll see a lot of these checks were to vendors who benefited, or for whom Mr. Bell benefited from their services. There's a lot of small checks in there, but they all tie back to specifics.
All right. Looking on page 11 of 11 within tab 3, what are your conclusions regarding whether the respondent's personal deposits equal his personal withdrawals from this volunteer state bank escrow account for the time period covered by your report?
Well, in this time frame, Mr. Bell appears to have deposited just over $606,000, but I show withdrawals from the same time period of $1.286 million.
How are you defining the respondent's personal withdrawals and transfers?
Primarily, I look at the history. If you look at the memo lines on these checks, most of these are Mr. Bell's memos. The only time I put a memo in there is for my own clarification. As you can see, we know that Mr. Bell has multiple rental properties. You can see some of those repairs going out to that. You can also see rent. You can see repairs on different things. You can see where he has purchased or put down payments on new property. I have things like purchase of a jet ski, I have purchase of automobiles. If you'll look there on page 8, we have a Century 21 earnest money for the Adairville property, which is in Kentucky. So I basically just tried to maintain an even documentation of the funds that appeared to be Mr. Bell's.
What are some of the business entities that the respondent withdrew escrow money or transferred escrow account money to?
Well, if you look at the transfers, primarily they're going to consist of money, both checks and transfers, going to the Second Amendment gun shop, which is actually owned by Mr. Bell's son in Springfield. We have transfers to the Springfield Cash Services, Inc., which is a check cashing service owned in part by Mr. Bell. We've got, let's see, we've also got Springfield Tax Service. Money's in and out of that. That's Mr. Bell's firm. We have checks tied to M&B Properties, which is, as Mr. Bell stated in his deposition, this is his rental property account. He also admits to the ownership of Eagle Recovery, which is a towing service. And he also had a few other businesses that seem to come and go. Auto restoration, a collision service, that sort of thing. And primarily the restoration, it appears, of a building on 903 South Market called the Bowling Building, which has substantial repairs to it.
Did any of these transfers or deposits go to, or checks rather, go to Rob's Dinner Bell Restaurant?
Yes, there were quite a number early on to Rob's Dinner Bell.
What is Rob's Dinner Bell Restaurant?
It's a restaurant in Kentucky.
Is that owned by Mr. Bell?
It appears to be. Not Mr. Bell, Mr. Bell's son.
Did you find within these tabs that there were instances where the respondent withdrew money to his or his wife's personal account?
Yes.
What does tab 4 within your investigative report reflect?
Tab 4 is the same criteria applied to the Regions Bank account, the escrow account. As you can see, it was not open quite as long. As I said, there were only about 400 transactions in it, but they're very similar in substance.
What are your conclusions regarding whether the respondent's personal deposits equaled his personal withdrawals on page 4 of tab 4?
Well, given I tried to be very fair to Mr. Bell in the classification of these, I still had deposits in the Regions account of $150,671, and I had withdrawals of $219,386.
To summarize your math regarding tab 3 and tab 4, is the $748,000 in personal withdrawals exceeding his deposits arrived at by adding the sums from tab 3 and tab 4?
It is. They're summarized in Exhibit 5.
Do you find any instances within tabs 3 and 4 where the respondent paid on any personal lines of credit or any personal loans out of these escrow accounts?
Yes, there were several payments to a home equity line of credit. There were also deposits made on behalf of, or from that home line of credit, home equity line of credit, into the escrow account.
What are the documents which I'm now handing you?
These are all checks and deposit tickets from Mr. Bell's escrow account, which I guess would probably give you a representative sample of some of the activity within the accounts.
Are these 15 or 20 or so copies of documents that I've just shown you copies of representative checks, transfers and deposits to other business entities owned by or controlled by Mr. Bell, or to his personal lines of credit or personal bank accounts?
Yes, they appear to be.
And where did you obtain these documents from?
These are copies I obtained from the Attorney General's office.
These are samples of some of the 15,000 pages or so of documents that you received from the Attorney General's office?
They are.
Your Honor, we would move as Exhibit 4 copies of the 15 or 20 representative checks, deposits, and transfers from the respondent's escrow account to his personal accounts, as well as to other entities or businesses in which he had an ownership interest. I estimate 15 to 20. I didn't count them all individually. Were there additional checks and additional transfer slips and deposit slips representing escrow account funds which went to the respondent's personal use other than the ones which you find before you in exhibit number 4?
Yeah.
How many?
Oh. Couple of hundred. I didn't run a total on this. But tab 3 and tab 4 show you the deposits and withdrawals.
Would you say that the documents which I've just shown you, sir, in exhibit number 4 are a small sample of the total amount of checks that you looked at?
Very small.
Did you find that the respondent transferred funds from his escrow accounts to the Second Amendment gun shop during the period of time covered by your investigative report?
Yes, you did.
What was the Second Amendment gun shop?
Second Amendment Gun Shop was a business owned by Mr. Bell's son, Robert L. Bell.
Did you find that the respondent transferred funds from his escrow account to Springfield Tax Services during the period of time covered by your investigative report?
Yes, I did.
What is Springfield Tax Services?
That is the respondent's firm.
Do you find that the respondent transferred funds from his escrow accounts to Rob's Dinner Bell?
Yes, I did.
What was Rob's Dinner Bell?
Dinner Bell's a restaurant in Kentucky owned either in part or in whole by Mr. Bell and his son.
Did you find that the respondent transferred funds from his escrow accounts during this period of time to Springfield Cash Services?
Yes, I did.
And what was Springfield Cash Services?
Springfield Cash Services was a corporation partially owned by Mr. Bell that performed check cashing services.
Did you find that the respondent transferred funds from his escrow accounts during this time period to Bobby's Auto Restoration?
Yes, I did.
And what was Bobby's Auto Restoration?
Bobby's Auto Restoration appeared to be a restoration service handled by Mr. Bell and possibly his son with regard to car repairs of antiques.
Did you find that the respondent transferred funds from his escrow accounts during this period of time to M&B Properties?
Yes, I did.
And what was M&B Properties?
M&B Properties, according to the respondent's deposition, was the bank account in which he handled all the family's rental property.
Did you find that the respondent transferred funds from his escrow accounts during the period of time at issue to Eagle Recovery and Towing?
Yes, I did.
And what was Eagle Recovery and Towing?
Again, in reference to the respondent's deposition, he stated Eagle Recovery and Towing was a business he owned, which was simply a couple of tow trucks.
Turning back to your investigative report, the large document, which is Exhibit 3, let's go to tab 5. Please explain to the board what the summary schedules under tab 5 represent.
Well, the very first page, of course, is a total of the deposits and withdrawals I looked at from each one of the escrow accounts. As you can see, they total over $8 million. Just below that are my classifications that we talked about briefly for Mr. Bell. Those things that appear to have benefited him, those deposits that appear to come from his businesses, from his loans, from his own bank account. The second line is money that I could attribute to Mr. Hood, checks that came in, not necessarily, these were checks that were Mr. Hood's personal accounts. The $1.8 million that went out were checks that I could determine belonged to Mr. Hood or one of Mr. Hood's known associates. The third line item, clients, is the deposits are reimbursements by Mr. Bell's tax clients for checks that he wrote on their behalf for various and sundry services. Everything from 941, sales tax, F&E. There were all kinds of payments made out of the escrow account on behalf of what appeared to be Mr. Bell's tax clients. The fourth one, unknown, pretty well speaks for itself. These are funds that I could not determine any source documentation or had a clue where they went. And rather than distort anybody's totals, I put them in an unknown account. As you can see, there's $361,000 that came out of this account, and I have no idea where it went. The bulk of these were large wire transfers that the bank did not tell me where they came from, and the AG's office had not determined it. The loans, the final line there, which you can see constitutes the bulk of the money, is simply the deposits and returns of various individuals who either appeared to be loaning money back and forth with Mr. Hood and Mr. Bell, or they were participants in the Ponzi scheme, willing, unwilling, or otherwise. These were folks that, and in some cases, they actually made money. I assume probably the early participants, as you all know, sometimes didn't make money. But you can see that's a very close difference there between what came in and what went out to these individuals. Just below that, I have, as one of my requests for this report was to determine the contributions and returns made by the complainants in this case. You can see Carney and Bonnie Bell and the Carrot Patch, their contributions, the money that was returned to them, Richard and Ruby Rowe, and of course Miss Wilkinson. That's pretty much a summary of the summary.
Okay. Going on next to tab 6, explain to the board what the summary table within tab 6 represents.
Tab 6 is the individual checks and deposits that I could account for that were either came from Carney and Bonnie Bell, returned to Carney and Bonnie Bell, or related to the Carrot Patch Corporation. You can see those totals at the bottom. We'll tie back to the summary.
What about tab 7?
Tab 7 is a little more extensive. This is the deposits and withdrawals attributed to Richard and Ruby Rowe. As you can see, they were receiving an incredible number of small interest payments on a monthly basis. These folks seem to keep up with that, but you can see some large deposits that they made, and some of these actually tie to promissory notes that we found. But again, they end up putting in $527,000 and getting back $179,000, almost $180,000. Just behind that, you'll see copies of some of the checks and deposit slips that I used as an example to show you how these were being handled, who was signing them, how they were being deposited, who was endorsing them.
Okay. Now, after you completed the schedules contained in tab 7, you include, as you just stated, copies of several checks written by the Rolls to the respondent and endorsed by the Rolls to the respondent, correct?
That's correct.
What did you notice was written upon the memo line of several of these checks?
Well, I think two things, the memo line, but also in some cases, the actual payee line was made out to Robert Bell trustee. They almost always say for a loan on the memo line, but you can see the Bob Bell trustee designation on quite a number of these. And of course, we've also got a redemption check down at the bottom of over $6,000 that was signed over to Mr. Bell.
Do you recall from reviewing the respondent's deposition transcript regarding transaction with the Rolls that the respondent admitted that the Rolls had loaned him money to buy real estate?
Yes.
Did you find any loan agreements whatsoever between the respondent and the Rolls?
There were promissory notes issued in some cases.
And do you know what types of loans the Rolls were referring to on the bottom of these checks?
I do not.
What is the last page within tab 7?
The last page represents one of those odd documents that I came across, which is actually outside the scope of the bank statements themselves, if you'll notice. It's dated, I believe, in 2000. It says it's a customer loan to Carney Bell. It's a letter of authorization to transfer funds to Bob Bell Escrow. That's the volunteer state bank account that we've been looking at. And I think it is, what, $63,000. Now, this was outside the scope of the bank statements I looked at, but it does represent, I think, how some of these funds came into the account.
Right. And this wire transfer was issued to the respondent's escrow account in September of 2000, correct?
Yes.
Okay. Who did you understand Carney Bell to be?
Carney Bell is one of the complainants.
And this wire transfer predate the period covered by your investigative report?
It did.
Okay. Was this the earliest evidence of any deposits being made into the respondent's escrow account which you were made aware of?
It is.
Going back to tab 7 again, let's look at page 3. What was the total of deposits made into the respondent's escrow accounts by Richard and Ruby Rowe?
I totaled out $527,259 in deposits. Payments back to the Rose of $179,937.
Before going on to tab 8, let's go back. I want you to point something out within tab 6. Let's go back to tab 6, your schedule of transactions for Carney and Bonnie Bell and Carrot Patch. What was the total amount of deposits into the respondent's escrow accounts by Carney and Bonnie Bell and Carrot Patch during the time period covered by your investigative report?
We're showing deposits of $880,525.
And what was the total amount of returns which the respondent sent back to benefit these individuals and entities during this time period?
My total shows $413,158.
All right, let's go to tab 8. What does tab 8 represent?
Tab 8 is a summary of the activity related to Ms. Florence Wilkinson in both of the escrow accounts of Mr. Bell.
Now, on the summary sheet to the transactions at the beginning of tab 8, what did you find that the checks that were made payable to Brentwood Store and Lock were for?
There were indications that this was to pay for Ms. Wilkinson's storage of some personal items nearby, I assume near where she was staying at Blakeford at Green Hills. And Mr. Bell, in his role as trustee or his power of attorney, was making those payments.
All right. And Blakeford at Green Hills was an assisted living facility that Ms. Wilkinson was living in?
That's correct.
And do you recall from your review of the deposition transcript of the respondent that the respondent admitted paying her assisted living facility residence fees, her storage, and her dry cleaning bills?
Yes, he did say that. I did find one dry cleaning bill.
And you have provided maybe 10 to 12 additional pages consisting of copies of checks written to and endorsed by the respondent by Mrs. Wilkinson, correct?
That's correct.
According to your schedule, what was the smallest check which Mrs. Wilkinson wrote or endorsed to the respondent during this time period?
I think it's probably the $20,000 that she did on August 13th, and then of 04, and then again April of 05. Those were the two small ones.
And what was the largest check that she wrote or that she endorsed to the respondent during that time period?
Well, in January of 06, she signed over a life insurance annuity surrender to Mr. Bell of $239,624 and change.
I
I note that all of the checks written by Ms. Wilkerson to respondent during that time period refer to the respondent as quote-unquote Bob Bell trustee, correct?
That's correct.
Did you ever find during your investigation any trust agreement or instrument appointing the respondent as a trustee for Ms. Wilkerson?
I did not.
Did you ever see any document appointing the respondent as a trustee for any individual?
No.
Do you recall from your review of the respondent's deposition transcript that he testified that he never had any trust instrument appointing him trustee over any of these individuals?
That's correct.
Did the respondent in fact endorse these checks as Bob Bell trustee?
He did.
What was the total amount of deposits which Ms. Wilkerson made into the respondent's escrow account during the period of time covered by your investigative report?
Best I can figure, it came to $1,324,454.
And what was the total amount of returns that the respondent sent back to Mrs. Wilkerson's benefit?
It appears that he paid on her behalf a total of $45,186.57.
Your Honor, could I ask for a bathroom break?
You may. Members of the board, we will stand in recess for 10 minutes. And let me remind you, do not discuss this while we're on break.
When we come back and we ask you a question.
No. Hearing again, I was discussing with Mr. Joseph the length of time that may be involved in this. We do have tomorrow afternoon set aside for the completion of this as necessary, but we are not able to begin until was it 12 or 1? Because there was, when the sunshine notice was sent out, it missed the time, so we're bound by what the sunshine notice is, so we cannot start at 9 in the morning. However, we can finish today if the members of the board are willing to do that, but it's strictly up to you. Mr. Joseph stated to me, with your permission, that he's about 2/3 way finished. Then that would then allow an opportunity for your deliberations and to make your findings of fact and conclusions of law, and for me to give you your charge. So if you want to keep that in the back of your head and say about an hour from now, we'll see where we are, and then you can decide what you would like to do as members of the board. That be okay with you, Mr. Chairman?
I would say assess it in an hour and see where we are.
Okay.
If you can give us a time frame, or if we have something to say.
Okay.
Does leaving, if somebody left before the process adjourned, does that disqualify somebody from voting on the?
Yes, sir, it does. You are a jury, so you have to consider all of the evidence. So if you were to leave, then you would miss something. So you would not be allowed to participate in the decision. The other thing is, just as because there are new members, you always have to have a quorum. So before you ever leave, always check with your chairman to make sure that you not being present doesn't affect the status of the quorum.
Is there any way the process can be expedited?
I mean, that's strictly within Mr. Joseph's realm. But Mr. Joseph, in representing the state, and whenever the government is going to take an action against someone's right to do business, the state is obligated to, to proceed very, very methodically and very clearly.
Understand?
Thank you. Was that the question that you had that you wanted to ask about
The other
leaving?
ones, yeah.
Okay, all right. Okay, well, that being said, we will go back on the record and continue, Mr. Joseph.
Thank you, Your Honor. Mr. Bell, we had just finished with tab 8 of your investigative report, which is exhibit number 3. What are the documents, sir, which you have listed within tab 9?
tab 9 consists of the promissory notes I was given from the Attorney General that are actually signed by Mr. Bell and give us a scenario of to whom they went. If you look back within the body of my report, you can see the summary as to amounts and persons who these were executed with.
All right. How did the respondent refer to himself when signing all of these promissory notes?
Robert E. Bell, trustee.
And who were these promissory notes issued to?
Well, I have Ruby Rowe. She had a couple. No, she had 3, I guess. She was the primary recipient of the promissory notes. There's 5. Then we had one to Ms. Martha Wilkes, Springfield. And we also had another one. Another individual. Yes, Mr. Thomas Gibbon of Springfield, who also had.
Has the respondent ever been registered by this department as a broker-dealer or an agent to issue securities such as these promissory notes?
Not to my knowledge.
Explain to the board the content of tab 10.
Tab 10 is the documents related to the termination of the Carrot Patch Defined Benefit Plan. And Mr. Dick Rolfe, who is, I believe, the president of Carrot Patch, and some of the documents that I obtained from him, as well as a couple of documents I received from the Attorney General.
All right, sir. The first page under tab 10 is an affidavit of Dick Rolfe, correct?
It is.
Who is Dick Rolfe?
Dick Rolfe is the president of Carrot Patch Incorporated, and he's also a complainant in this case.
What are the next 2 pages within tab 10 after the affidavit?
This is a copy of the check and the deposit slip that was the primary consideration. As you can see, it's from the Hartford. It shows a full termination of the account and the defined benefit plan. It is in the amount of $268,167, and it was deposited into Mr. Bell's escrow account.
This is a copy of the Hartford annuity check to Carrot Patch terminating the defined benefit plan in August of 2006.
Yes, it is.
And the deposit slip reflecting that this money was deposited into the respondent's escrow account?
Yes.
Please explain to the board what the last 10 to 15 pages within tab 10 are.
When I interviewed Mr. Rolfe, he indicated that at some point in the termination of this pension plan, he had talked to Mr. Jerry Davis, who was the actuary and also the administrator for this plan. He produced these pages from a file that he had kept. As you can see, where Mr. Davis outlines the possibilities of problems arising with the termination of this plan. Also, the fact that maybe some of the contributions had not been taken correctly. That was the gist of it. He also had some, as you can see, he had some supporting documentation on that.
All right, sir. Was there anything within these documents which indicated that Mr. Davis was having difficulty with respect to the respondent returning phone calls and faxes?
Yes, he indicated several cases, and one of these was actually sent to Mr. Hood, in which he talks about, if you look at the very last 2 pages, this is a memo to Mr. Ed Hood that was found in his office, obtained by the Attorney General, which he talks about Mr. Bell and the problems he's had with him.
All right, who did you understand Jerry Davis to be?
He is an actuary and the administrator of the pension plan for Carrot Patch.
What was your overall interpretation of these communications from Jerry Davis to the respondent in 2001 and 2002?
I thought that Mr. Davis's problems were well-founded and that he was essentially warning his client not to do anything incorrect with regard to the plan.
Have you been made aware of Davidson County Circuit Court litigation brought by the estate of Florence Wilkinson versus Ed Hood, the respondent, and Edward Jones, and a third-party lawsuit brought by Edward Jones against the respondent in case number 07P231?
I have.
Are these the documents that you've seen?
Yes, they are.
Your Honor, we would move into evidence. We would move into evidence as collective exhibit number 5, certified copies from the Davidson County Circuit Court of various pleadings, including the verified civil complaint, a copy of a motion for default, a copy of the respondent's excerpts from the respondent's deposition, a default judgment certificate against the respondent, an amended third-party complaint by Edward Jones for indemnity or contribution, an order filed September 13, 2011 granting default judgment, and an agreed order resolving a motion regarding the division of proceeds between Regions Bank and Edward Jones. We would ask that all of these documents, which have been certified as true and correct public records by the clerk of the Davidson County Circuit Court, be entered into the record as collective exhibit number 5.
I will recognize the pleadings filed in this matter in the 7th Circuit Court for probate, the deposition of Mr. Bell, the pleadings and complaint filed in the 20th Judicial District in the Emory Estate of Florence Wilkinson, pleadings and the orders issued in that, identified as such and entered into the record as collective exhibit number 5.
Now, Mr. Mills, are you aware that within these documents, which have just been entered into evidence as collective exhibit number 5, that according to the Davidson Circuit Court clerk's record, Edward Jones and Company has recovered a default judgment against the respondent for indemnity and contribution?
Yes.
And you are aware that within the default judgment certificate filed by counsel for Edward Jones, that Edward Jones has indicated that the respondent is indebted to them in the amount of $2 million, correct?
Yes.
And you've also witnessed the fact that the court has set this matter for a later damages hearing, correct?
I have.
Mr. Mills, during your investigation of this matter, did the respondent provide you with an affidavit setting forth his position?
He did.
Is a copy of the document which I'm showing you now a copy of the respondent's affidavit executed on August the 4th of 2010?
Yes, it is.
Did the respondent sign this affidavit in your presence?
Yes, he did.
And you are a notary public, sir?
Yes, I am.
Your Honor, we move admission into the record as the next numbered exhibit, which would be exhibit number 6, a copy of the affidavit of the respondent, Robert E. Bell, which was provided to Mr. Mills on August the 4th, 2010.
I will enter into evidence the affidavit of Mr. Robert Bell signed August 4th, 2010, identified as Exhibit 6.
seen a copy of a power of attorney for financial management executed by Mrs. Wilkerson in favor of the respondent, appointing the respondent as her attorney in fact dated January of 2006?
Yes, I have.
Is a copy of the document, which I'm showing you now, a copy of this durable power of attorney for financial management executed by Mrs. Wilkerson, appointing the respondent Robert E. Bell as her attorney in fact dated January 9th, 2006.
Yes, it is.
Your Honor, we would make a copy of the January 9th, 2006 durable power of attorney for financial management executed by Florence Wilkerson, appointing the respondent as her attorney in fact, signed before notary public as the next numbered exhibit, which would be exhibit number 7.
I will enter the durable power of attorney for financial management executed by Ms. Wilkinson to Mr. Bell and dated January 9, 2006, into the record identifying it as exhibit number 7.
Now, Mr. Mills, according to this durable power of attorney that Ms. Wilkerson executed in favor of the respondent, which has been entered into the record as exhibit number 7, what does this durable power of attorney say regarding the respondent's ability to handle Mrs. Wilkerson's tax matters?
If you look at page 3 of 7, about halfway down, tax matters, gives Mr. Bell the authority to prepare, sign, file, and also in the second part, obtain information or documents in the government or its agencies representing in all tax matters, etc., etc.
What else does this durable power of attorney state relative to the respondent's authority to handle any other financial and/or insurance matters on behalf of Ms. Wilkerson?
Well, it gives the respondent general power of attorney. Let's see, I think if you look on page 2, you'll see banking transactions are covered, business operating transactions, and insurance transactions, claims and litigation, etc., etc.
You are aware from reviewing the deposition of the respondent that was taken in September of 2007 that the respondent has claimed that he was unable to obtain Form 1099s from Ms. Wilkerson, correct?
That's correct.
Are you aware of any efforts that the respondent undertook pursuant to this power of attorney to obtain them on his own?
Not to my knowledge.
All right, Mr. Mills, in your review of these matters generally, sir, which resulted in your investigative report, did you find some instances where the respondent did return funds from the escrow account to the benefit of his tax clients and to the benefit of the eligible clients?
Yes, I did.
In your review of these matters, Mr. Mills, which resulted in your investigative report, did you attempt to give the respondent the benefit of the doubt as to some of these transactions which are reflected in your schedule?
Yes.
And how did you do that, sir?
Well, for instance, any cash deposit that was made, I assume, came from Mr. Bell. Any sources that I could, at any gray area, I gave to Mr. Bell to benefit his side of it. I tried not to show any deposits, as you can see from the unknown schedule. I had over $360,000 that I could not account for. I did not charge those to Mr. Bell.
Were there a number of transactions within the respondent's escrow accounts during this time frame where you could not determine the source of the funds?
That was, as I said, over $300,000 worth that had either no backup documentation or insisted of wire transfers that showed up only on the bank statement with no support.
Looking back at tab 5 of your investigative report, what was your finding within tab 5 as to the total amount of funds from these escrow accounts which were misappropriated to the personal use of Ed Hood?
I think that Mr. Hood probably had an amount of $954,441 that appeared to be in excess of what he might have been entitled to.
Now, in reviewing the thousands of checks that you testified that you reviewed, deposit and other transfer slips that you reviewed, reflecting deposits into and withdrawals out of the respondent's escrow accounts, what was your methodology in determining whether a particular transaction should be considered as benefiting the respondent or as benefiting one of his tax clients or other individuals or entities which might have been Ed Hood's Edward Jones clients?
Well, I basically had a fairly good understanding at this point of, number one, the accounts that Mr. Bell was keeping for his other businesses. So a lot of those were made in transfers because several of them were volunteer state bank accounts. They were transferred by phone. They usually had the account numbers, so I was able to track those. That made it a little more clear. As I said, though, I primarily concerned myself with vendor checks, in which case the payment to this vendor appeared to benefit only Mr. Bell, especially in light of his businesses, his rental properties, business in general, and the fact that I had no other indications that possibly Mr. Hood could have benefited from these.
What is your opinion, sir, based upon your review of all of the documentation that went into your investigative report, as to whether or not the respondent committed fraud?
Well, I think under the strict definition of fraud, it's willful taking by deceit. It appears that Mr. Bell probably took at least $748,487 to which he was not entitled in these two accounts. That does not include any shortfall that might have come about for lack of reimbursement to this account by his clients.
Are you familiar with provisions of Tennessee Code annotated, sir, applicable to the accounting profession under Title 62, Chapter 1?
Yes, I am.
And how are you familiar with those provisions, sir?
Because I have an active license to practice in the state of Tennessee, and I'm the board's investigator.
Based on your investigation and the content of your investigative report, do you have an opinion, sir, as to whether the respondent in this case has violated any provisions of Tennessee Code annotated Title 62, Chapter 1?
I do.
And what is your opinion?
My opinion is that with respect to Section 62.1-111, Mr. Bell is probably appears to be in violation of the subsection 5, which is dishonesty, fraud, gross negligence in performance of service. Subsection 7, which is violation of any real professional conduct promulgated by the board. And also number 10, which is any conduct reflecting adversely upon the licensee's fitness to perform services.
Are you familiar with the AICPA Code of Professional Conduct, sir?
Yes, I am.
And how are you familiar with that code?
Because I'm a member of the American Institute, and also because the board law and rule states that in any instance the board has not addressed an item, that the next authoritative source will be the AICPA Code of Professional Conduct.
And has that code been incorporated as applicable by the rules of this board?
It has.
Based on your investigation and the content of your investigative report, sir, do you have an opinion as to whether the respondent in this case has violated any provisions of the AICPA Code of Professional Conduct?
Yes, I do.
And what is your opinion, sir?
I think the respondent is in violation of the Section 54, Article 3 under the American Institute Code regarding integrity. It states that a member should be, among other things, honest and candid within the constraints of his client confidentiality, service and the public trust should not be subordinated to personal gain and advantage. Integrity can accommodate the inadvertent error, cannot accommodate deceit or subordination of principle. In addition, I found violation of Section 53, Article 2, the public interest, which states in part, distinguishing mark of the profession is acceptance of its responsibility to the public. The accounting profession's public consists of clients, business and financial community, and others who rely on the objectivity and integrity of certified public accountants to maintain orderly functioning of commerce.
Are you familiar with the rules and regulations of this board?
I am.
And how are you familiar with them?
As a licensed CPA in the state of Tennessee and as the board's investigator.
Based on your investigation and the content of your investigative report, do you have an opinion as to whether the respondent in this case has violated any of the board's rules?
I do.
And what is your opinion, sir?
I think that the respondent has violated the rules regarding discreditable acts, which says a licensee shall not commit any act that reflects adversely on the profession.
What is that citation, sir?
That is Rule 0020-3-.12.
All right. Go on.
Chapter 0020-4, disciplinary action and civil penalties. Come down to Section 4.03, grounds for discipline. Under subsection B, dishonesty, fraud, or gross negligence, including knowingly or through gross negligence, making misleading, deceptive, or untrue representations in the performance of service.
By the way, I did not ask you this earlier. What is the respondent, Robert R. Bell's, CPA license number?
His license number is 3556, as I recall. I have that in front of me. I'm sorry. License number 3250.
And when does the respondent's license expire?
His license will expire December 31st, 2012.
What is the respondent's CPA firm permit number?
Springfield Tax Service has a firm permit number of 1966.
And when does the respondent's firm permit expire?
It also expires December 31st, 2012.
When you looked during your investigation at records regarding the volunteer state bank account, when did you find that that account was closed?
It appeared to have been closed in November of 2005.
Was it closed with a zero balance?
It was. In fact, it had a negative balance, and as I recall, I had to make a cash deposit on November 18th of $33.18 in order to close the account.
What was the balance at the Regions Bank escrow account as of the end of November of 2006?
Check the report. Let me say $56. At the end of the last bank statement, November 30, 2006, the bank balance was $150.23.
Your Honor, that concludes my questioning of this witness, but the state does have two other documents that it wants to enter into evidence. Do you want me to wait until after the board members have had an opportunity to examine?
Yes, sir, let's let
Mr.
them
Bell's?
ask, because I believe one of them will be testimony. Okay. Members of the board, do you have any questions for this witness?
One quick question. Other than the affidavit Mr. Bell submitted, did he offer any other explanation regarding the finding?
He did give me a little oral explanation that might have expanded the affidavit, but it was that to the effect that the TBI had been there the Attorney General had been there and no one had found anything, and I was welcome to take a look.
Was he aware that you found discrepancies?
At that point in time when I obtained the affidavit, no, I did not have access to the Attorney General records at that point.
So, did he ever, I mean, was he ever presented with the opportunity to respond to this discrepancy? I'm trying to understand whether he knew there was a discrepancy and whether he offered any explanation. First, did he know?
Yes.
Second, did he offer an explanation?
He met with Chris Whitaker, Mark Crocker, and I think in March of 2010. He was given an opportunity to address this. He stated at that time that any money that came out was put back.
How long has he been practicing with his license?
I think he has a 1966 issue date. 3000. It's been out there for a while.
If the TBI didn't find anything wrong, then according to these documents, Edward Jones paid the estate of the Wilkerson estate $2 million. So, but you're saying that no criminal charges have been filed, and the TBI have found no evidence of malfeasance or defalcation.
It was communicated to me that there was insufficient evidence to proceed on criminal charges due to the level of proof required. Yes, sir.
What is the level of proof required?
For criminal?
Just generally speaking.
Well, in the criminal, it would have to be beyond a reasonable doubt. The civil cases would have been, I guess, preponderance of evidence in the state of Tennessee. That would be a legal question.
Any more questions for this witness? You may.
Now, Mr. Mills, you just testified in response to Mr. Wallace's question about the TBI not finding that they had sufficient proof. Were you also informed anything about whether or not the state felt that the statute of limitations had expired on criminal prosecution?
That came into the conversation as well.
And what were you told in that regard, sir?
That the statute of limitations had expired, there wouldn't be anything pending as far as criminal charges.
That's all.
Thank you, Mr. Mills. You may step down.
All right, Your Honor, next, to provide a bit of history, I'm certain Your Honor has seen the record. We conducted a conference call with Judge Stovall, who was assigned this matter before Your Honor had the case transferred to Your Honor. And we were permitted to take an evidentiary deposition of a gentleman by the name of Dick Rolfe, who is an owner as well as the president and CEO of Carrot Patch Incorporated. Within that conference call, we had the respondent on the phone on October the 3rd. It was agreed that Mr. Rolfe could not come to this hearing today. He was unavailable because he had a showcase selling with Vanderbilt Children's Hospital, which was very vital and very urgent and very important to his business, and he needed to be there all day today and all day tomorrow. As a consequence, Judge Stovall permitted the state to take this witness's deposition and considered it to be a deposition for all purposes, an evidentiary deposition. We submitted a notice of deposition in the record on October the 4th to the respondent. We were told during the conference call that we could not commence the deposition until 4:00 p.m. in order to accommodate the respondent's schedule. I was told that I had to go to Springfield, Tennessee in order to conduct the deposition, and that is what we did. The respondent did not appear for the deposition. The state waited until 10 minutes after 4 to commence the deposition. We complied with Judge Stovall's order, and we have here as the next numbered exhibit the deposition testimony of Mr. Dick Rolfe pursuant to the deposition that was conducted on October the 11th, 2012 as exhibit number 8.
The deposition of Mr. Richard Turner Rolfe on October 11th, 2012 is entered into the record and identified as exhibit number 8.
I did not get an opportunity to put a label on the original. The last numbered exhibit that the state would like to introduce is something that the respondent has already acknowledged and the board could take notice of, and that is a newspaper article announcing this incident as well as announcing the suicide of Mr. Hood, a Nashville, Tennessee article dated November the 3rd, 2007, entitled "Springfield Broker May Have Stolen from Clients. His Suicide Followed Colleagues' Testimony." And we'd like to enter this Tennessee article as the next numbered exhibit, which will be exhibit number
9. Tennessean article dated Saturday, November 3rd, 2007 is entered into the record and identified as exhibit 9.
would simply close briefly, but I had planned to distribute the proposed findings of fact and conclusions as well, which I have here.
Okay, that's fine. Members of the board, why don't you read over this deposition and review this article, and then I'll allow Mr. Joseph to pass out his proposed findings of facts and conclusions of law at that time.
Your Honor, this concludes the state's proof in this matter, members of the board. Without belaboring the proof that the board's already heard, the board believes it is proven all of the allegations that were set forth in its notice of hearing and charges by preponderance of the credible evidence that all of the conclusions of law have been proven, and that the board should consider a severe sanction against the respondent as warranted by the respondent's conduct. As to any question as to why the respondent was not criminally prosecuted, as was testified to by Mr. Mills, that would have been impossible because, for whatever reason, the statute of limitations expired and no criminal prosecution could be filed against the respondent. We'd also like to point out that for purposes of this proceeding, our standard of proof is lower. The board only has to prove matters by preponderance of evidence, and the criminal standard is proof beyond a reasonable doubt. We have prepared to assist the board in its deliberations, proposed findings of fact, proposed conclusions of law, and a proposed judgment, and they track in almost an identical fashion with the allegations that are included in the notice of hearing and charges, with the only difference being we have added one paragraph regarding the entry of the default judgment against the respondent in the Davidson County Circuit case, for which you were provided a copy of within the Circuit Court certified documents in the third-party complaint that was filed by Edward Jones against the respondent. Otherwise, our proposed findings of fact and conclusions of law track the notice of hearing and charges, factual allegations, as well as the alleged conclusions of law. The state believes that the respondent has certainly misappropriated funds in the amount of $750,000 or $748, whatever the exact amount was that was testified by Mr. Mills. The respondent acquiesced in a role as trustee. He signed multiple checks as trustee. He had a power of attorney on behalf of Ms. Wilkerson. He had an obligation to exercise a fiduciary responsibility for her benefit, for his other tax benefits, and for these other individuals, multiple individuals who were depositing monies into these escrow. The respondent did not use the funds in the escrow account for the purposes for which they should have been used. It's clear that the record reflects that he sent many of those funds for his personal business, for his own personal accounts, and he did not do, as he testified in his deposition he would do, that is to say, he did not ensure that he made deposits sufficient for all of the withdrawals that he took out. On the basis of this record, which we submit to the board as uncontested, the board will request that the state rather will request that the board revoke this respondent's license, not allow the respondent to reapply or ask for reactivation until a 5-year period, that the board assess a civil penalty in the amount of $2,000 for 55 consecutive months of misappropriation. We think the records reflect for a total civil penalty of $110,000, and assess the cost of this cause against the respondent, including specifically the cost of the Administrative Procedures Division of the Secretary of State's office, the cost of the court reporter, and any other costs that the board may, that the state may have in the way of investigatory costs. That is the state's prayer in this matter, and that said costs and civil penalties have to be paid before the respondent will be permitted to submit any new application to this board. Thank you.
Members of the board, you've now heard the proof in the matter of Robert E. Bell, CPA, and yeah, you may pass this out, and the Springfield, doing business in Springfield Tax Service. You will decide this case only from the evidence which was presented at the hearing today. That evidence consisting of the sworn testimony of your witness, in person, by deposition, or by affidavit, exhibits that were marked into evidence, or any other matters that I may have instructed you to consider as evidence. Statements of counsel that are made during the proceeding are not evidence. Statements by counsel are considered argument. The Administrative Procedures Act specifically requires your order to contain findings of fact, conclusions of law, and a policy reason for your decision. You will make your findings of fact based solely upon the evidence presented before you in this hearing. The proposed findings of fact and conclusions of law are not evidence. However, you may use this document as a guide to assist you in making your findings, but it's the sole responsibility of the board to make your own findings of fact. Please use this guide after careful consideration in determining that it accurately reflects your own independent recollection of the evidence and your own conclusion. The state has alleged that the respondent has violated certain statutes, rules, and regulations. The state carries the burden of proof in this case. It is their burden to prove their allegations by a preponderance of the evidence. A preponderance of the evidence means that amount of factual information that's presented to you is sufficient to cause you to believe that the allegation is probably true. Do not confuse this standard with the criminal standard of beyond a reasonable doubt. The civil standard of carrying a burden by preponderance of the evidence is not as stringent as the criminal standard. If you weigh the evidence on the scales of justice and the scales tip in favor of the state, you must find that the respondent is guilty of the allegations that he has been charged with. If the scales tip in favor of the respondent, you will find that the state did not carry their burden of proof. If the scales are evenly balanced, you will find that the state did not carry the burden of proof. The respondent does not have to prove that he is innocent in these matters. You also heard testimony by an expert witness in this matter. An expert witness is a witness who has special knowledge, skill, experience, training, or education in a particular science profession or occupation. They are a witness who may give his or her opinion as an expert as to any matter which he or she is skilled. In determining the weight to be given an expert's opinion, you should consider their education, qualifications, and experience of the witness. You will give their testimony such weight, if any, to which you believe that it is entitled. You are not required to accept the opinion of any expert witness. You also had testimony by depositions. A deposition is testimony that is taken under oath prior to the hearing and preserved in writing. You are to consider that testimony as if it had been given under oath during the hearing today. In making your decision, you will consider the evidence in light of your own reason, training, experience, expertise, and common sense. Once you have made your findings of fact and decide whether or not the state has proven their charges, you will then state your conclusions of law. If you decide there has been a violation, you will then decide what action, if any, is appropriate in accordance with your legal authority and the particular aspects of this case. You must limit your inquiry regarding violations of statutes and rules to those only alleged in the state's notice of charges. Once you've articulated your findings of fact and your conclusions of law, you will then state a policy reason for your decision. Your policy reason states why your decision in this situation is appropriate. All motions must be carried by a simple majority of the board. If you have any questions during your deliberations, please address those questions to me. Unless there are any further questions about my charge, I'll turn the hearing over to the chairman.
Discussion.
Well,
Why is the recommendation to revoke his license only for 5 years? and not permanent?
Can he answer that question?
No. I believe,
There
and
may
it's,
be a maximum.
I believe that the understanding is that, yeah.
Okay.
I was thinking that earlier. Look up.
Say it's a maximum.
I think there's a maximum.
It's in the code. In the,
By law, after 5 years, you can get 5.
And make sure you speak up because she's having to write down everything you say.
Might be
That's the
helpful if
hardest
we
part of this.
identify ourselves as
We turned everything so she could see, just so you don't speak over and you speak loudly. Mr. Eldridge, we're having problems with him already, so.
I think I would point out that I believe the state has proved its point, and in my mind, this is probably the primary reason this board exists, is for egregious acts such as this that harm the citizens of the state and cast a very negative light on our profession. Those are my personal opinions, but for that reason, I'm inclined to agree with the violations of law that have been presented. But again, those are my opinions.
You need a motion.
I'm sorry, I got a question first. Can we ask the administrative law judge a question?
You can ask.
What is the standard for gross negligence in the accountancy statute?
That I can't answer, because that's something that would have to be contained in your statute, unless you have a specific statute and legislation. I read it, and I don't remember there being any separation under a finding of gross negligence like other toys. But if there would be, it would have to be contained, but it would also have to be a charge made within the notice of charges. So it would have to be you would have to be charged with that in the notice of charges.
I think that's, in the statute that was allegedly violated. The account was
If it was, then you can find it, but I don't know that you have a specific definition. We can look and see.
Can we look? Is that
You
okay?
may, absolutely.
I've looked and I don't see it, so I would appreciate it.
I didn't recall seeing it labeled that specifically stated, but members of the board, this is your statute and you wrote the rules, so if there's something that it isn't up for discussion. But I think you have a copy of your rules on your iPad. I brought a copy of your rules with me as well as your statute.
and the alleged conclusions of law is dishonesty, fraud, and which negligence was to be. 62-1 triple. 62-1 triple. And it seems to me, first off, he kept no accounting records for the transactions that he was conducting as a CPA, as a trustee. That's number one. That's gross negligence. Number two, he commingled the fund, regardless of whether he were to replace them or not. He should never have taken funds out for his own benefit. Period. That's discreditable acts and fraud and dishonest. In the recommendation on the pension funds, bad advice, for sure, whether or not it's gross negligence, obviously it's a matter of interpretation there, just as I'm arguing this right now. But I would think the gentleman has been a CPA for quite some time, and he has to be very familiar with pension laws, DOL regulations, and as such, probably was aware that that was not a smart thing to do. So, I would concur with the state that he violated our rules and regulations, the state of Tennessee laws, and that his license should be revoked for a 5-year maximum period.
I would note, I guess, if his license is revoked, that's an automatic revocation of the term as well. Is that an accurate statement? No?
Well, we would need to include Can we amend the statement as for the term permitted to be revoked?
Is that within our right for a term as well?
Can we add that?
Can I ask one other question to the judge, Your Honor? Are you aware of a statute of limitations for any of these claims?
I am not aware of the statute of limitations, no, sir. If I, once again, as I understand your law, and once again, this is your area, and I will bow to the legal members of your board, but it's my understanding that when you practice as an accountant, you have a firm, are those not like
I thought they were
joined?
joined, and that's why I
I
was
think
asking
they
the
are
question.
conjoined, and so I don't believe that that the state would be required to bring that, and I don't know, because you need to look at your statute for that, but it seemed to me as if when I read your statute, that it said that when you are practicing as a CPA, then
Can we clarify that with our executive director or not? Just because
I think you should, I think you could clarify that with your executive director, with the understanding that I'm going to, I'll tell you what we'll do. Can Mr. Mills answer that question? Since he was the expert witness in this matter? Mr. Mills, can you answer that question for the board?
Yes, ma'am.
There we go.
To the best of my knowledge, because Springfield Tax Services consists of a sole proprietor, if you have a revocation of the sole proprietor's license, then the firm ceases to exist. Right. Cease to meet the criteria to continue the firm. Okay. Where it simply goes away.
It just goes,
That's why you have an expert witness testimony.
It certainly would not be
Thank you, Mr.
renewed.
Mills.
I have a question. I'll speak up.
Thank you.
Could you not have a situation where, I don't know, I'm asking this to this, but have a situation where you could attach another CPA to that firm? We think, this gentleman loses his license, the firm still would stay in existence, and then he, has an opportunity to practice at the same firm. It's still going to be named.
I think it would have to change because that person's name would then have to be associated.
Would it change?
You couldn't hold out to be, well, it is Springfield.
Yeah. We don't, our firm's not named after our partner.
Quick question, is it only Robert Bell who's a respondent, or is Springfield Tax Service also a respondent since they're listed in the caption?
As far as I'm concerned, we didn't bring a notice of charges against the tax firm. We brought the notice of charges against Mr. Bell, and that's the understanding that I have.
Any more discussion, questions, comments? Is anybody prepared to make a motion?
The motion would be to adopt the proposed findings of fact as presented by legal counsel. So
Judge shaking her head.
Judge is shaking her head. For the record, you need to go through and make sure that the state proves each and every allegation of fact. Now, how you choose to do that different board members do it different way. You can say that we adopt finding of fact number 1, finding of fact number 2. You may choose to read them into the record. Either way, it doesn't matter. But as an example, you may find that a finding of fact in here has a typographical error in it, and now you've adopted something that wasn't true. For instance, let's just say the CPA license number has been reversed somewhere. So what you want to do is you want to go through each finding of fact and make sure that the state proved that specific finding. And yeah, you may take them in blocks, and that way each one of you have an opportunity to review them, but it's very important that you look at each one individually.
Do I have a motion on finding of fact number 1?
So moved.
Second. Second.
Yes, sir, and what you may choose to do is all in favor say aye, and that way if there is someone opposed, I'll just instruct you now, speak up, state your opposition, and take up your discussion at that time.
Okay. I have a valid motion, I have a second. You said not to do the discussion, or can you just say yea or no? Or do you have to call for discussion?
Yes, if you do need to call for
Okay,
this.
so, any discussion? Hearing none, all those in favor say aye.
Aye.
See that it's a majority vote. Finding of fact number 2, do I have a motion?
So moved. Second.
I have a valid motion and a second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Do I have a motion on number 3?
So moved.
Second.
There's a proper motion and a proper second. Is there any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Number 4. Do I have a motion?
Second.
So I have a proper motion and I have a second. Do I have any discussion? All those in favor signify by saying aye. Aye. Number 5, do I have a motion?
So moved.
Second. I have a proper motion, I have a proper second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Mr. Chairman, who's the second?
Who did the second?
I'm
Down.
sorry.
Let's see.
Mr. Etheridge.
I second.
And then number 6, I have a motion on number 6.
I move approval.
I have a motion, do I have a second?
Second.
I have a proper motion, a proper second. Any discussion?
Well, number 6, were all of these transactions initiated by Mr. Good? Are we assuming that all of them were initiated by Mr. Good?
You're talking about the transactions themselves? I think it was both sides, I think, Hood and Bell.
I think 6 says that not all deposits were initiated by Mr. Good. So I think my understanding of 6 is that Mr. Bell initiated some or all the transactions that is talked about there, and all those different businesses on his own initiative.
Any more discussion? All those in favor signify by saying aye.
Aye.
Your Honor, we have, I think, gone through every one of those. I guess now it's... Yes, sir.
If you do them in blocks.
We got a long way to go.
I think we just said you do them in blocks.
I believe that what you have here are the matters that are, let's begin by the matters that are related to Ms. Wilkinson, and what you may want to do is take an opportunity to read each one of those. For instance, you just had a discussion and a question on whether you remember the evidence accurately reflects these facts as you find them.
You need to do 7 and 8.
I'm sorry.
I move approval of 7 and 8.
Second.
Okay, I have a proper motion and a second. Any discussion? All those in favor signify by saying aye.
Aye.
I move approval of items number 9 through 16.
Have a motion, is there a second?
I would second it.
Any discussion? All those in favor signify by saying aye.
Make a motion regarding items 17 through 21 relating to improving the road.
Second.
Have a proper motion, a proper second. Any discussion? All those in favor, or hearing no discussion, all those signify by saying aye. Aye.
Mr. Chairman, I move adoption of items 22 through 30 relating to Carney and Bonnie Bell and Carrot Patch and Carrot Patch to identification.
Second. Have a proper motion, a proper second. Hear any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Okay, motion to accept the findings and overview of respondents' actions, items 31 through 34 as presented.
Second.
Have a proper motion, a proper second. Any discussions?
I just wondered about the use of the term Ponzi scheme, because I'm not sure there's been a lot of discussion or explanation or information given to explain how this fits into the definition of a Ponzi scheme. I just was a little bit, I didn't hear it. I just was wondering
Any comments
if that
on
would
that?
be appropriate.
Take up word finding and say, it's fun and knowing that they
That's fine.
I'd amend my motion then to
I've got one comment, so I'm sorry. Personally, when I see the word knowingly, I don't know that I'm there yet based on what's presented. I think gross negligence to me seems like that's sufficient. I'm not sure about knowingly because I don't see documents, I don't see emails, I don't see communication between Mr. Hood and Mr. Bell talking about how they're cheating the people. And maybe that's not necessary. Just personally, it seems to me like knowingly seems like a higher standard than gross negligence.
I don't necessarily have a problem with knowingly in this case where someone takes money out of an account and puts it into a personal account. To me, that indicates a knowledge, and that's my personal opinion.
Well, I think I agree with you on that part, but I guess my point is knowingly participating in the scheme. I mean, the question to me knowingly modifies the scheme, so the question is, yeah, you're knowingly taking out an account, but are you knowingly taking out an account to fraud someone? Perhaps you thought money was in there, and as a result of your intent there. I don't know. That's my point on the word knowing.
I personally don't have a problem making it. I don't have a court feels. Encourage everybody to speak up on this issue.
You want to amend the motion?
I would propose to perhaps say at least with gross negligence.
consent you're talking about there, Jackie.
Yes, sir. In section 31, respondent, at least with the level of gross negligence, participate in a scheme, assuming we've accepted the other amendment along with that.
I guess I don't understand how you participate in a scheme. No one's doing so.
I'm just thinking,
What are your thoughts? You're an attorney.
I was just gonna say, great compromise here. Maybe we could say respondent knowingly participated in a scheme, or take out the scheme. Respondent knowingly participated along with Ed Hood in withdrawals and deposits. Maybe say just respondent knowingly participated along with Ed Hood to separate the depositors from their money. Like he's the
I'm not
I don't have a problem with
With
So
that.
whatever motion is on the
Again, this is the board, so we decide. If I'm the only person that says that, that's fine. The point is, if he didn't have the intent to knowingly participate in the scheme to defraud someone, either way, he was party to something that happened that resulted in people being defrauded. So the point is that even if he didn't knowingly participate or try to do it, he was still part of it. And he did, as Mr. Sargent pointed out, he didn't have trust accounts, he didn't keep records of his of the transactions, he commingled funds. All of those things to me definitely, at the very best, seem to be gross negligence. And that's all I'm saying. So I'm not trying to stop the process. I'm just voicing that difference of opinion on the word. But if y'all don't, we can go ahead. I'll do the motion to amend, as was just Bainbridge. Is that correct? And then if y'all, you can vote it up or down or in a second. So I so moved to make it read as she just said. Would you read back what you just said?
I said respondent knowingly participated along with Ed Hood to separate the depositors from their money.
Okay. Do I have that's your motion. Do I have a second?
No, this is the amendment.
Well, this is a proposed amendment to 31. Do I have a second? Second. Any discussion? All those in favor signify by saying aye. Aye. That's amended. Okay, can I get a motion on the rest? Right, with the amended.
Yes.
Who made the original motion?
I did.
Can you amend your?
Make my amended motion to include the proposed amendment.
Do I have a second?
Second.
Any discussion? All those in favor signify by saying aye.
Aye.
Okay. So we'll phase back.
Mr. Chairman, I move that we adopt the proposed conclusions of law as presented, items 1, 2, 3, 4, and 5 and 6.
Are we okay with that?
We need to take for 32 and 33, 34.
We did with that second motion.
All right, thank you.
So I have a motion on the table for adoption of the proposed conclusions of law, numbers 1 through 6. Do you have a second? Second. Have a proper motion, a proper second. Any discussion? All those in favor signify by saying aye.
Aye.
Now I guess we're to the penalty phase.
Yes.
I move approval of the proposed judgment outlined in 1, 2, and 3 of the
I have a proper motion on the floor. Do I have a second?
Second.
Any discussion?
When it comes to penalties, is this the maximum, or is this, where does this fit in?
This is high.
This is the
I mean,
maximum.
from what I've seen.
No, it's not the maximum.
It's not the maximum.
No, it's
time.
not the maximum, but it's the largest penalty I've seen.
Yeah.
in my opinion.
Yes, I would agree. Largest one I've seen.
Do we have any estimate of what the hearing costs and all that would be?
Do y'all they just tack that on each year? How does that work? Y'all don't give us a number for that.
We obtained a notarized bill of costs from the administrative procedure.
But that comes after the fact.
Well,
I believe.
generally speaking, I like to include the cost within the order that I was prepared. to
We
send.
usually say, and
Right, I would state specifically the administrative procedure division's costs as well as the court report's cost. I don't believe we have any specific costs attributable to Mr. Middleton as much as he's a salaried employee of the board.
But you will have, because you took the deposition.
I will have
you'll
those
a
deposition
court reporter
costs.
deposition costs
so we could
for
say
that.
administrative cost.
And yes, and your statute specifically allows you to, assess the costs of the investigation and the hearing costs, which would include her costs, my costs against him.
And that is number 3.
I thought in the past we charged for the time for the investigator also. On occasion. Which would be Mr. Mills' time. Even though he's a state employee, we still charge
His time.
his
Yes, sir,
time.
his
And
time.
travel costs,
Right.
incidentals.
Just like to see that the state's not out any money from this.
The intent with number 3 is to recoup those
That's what I
costs.
asked.
Yes.
That's typically.
But it won't be paid unless he can let his license just lie and not pay it back. This is only if he wants to get it reinstated. Is that-
He's supposed to pay this.
We can file a lawsuit, I believe, in Chantry here or something for the courts.
Yes.
The attorney
But part of the proposed judgment too is that he can't get his license back unless he's paid all these fines and penalties.
He's supposed to pay them back regardless of whether ever
And the attorney general will have to handle that. Any other discussion? Hearing no further discussion, all those in favor signify by saying aye.
Aye.
Your Honor, we have,
You have a policy review.
I do have that, and I think I have worked one up here. We'll see what happens. I'm shooting from the hip.
There's a beginning sentence.
Okay. Okay.
I mean, you can't use all of it.
Yeah. I know. This board has a regulatory duty to protect the health, welfare, and safety of the citizens of the state of Tennessee. This board has found that Mr. Bell did in fact violate the laws and rules as outlined in the proposed conclusions of law, labeled, I'm not sure what exhibit that ended up being. The last one?
It wasn't.
It wasn't. Okay. So, the board has found that Mr. Bell did in fact cause harm to citizens in the state of Tennessee, and as such, the board has assessed penalties the board finds appropriate in light of the evidence presented today. Does that suffice?
That's what we heard.
All right. With that, I think.
You need a motion and a vote.
Okay.
I moved that law.
Okay. Thank you.
Second.
Have a motion and a second. Any discussion? All those in favor signify by saying aye.
Aye.
We're adjourned. Thank you.
Yeah, we can.
Just do some corrections.
Just get there whenever it's convenient.
This is the licensing committee of the Tennessee Board of Accountancy meeting on October 19th at 8:30. All members are present. I'm Jennifer Brennan. I'm facilitating the committee meeting today, and Troy Brewer, Stephen Eldridge, and Henry Haas are all here today. We have a short agenda, so hopefully we can get through this quickly. I'm just going to introduce the topic, and Kathy can jump in, and if I omit anything or she thinks that any other information would be helpful, she can jump in. Our first item is Landon Morris has appealed voiding the CPA exam passing score relative to the 200-day rule. Basically, the way I understand this is Mr. Morris was admitted to sit for the examination under TCA 65-1-106C1 under the condition that he would complete his educational requirements within 200 days immediately following the date of the examination. And he applied November 14th. He sat for one section on February 24th. He sat for a second section on April 13th. And then the end of the 200 days ran on September 11th. And he actually plans to finish his 150 educational requirement hours on November 4th, which is 54 days after the deadline. Mr. Morris has written us a letter that's dated September 29, 2012, in which he provides his appeal to us and his explanation of what has happened. I actually had, just to start off, I had two questions. I guess my first question, and we may not have this information, but did the board actually have to decide to allow him to sit, or did he apply and it's just something that if you apply, you automatically sit
We
for?
don't do the exam.
Okay, so
We
he did it
contract
for-
out to CPA Exam Services, and they gather all the information and determine whether he's eligible to sit. And they determined he was eligible to sit using the 200-day time period to finish his education.
And then how did you find out that, how did you become aware of this situation? Did he receive a letter, or did he actually, a few days after the 11th, did he
I
do it on
cannot
his
say
own?
for certain that CPA Exam Services sends a letter saying, hey, by the way, your successful score is now void because you've not finished your education. Obviously, he was aware he had requested the 200 days. He probably knew about when the 200 days was going to end. He knew he had not completed his education and indicated that he was enhancing his education tremendously, he thought, and was requesting that a waiver be offered.
Okay.
And the board does have the authority on the little table that has the dates on it, and then behind the letter in your book is the full section of that law, or law, if you want to look at it.
Has there ever been a waiver before?
I don't remember in my tenure, but I've not been here very well, Mark.
I don't recall one either.
That's a good point. Under the, I didn't say, under the legal statute that I quoted earlier, we do have the discretion. And it says it's basically the request and good cause.
Was he successful in passing the exam?
He's taken two sections, he's been successful in passing one that is now outside.
Is that the one in question here that we're talking about?
He wants to keep the odd successful passing of April 13th, 2012. And if he can keep that, then he has however many months left out of 18 from April until now to finish the other three sessions successfully.
The 200 days has been in the law not that long, though. Isn't that correct, Mark? Meaning, you had pointed out that there had been a waiver. It was passed during at least my tenure in coming to these meetings with a fairly new addition. Is that correct?
I don't recall when the 200 days was added.
The last time this statute was amended was 2007. So, would that have been?
That could have been when
That
the
could have
200
been,
days
yeah.
was added.
It was shortly before I came, and I came in early 2009, so it has not been long lived.
Yeah.
And I don't know that many people have used it. We don't really know. If we wanted to find out the statistics, maybe someday we could. It's been a moot point up till now because anyone who requested it either completed the exam or didn't contest it.
I kind of went back and forth. My first gut reaction was when I skimmed through this quickly and thought, well, he was trying to take classes that he felt would, better his career and what he was interested in, and he was actually it seemed like, trying to be on the ball of what he needed to do. When I read it a second time and kind of thought about what this committee has considered in the past, I was a little upset as he was aware of the 200 rule that he didn't at least come in before it passed and come before us and say, here's what I'd like to do. I'd like the opportunity to pursue this type of education. I'd like an exemption. I'd like to be exempt from this requirement. So that's kind of the tension that I've been, in my mind, going back and forth.
I agree. I mean, I've been back and forth too. At first, like you said, I thought, well, it's just 54 days. But on the flip side, it seems like we've never had this before, and I don't want to open Pandora's box. The rule is the rule, and next thing you know, we're going to get 100 or so requests, and what's the point of even having a deadline on the expiration of the score? So.
I tend to agree with that. I would take it as a waiver.
I would, even though we have the rule, it's written into the rule that, we have an option to give him the benefit of the doubt and grant him the additional days. I would be inclined to do that, grant him the additional days.
Where do we draw the line though in the future?
I don't know. I'm not real sure. It seems like if this is going to be an ongoing issue in the future with additional problems coming up, then we need to identify where we can draw the line. It seems like we need to have, if this is going to be a continuing problem, then we need to have some kind of a standard set out there, some way of identifying where people are abusing the issue.
I just think when I read it, I was looking for a circumstance, an unusual event, or there's all kinds of things that would happen that you just you couldn't completely. To me, he knew when he signed up, kind of what the rule was. So when I read it, I kept reading through his letter, and I wanted to hear some kind of a children issue, or hear some type of issue in there that would say, okay, this is unusual. And then I would be more inclined to extend it. But this, to me, was I just didn't finish. I'm really doing well. I'm working hard, which is great, which is good, but it's not something, we all work hard and do that. So that's the only reason I had the opinion that I had.
Does he need the 6 hours to meet the 150-hour rule? Well, it says the last 6 hours will give me the 150.
But he can pass the exam before he sits for the exam. And that's the problem. He's trying to pass the exam, isn't it? Yeah. Ahead of completing.
But if we allow this to, we don't allow the exception, then the successful completion of the audit portion of the exam will go away. Basically, what happens in this committee, for those of y'all that are new, is that we basically make a recommendation to the board on what we suggest. So we tend to, even though kind of somebody informally makes a motion or a way to go, and then
one of the things he could have done is completed 150 hours and then taken the additional courses that he wanted. The way I read this, the way he explains it here, he just went into an additional session to take a course that he particularly wanted to have.
probably do a motion, don't we?
A
Yes.
motion to recommend to the board.
Yeah.
I would, trying to think how to word it. I would recommend the board that we do not extend the
I'll second that.
All those in favor?
Can we discuss real
Oh,
quick?
sure. Oh, yeah, sure.
I mean, it may be something worth recommending to the board to consider, adding some language that says, based on some circumstance, like a illness or a death in the family or some kind of, significant situation rather than just, I missed the deadline, I had good marriage. I mean, it's an impressive kid, but I mean, having some kind of criteria for appeal or.
Do we have a rule? This is a statutory section, so this would require, we don't have a complementary rule that goes with this.
Not for this statute, no. Not for this portion of the statute.
I guess the board could adopt a policy. Do we ever adopt a policy?
We have policies, we have rules. If you're going to go policy route, bear in mind that's not legally enforceable. So,
If we wanted to put it in some kind of clause that says, consideration will be given for extenuating circumstances like an illness or something, would that be something the board would do, or is that?
How would that work? I mean, it's changing a statute, so you have to go to the legislature and do we make a recommendation to the Department of Commerce and Insurance to include it in there?
if you want to make a statutory change, yes. That's what you'd have to do. You'd have to go through the Department of Commerce and Insurance.
But we could, I guess we could, can this, well, and I guess it's, I mean, each committee, can you adopt a,
I mean, we have the authority to give an exception. We just have a policy that says
Yeah.
if you want to bring an exception to us, that we're going to throw them out unless it meets these certain
Because if there would have been some type of extenuating item, I probably wouldn't make a motion. I mean, I'm looking
I agree.
for something there.
You're looking for something to help him.
Yeah.
would it be appropriate to ask that we maintain a list of the types of, so that for future committees, since this, you're trying to create consistency, I guess, is create a list of the type of applications that have come before, the circumstances and the action that we've taken. So that way, when one of these comes up in the future, Kathy can pull out that and the board will know, here's kind of the consistent action taken, or?
I think kind of what you're trying to determine is what it is a good cause or discretionary.
Correct.
I mean, he made the determination that he would go abroad and study. If you restrict yourself so much, saying, is flu an extenuating circumstance as opposed to open heart surgery?
That's a good point.
I think it's just going to have to be on a case-by-case basis.
But I think the key is discretionary or unexpected.
I agree with that.
Okay, so we have a motion and a second. All those in favor? Aye. Opposed?
I'll just be quiet. You've got a good point, and I respect your position on it very well. I hate to see the guy lose his credit on it, but I think he made an intentional decision to extend it instead of coming and asking. Or
He wrote this letter three weeks after it expired. He knew it expired, so instead of being proactive and writing a letter September the 7th,
right.
he wrote it 3 weeks later. I'd have been terrified. I'd have written a letter in August.
Yeah.
And then he claims form of substance.
Yeah.
I mean, I don't want, my intention is not to discourage him from passing the CPA exam. I mean, I hope he succeeds. My concern is I just don't want to open up
Slippery
floodgates for anybody that wants to do it.
Couldn't he have got the additional 6 hours prior to taking this trip, this period of where we was at.
Sounds like you could.
He could.
I totally understand it. Not creating a slippery slope.
I mean, is this an issue that if the person wanted to come present it before our committee, that they can do that? And is that allowed to?
Yes.
Yes.
Just the time that I've been on this committee, people traditionally don't appear. We have invited people to come and appear before the board when it's been a difficult situation. We wanted the person to have a chance to that's some decisions. Okay, we'll move on to our second item. This was a request by the University of Tennessee Municipal Technical Advisory Services, or MTAS. They are asking that they have a program, Certified Municipal Finance Officer Program exams. They're wanting that they have 11 of those exams, and they're wanting 5 hours of continuing professional education for CPA license holders under Rule 0020-5-.048. And that rule, I don't know if it's in our...
It is, it's right, okay. It's the last page in there.
That rule says that CPE credit may be allowed for the successful completion of exams for Certified Management Accountant, CMA, Certified Information Systems Auditor, CISA, as well as other similar exams approved by the board. Credit will be awarded at a rate of 5 times the length of the exam taken and limited to 50% of the total CPE required under Rule 0020-05-.03. I asked Kathy if we had maintained a list of other exams that this committee in the past had provided allowance under this rule, and she gave me a list, which I can pass around here.
In actuality, it was already in these books when I went to open, when I went to read
Okay,
them. So
thanks.
it
Oh, is it
should
in
be in the
everybody's
back
book?
of your notebook.
It's the list in the back that says certification exam for CPE. I thought it might be helpful for us just to see what had been done in the past.
Basically, they're wanting CPE credit for the...
Sitting for the exams.
I think it's a very reasonable request. I mean, I know we do a lot of governmental work, and so I'm familiar with the program. And actually, one of my partners teaches one of the class, and I would hate for him to be my teacher. I probably wouldn't be able to pass it myself. But I mean, it's a very difficult course. I think it's very obviously pertinent to the accounting industry, especially the governmental accounting industry. I don't know that it's an unreasonable request. I mean, it's probably more difficult than the normal CPEs that we have, where you go and sit for a certain number of minutes and there's no test, and then you actually have to pass a test to get credit for the class.
I'm in agreement. I've done work in the past with MTAS, and they're a great organization. They have wonderful programs. I'm in agreement with what you're saying, and also I think it's in line with the other types of exams that have been given in the past.
Kay used to actually work for us. She would wear us out. Move to allow this to be accepted as adequate CPE.
Second.
Any discussion? All those in favor, say aye. Opposed? Okay, we'll recommend to the board that it be given, I don't know what the proper word is, but they'll be given their request will be granted. Under Tab 3, Kathy, do you want to explain to us about the audit statistics?
Yes, this year we selected an N of 484 candidates to be audited. Every one on the board whose license renewed last year was audited, and everyone passed. That was pretty crazy. And then were the other people that made up the 484, the N. Of those, 362 or 75% roughly were compliant straight out. They complied without using any assistance. Some were compliant with carryover, but the carryover is the scariest thing to me because people always think they have carryover and sometimes it doesn't work out so well. But at least those people, 23 of them did have carryover hours from the prior licensing period. 37 were compliant with late ethics, either state ethics or general ethics. These people had to have the 4 hours, one being state specific. Others were compliant doing late ADAs if they were through chest services, maybe like technical hours. 40 hours have to be technical, so they may have like 42 frou-frou hours and 38 technical hours, and then have to make up the technical hours. 35 were compliant with penalty hours. Either they didn't have the 80 or they didn't have 20 each year. There was no one not compliant, but that's because we did send one complaint. So, you know, you can play with statistics any way you want to. I'm saying no one was not compliant because we sent a complaint. There were 16 removed from the sample, either they retired, inactivated, or closed. Now, if we compile, again, if you do anything you want to with statistics, if you compile everybody that became compliant or was normally compliant, that would be 96.4 of the entire population. And if you take out the 16 who were removed from the sample, we had 99.7 of our population compliant. Again,
What does the term closed mean?
that means you've literally surrendered your license.
Oh,
And it is a good status in the state of Tennessee. What we're trying to do is to make sure that people, especially young people, get their first license in Tennessee. It's not always the case. And then they get their first job in Georgia, so they get a Georgia license, and then they just walk away from the Tennessee license, abandon it basically, and then it expires. That is a bad status. I want them to close the license. They can get it back pretty easily.
go through a formal process of actually turning in their license or
If they
closing
know
it?
where it is, yes, they have to turn in the law certificate. If they don't, they can close indicating it's been lost or stolen. But if you sign an affidavit, but getting it back is so much easier than abandoning it.
Do we have is there a tab 4?
No.
Okay.
Do I have something on the agenda before?
No, there's on a piece of paper.
Oh, I must have cleaned it out last time.
Do you help me understand this just a second. How do you select the 484 people? Are we evenly split with half being reported one year and half reporting the next year?
That is pretty even. I mean, that's just a happenstance. We only look at the people who expired. This population had their licenses expire.
No, I'm talking about the whole thing, the whole 484.
That's the
what
four
you're
things
talking
I'm
about?
talking about. They all had odd-numbered licenses, so they expired in 2011. We audited in early 2012.
Okay, and out of all those that had odd number licenses, you selected a sample of 484?
Correct. It's 10% of the people who were new,
Now, is that out of about 5,000 people?
roughly.
And they use a true random number generator that works. And doesn't select the same people all the time.
Except if you're on the board.
Except if you're on the board, you get out every time. That's 100%.
Yeah. And these are only active people, because when we make the selection, they all have to hold an active license.
Okay.
Because there's no need to select somebody who doesn't need to do CTE. But some of these, either they retire prior to getting the letter, they retire to avoid having to report CTE, whatever.
this is completely off the agenda, but Mark, have we ever considered doing state-specific internet course presented by the state board? I know we're going to consider some rule changes on instructors and things later, but I just was curious about that.
I've actually given it some thought, Trey, but I've not pursued it.
It just seems like if we're traveling the state, presenting and doing things now with the internet, it feels like we could present our own course. I mean, of course, a lot of people make a lot of money presenting our state ethics courses, but if we're presenting in other cities and doing things like that, would it seem reasonable at this point in time that we start pursuing that avenue?
We have, just tangentially to mention, done what I think one would call a webinar. When we go up and do for the revenue department,
Right.
they have 5 or 6 sites where people are watching
Right.
this remotely, so it's some form of distance learning. But it's expensive to have the cameras and stuff. That would be one thing we would have to consider.
Well, but we travel too to present these
That's-
courses,
yeah.
so that would be some of the offset, I would think.
Do you charge now when you present a course?
No, that's a free service. He came to my office.
Yeah, it's a service the board provides.
Do you have to have it, what's the minimum number?
10.
10?
But one of the reasons we started doing this, and I'm not teaching anymore because I'm
Right.
kind of a full-timer, but to let people get out and see who we were and find
Right.
out we didn't have 2 heads and that we would answer their questions. And we
Well, and I'm thinking, maybe you up the 10 to 20 or something.
Yeah. We upped
You
it
could
from
play
5
with the
to
numbers
10.
or something and then
Yeah.
have
'Cause
it stuff there.
we have one guy who's in rural, between here and Jackson, who's a sole proprietor, and twice he has gone out to get 30 or 40 people, other
To have,
sole proprietors, yeah.
right.
And they're the fun people to teach sometimes
Right,
because they
right,
really
right.
don't have any exposure
Right.
in the middle of nowhere.
Well, and we have state society meetings
Yeah.
all over the state that we can, I'm sure, be invited to speak and do things of that nature. But it just seems like this way we also have control over the content of what we're teaching as far as ethics. And we can take things that have been a problem, for example, in your experience, what are the problems that you're seeing out there when you're auditing these folks, and start incorporating some of that to deal with real problems that the board's facing.
Oh, just tangentially, I think it was really funny. I mailed the letters. The initial invitation is by letter only, kind of like the military congratulations. The initial letters were mailed the morning of April 17th. The first audit was received on 4/18 at 12:18 p.m. Since we do it by email, I mean, that was pretty exciting. Yeah, but I do work at coercing these people, I guess you might say. If they don't respond, we don't leave them alone.
Kathy is relentless.
Thanks her stats for proclamation.
Is there anything else? If not, adjourn. Thanks, everybody. We're adjourned. We're
All
done.
right.
We're done.
Real good. Calling to order the Laws and Rules Committee of the Tennessee State Board of Accountancy. I think we have 2 items we will discuss today. The first is it's a retired license status, and I'll kind of go over those. I think the item that we're discussing is we're trying to establish retired license status. A licensee whose certificate is in good standing. I'm just going to read this off of our notes. Good standing shall, upon reaching the age of 55, be eligible to place his or her license in retired status. In order to place a license in retired status, a licensee shall send a written notarized request to the board requesting that his or her license be placed in retired status. The licensee's request shall include a statement verifying the applicant does not intend to provide accounting services and does not intend to receive any compensation for providing accounting services while his or her license is in retired status. A licensee whose license is in retired status should be prohibited from signing any documents as a CPA, and signing of such documents would constitute providing accounting services. And we have two tiers of retired license status. A life licensee between the ages of 55 and 65 who possesses a certificate in retired status should be required to pay an annual renewal fee required of all certificate holders. A licensee over the age of 65 who possesses a certificate in retired status should not be required to pay the annual fee required of all certificate holders. Licensees over 65 retired status may keep their wall certificate. And expirations of applications for initial licensure. All applications for initial licensure shall expire 1 year from the date of application from the initial date, and then all CPA exam scores shall expire 10 years after the last passing score is earned. However, upon written request, the board may at its discretion grant an extension. Now, this is how it stands at this point. Is that correct, Mark?
No, these are proposed changes that this committee has already approved, and they sent it back to legal for appropriate wording.
Okay.
So they've been approved in theory,
right,
and now you're getting the actual wording that he's proposing.
These words are what's proposed.
Yes, sir.
Approved. Language, I guess, this language, the proposed rule change, I guess, would be the language toward the end of this, these statements. And they want to replace the word lapse with expired. I think would be the, I'm assuming this is correct.
Yes, sir.
Is there any discussion on that at all we need to have?
Mark, does the content pretty much look the same as it did when we passed it originally?
You want to ask me that again, Trey?
Does the content seem pretty much like what we passed, just add
Yes.
some legalese to it?
Yes.
Okay.
I've read that out loud. I mean, I know it's on the form, but just so everybody could hear it. But is there any discussion or change that we need to make? Or?
Are you just talking about the second part or the first part?
Well,
the retired or something else, or all of it?
I would say all of it.
I guess I have a couple of questions on the retired.
Okay.
If that's okay. On the retired, can you? I think there's new people on this. Is that correct?
Yes.
Can you explain why we got here? I mean, what was the, did we not have a retired status, or are we revising a status that was already there?
We have a retired status. What we're trying to do is outline what the licensee cannot do as a retiree.
What you cannot do as a retiree?
Yes.
Okay. So if you're between 55 and 65, you can't, this is saying that you really can't do anything, but you still have to pay the fee, right?
Yes.
And are you still required to have CPE? Because I think when I read it, I wasn't sure in either section how CPE would be treated for these folks.
No, you're not required to have CPE.
And is that because you're now considered inactive?
Basically, yes.
So is it a problem if that's not really clarified anywhere, or do you think it is on the CPE side?
I think it is on the CPE side.
On the CPE side, doesn't it say actively licensed that you're required to present the work verbiage?
No, I think it says, in Rule 0020-5-.03, it says, upon application supported by such evidence as the board may require, those licensees not practicing in Tennessee who do not perform or offer to perform for the public one or more of the following kinds of services, yada, 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 may be exempted from any continuing professional education requirements provided that. So I think that this rule, the way that it's worded, saying that you're not going to be providing any services, places you in that category. So then you're not going to be required to have the
But then do
CPE.
they have to, can they still use the title and put inactive after it?
Or retired,
Or
yes.
retired? And where does it say that, does that need to be added anywhere, or is it clear in the revision that you would use that?
That may need to be added.
So I guess under item 1, we need a change in that item 1.
Well, the way it reads in the rule right now, in regard to inactive licensees, says licensees granted such an exemption must place the word inactive adjacent to their CPA title or PA title when used in any written form, with the exception of their certificate of registration. So I'd say that you could probably adopt that language and just place retired there instead of inactive, and say licensees granted such an exemption must place the word retired adjacent to their CPA title or PA title when used in any written form, with the exception of their certificate of registration.
Mark, what page are you on?
Page 63. I'm in section 3A.
Okay, thanks.
The problem we have is that currently we have a retired status internally, but our rules don't address retired per se. We have inactive, and we've been treating retired people just like inactives. So we're trying to get something in the rules to address this retired status that we're offering.
And Actives have the same, I mean, do they pay the fee, the renewal fee, and
Yes.
the same
Yes.
treatment?
If you have a license, you pay the renewal fee until you're 70 years old currently, regardless of your status.
So the only way, if you close and you give back your wall certificate, then you're free. But this basically.
I wouldn't phrase it like that.
Basically, the inactive and retired allow people the choice of which way that they want to, I guess, characterize themselves. And it allows them to keep their wall certificate, although they're not continuing to practice, but yet they're still part of the profession.
Part of the profession, they can tell people they're a CPA. Yeah. So if we duplicate the language in 3A and simply place retired there instead of inactive, would that satisfy the committee?
You're duplicating that over to for the retired?
Yes.
You're not getting rid of what's there?
No. Lord, no.
Do we need a motion of anyone to accept that change?
I think that would be a good idea. Yes, sir.
I make the motion to accept that change.
Second.
So moved with change and added the word retired to 3A. Along with our next consideration of changing the proposed rule changes that have already been considered is replacement of the word lapse with expired in Rule 0020-5-046. Is there any discussion of that from anyone? Did I accept it or?
I think that is an incorrect site, Mr. Chairman.
Is it correct? Is the rule incorrect, the rule number incorrect?
I think it is. I think that is supposed to be 0020-5-.036.
discussion at all? Motion to accept it.
So moved.
Second.
Motion has passed. Those are the two active items we have on our list today. Is anything else we need to add, or?
If I could ask one question, Mr. Chairman. I'm looking at my document on this thing. At the bottom, there's something about additional language specifically stating that the board has no jurisdiction over fee disputes. Is that something we're supposed to be addressing today, or I'm just talking about what's on my thing here?
This, I guess, would state proposed language in the rule of the board has no jurisdiction over fee disputes between licensees and clients. The board shall not seek to impose discipline against the licensee on the basis of a dispute between the licensee and client regarding payment of fees by the client for professional services rendered by the licensee. So that seems to...
The board traditionally doesn't get involved in fee disputes, and I think council is trying to clarify that with a rule stating that we're not going to get involved in fee disputes.
Yeah, so my only question is that, I mean, does that need to be addressed by our committee?
Yes, please.
Is there a motion for, I mean, do we need to, is there anything to discuss with that? I'm assuming that's straightforward.
I have nothing to discuss.
Yeah.
I would move to accept it
Okay.
to committee.
I second that motion.
Motion is carried. Is there any other items?
No, sir.
Mark, anything we need to add to that?
No, I just want to be sure that you all understand that we are proposing now to, that we're putting in this language about licensees. Initial licensures shall expire 1 year from the date of application. And we're also putting in the section about the expiration of the exam scores. Currently, exam scores do not expire. We have to keep them in perpetuity. And we're proposing that after 10 years, those exam scores be expired and we can destroy them.
What is the reason for keeping them in perpetuity?
I have no idea.
Okay.
I just know that there's no rule and no law anywhere that says those exam scores expire, and currently we have to keep them all home.
Is there any reason that people would need their exam scores past that period of time?
I can't think of one, Vic. I think if you've passed the exam and you've had 10 years to get licensure, and that length of time, if you haven't decided to become a CPA, then you're probably not going to. We did have a couple of applications come in last year, people who passed the exam back in the late 90s and early 2000s who wanted to be licensed. So it does happen, but I see no point in having to keep all those exam scores for 1 or 2 applicants.
How do other states treat that? I mean, are we going to be different? Will people be caught unaware?
No, actually, we're one of the few states that has no expiration date established.
Is 10 years pretty much the norm?
10 years is kind of on the outside range. Some keep them 5 years, some keep them 7. 10 is longer than most, but since we've kept them always, I think we probably need to go with 10 years.
What happens if somebody is outside that range? They just have to take the exam?
Yes. If you passed it once, you can pass it again, right, Wendy?
Mark, in that case, could that person produce documents from the AICPA that with their grades, or do they have to be, or do we have to have an official transmittal from AIC or from NASB or whatever, that the testing agency, whoever it has to be, but
You know, I think that would be at the board's discretion. If they brought something in that was older than 10 years, I would be loath to accept it myself personally, but I would certainly bring it before the board.
But if it was from considered to be a reliable third party. I'm kind of like, you know, I mean, why wouldn't we consider it?
Sure. I mean, that's
the language of the rule proposed.
the language of the proposed rule says, all exam scores shall expire 10 years after the last passing score is earned. However, upon written request by the applicant, the board may, in its sole discretion, grant an extension of the score expiration for good cause shown. So the board has the authority.
So
to,
we have the ability to consider
yes, sir.
other facts.
Yes,
Okay.
sir.
Question? Our meeting is adjourned. Unless, is there any, I mean,
Yeah.
I'm new at the chairmanship, so you'll have, you can help me if you need.
Mr. Chairman, I think there was one more agenda item on your list, and that was consideration of a rulemaking hearing at the January meeting.
There's something I don't, or maybe something I
It's on your PDF. Well, it's on the agenda.
Is there any discussion involved? And what, like I say, this is rulemaking hearing January 2013. Exactly what ruling are we discussing?
Well, these rules that you've just looked at,
Right.
these proposed language,
Right.
we need to get these approved and moved into the rules. The only way to do that is through a rulemaking hearing.
Okay, that's the process is what I.
Yes, sir. You've got to have a rulemaking hearing to put these rules into the rules.
So we have these accepted, we've accepted them, we've reviewed them, we've accepted the wording of everything that we discussed today, and then in January of 2013, we have to have a rulemaking hearing to put these in
Yes, sir.
the rules.
Yes, sir. That is correct.
So we're recommending to the board that a rulemaking hearing occur at that time. Is that what we're suggesting?
Yes, sir.
Yeah.
So moved.
Speak up.
So moved. Let's have a rulemaking hearing in January.
A second.
Motion carries. Rulemaking hearing January 2013.
And with that, Mr. Chairman, I think you are finished.
Thank you very much. We're adjourning the meeting with the guy.
10 o'clock. Oh, gosh, I lost my, sorry. It's okay to bring it up my agenda. 8 topics. First thing on our agenda is to review activities allowed to retired and inactive licensees. Mark, do you want to walk us through this?
Well, this is a result of the call that we had last board meeting with Mr. Cowles. And in that board meeting, Mr. Warren and Ms. Stickle assured him that we would revisit the activities allowed to retired licensees. If you remember, he was asking to be able to provide management advisory services on a retired license, and the board instructed him that he could not do that. So as a result of that, we're going back to revisit Rule 0020-5-.033, which outlines what a licensee may or may not do as a retired licensee.
Mark, where can you find it?
If you'll look in the rules,
Okay.
Are you on there?
I think I've done it.
Well, sure. You tell me,
Proposed rule changes or clause and rules?
there's one at the very bottom, Bill, that says Rules of the Tennessee State Board of Accountancy.
Okay.
Mark, you got a number sheet, what page is it on?
Well, It's on page 63 in here, but that ain't going to help you because that includes the laws. I'm in section 5, page 2.
Down at the bottom, if you tap on it, show you the pages down at the bottom, what page you're on.
It's 35.
35, 44? Yeah. Okay, I just want to be sure. What page is it in here?
63.
What is the issue, Mark? This is with regard to CPE, right?
This is in regard to what a retired licensee may or may not do in regard to performing accounting services in the state of Tennessee on a retired license.
You see?
Yeah. 3, I think this is it.
That's right.
I think it's wrong on the agenda. I mean, I think it's wrong on our,
Well, I know it is, but what does this refer to retired? This is about,
well, we'll have to provide evidence as the board may require those licensees not practicing in Tennessee who do not perform or offer to perform for the public one or more kinds of services involving the use of accounting audit skills, including the issuance of reports, management of our social representatives, may be exempted from any continuing professional education requirements, provided that Mark, you'll have to refresh my memory, because I remember the phone call, I remember the decision. I don't remember what we were revisiting.
Well, I think the issue was you were going to revisit whether or not a retired licensee could offer any services in the state of Tennessee on a retired license.
Okay.
Now, the Law and Rules Committee is going to propose something to you a little bit later today that says, in regard to a retired licensee, verifying that the applicant does not intend to provide accounting services and does not intend to receive any compensation for providing accounting services while his or her license is in retired status. A licensee whose license is in retired status shall be prohibited from signing any documents as a CPA if the signing of such documents would constitute providing accounting services. So basically what we're doing is we're adding language to the rules specifically regarding retired licensees. Now, in North Carolina says retired status does not preclude volunteer services for which the retired CPA receives no direct or indirect compensation so long as the retired CPA does not sign any documents related to such services as a CPA. So they specifically outline that as a volunteer you can do this as long as you don't sign it as a CPA. You may want to consider adding that to the rule or proposing that to the Law and Rules Committee.
but it doesn't sound like we need to do anything here, from what I'm hearing, Mark. I mean, we're going to talk about that later in the full board meeting, right?
Yes, sir.
Instead of wanting to change any of the language reviewing this particular section,
But I guess the question would be, do we want to dilute this to some degree? But I don't think we do.
That's the question.
Yeah, I mean, he was asking for an exception, and then we're going to, I guess, reconsider what types of services might be appropriate on the retired status.
Yes.
But my recollection is that he wanted to be in a retired status and hold himself out as a CPA.
Well, yes, Bill. He wanted to provide management advisory services.
Right. But refer to himself as a CPA.
Yes.
But he could do that if he didn't refer himself as a CPA.
No, he closed his license. The board voted not to allow him that exception. So management advisory services are considered by definition accounting services in the state of Tennessee. So he closed his license officially so he could do that. So he could offer those management advisory services to his clients.
So somebody that's never been a CPA could provide those services without a problem.
Yes, sir.
But he cannot because he was once a CPA.
Still a CPA.
He was still a CPA.
Still a CPA, but even though he doesn't represent himself as, say, Joe Schmo CPA.
That's correct.
Well, I suggest we move on.
Okay.
I think we need to do it.
Are you going somewhere with that, Bill? Anything on?
I'm just, I guess I'm going to be unemployed.
So if you voluntarily do tax work, you can't sign a return?
That's what I'm hearing from the side.
But we're going to consider volunteer services here later in the board meeting, right? Isn't that what the, said we're going to, rules committees?
You can bring that up, Casey. That's not part of what the Rules Committee considered.
He was suggesting that as something that North Carolina's language provides.
Right, so we can talk.
We can talk about
yeah,
that, right.
Yeah, I'm saying there'll be an opening to do that later.
Correct.
Yes.
Yeah.
Okay. Move on.
Unless Henry objects.
We need to review the proposal for the new law and rules books.
That is actually in your iPads behind the proposed law and rule changes. There's one page of law and rule changes, and then there's a page that is the,
I don't think this is the same one.
Does every state publish the rules, or do any of them just have it on their website?
I think by and large, most do have some type of written document, Bill. We're still in the paper society to a certain extent.
How many active licenses do we have?
Active licensees close to 10,000.
We're printing 1,750 books.
We're not going to send them to all the licensees. We're only sending them out with the new licensees, with the application packets, because it is on the web.
You would have had copies though for the board. And
Yes, sir.
And others that may need a hard copy. You'll have to pay for that.
Yes, sir. We estimate that this 1,750 will last us about 18 months.
What's the cost? I'm sorry.
Cost is $22,580
For 1,700 bucks.
for 1,750 books.
12.
How is notice going to go out to the active licensees? By going to the website, only voluntarily checking it themselves, or is there going to be notice?
Well, we've tried to put notices in the newsletter that there are rule changes. Other than that, it's on the website.
This book costs $12.50 to print.
90.
Don't mind.
That one didn't, because we printed like 22,000 of those. It's the more you print, the less they are. Yeah. It's
Oh, that seems crazy.
22,000 is the initial setup and all that.
Who prints those? Do we bid it out, or does the state do it and charge us back, or what?
LexisNexis is the provider, and they're the ones that the state uses.
So this is a state contract that we're just operating through.
Yes.
That's expensive.
When you refer to the newsletter, that's the once a year thing?
Yes, sir. We are going to try to do 2 newsletters this year, one in the spring and one in the fall.
Do we give this, when they print, do we give it to them and then they print, how does that work?
They pull the information directly off the Secretary of State's website, so they have the most up-to-date law and rules available.
Okay. So when in effect, we're generating the type, the layout. Is that right?
We're not, no, they do it.
They do it.
Well, I mean, we type things up, but when we do the rules and send them to the Secretary of State's office, if there are any formatting issues, because there are certain formats that it has to be in terms of, paragraphs, subparagraphs.
But the state does that. We're not relying on an outside service to lay this book out.
Not to my knowledge, it's probably pulled electronically. I don't think there are people sitting at LexisNexis, looking and typing this thing by hand. That's my guess.
Are we required to operate under the LexisNexis agreement form?
Yes.
We have no choice.
Right. They are the vendor of choice.
Is it possible to, since we have email addresses now, some state boards send out emails, mass emails to notify pending or actual rule changes?
We can certainly get on listserv and do that, Stan.
I think that could be more effective than the newsletter.
Yeah.
Because it can be done, on a timely basis, on a monthly basis. Sometimes when I read the newsletter, I thought, oh, Lord, that's something we approved a year ago, So it's not as current as an email.
I agree with that. I also agree if you're a new licensee, it is kind of nice to
I agree.
get this in the mail, but $12.50. $12.90. Keep going. I don't know why I keep on saying $12.50.
Just round up to $13.
That would be the easiest thing.
So, Mark, what do you need from the committee?
I guess an approval to spend the money.
I want an approval to spend this money. I felt this was a lot for that number of law books.
I think we need to do it, and I'll make a motion that we approve this expenditure of $22,580.74 for 1,750 copies of the new book.
Thanks, Tracy.
Okay, I have a motion, a second. Any discussion? Hearing none. Signify by aye.
Aye.
Aye. So okay. Discuss the policy relative to licensees who default on student loans.
Is that in this thing you handed out?
No, it's not. This is something that the committee discussed at the last meeting. We had one of our licensees who had defaulted on a student loan. My notes indicated that the committee recommended that after the first default that we call to determine the reason for the default, and then if there is a second default, to open the complaint. So I think that's what the committee needs to recommend to the full board as a policy in regard to handling student defaults.
That was part of that original discussion. I guess y'all were probably part of that. So that was y'all's recommendation out of the last one. I don't think that's a bad idea. Give people the benefit of the doubt, I guess.
I wonder why we singled out student loans. I mean, I don't know where student loans fit in the scheme of somebody that's forced to file bankruptcy or get relief from the bankruptcy courts or whatever. How did this particular issue come up?
Well, there is an entirely separate statute. I think it's 561308, but it's not in our statutory rule scheme. But it specifically allows for the suspension of the professional license of a professional if they default on, I think it's mostly TSAC approved student loans. Not exactly sure which all categories fall in, but I have seen a couple, and by the time we see anything about it, there's already been a default order, ordered for the board to suspend based on the order done by whoever handles those things. And so by the time we get it, they have received, you know, at their last notice of record for whoever does this stuff, you know, a notice that if you default on this, we're going to send out an order to the board or boards that you're licensed by, requesting, or in some cases ordering, that the license be suspended until, now it's not until you pay in full, because that would be ridiculous, because very few people have the kind of money to do so, but once they get into a payment plan that is agreed upon by the debtor and whoever they owe the student loans to, the folks who handled the original suspension request or order will send something back to us saying they've entered into a payment plan, and if their license was suspended as a result of our last missive to you guys, then it can be lifted now.
Is that an automatic suspension, or do we have to, as a board, act on each situation that comes up? Is it just Tennessee laws, or is it federal student?
Well, the things I'm referring to are Tennessee laws. I've not seen anything federal in this regard, so I don't think we have to worry about that, at least right now. But I think one, maybe two tops, Mark, is all we've seen of these so far. Yeah. And the last one we had was a while ago, so whether it's mandatory or permissive, I would probably have to look at. But if it is mandated by statute, you know, I have some questions about that, because it's potentially in conflict with 62.1.111 that requires notice and hearing before you can take action against a license, which is a property right. So, you know, I guess there's an argument to be made that, you know, they had notice and a hearing about their student loan default, but that's an entirely separate question to me as to whether that separate default constitutes something that would be disciplinary action under our law and rules that would mandate or at least allow disciplinary action if necessary. So if the committee and or full board would like, I can try and put something together between now and the January meeting to sort of give you an idea about how those things interact with one another, and whether it is mandatory or permissive. And to be frank, the reason I say in January is because I may have to speak to some folks a little higher up the food chain than myself, because it does, you know, like I said, implicate property rights and people's professional livelihood. And I would like to make sure that I get a good, correct answer to the board.
I wonder too about like bankruptcy, the way, you know, people do have student loans and have other problems, and they have to file bankruptcy, and courts are there to let people be rehabilitated. But if they can student loans and federal loans be, I guess, forgiven under the bankruptcy statute?
Not anymore. Not since 2005. You got to be dead or quadriplegic, pretty much. I mean,
get relief from the student loan situation.
It used, I mean, pre-2005, before the most recent bankruptcy code amendments, you could get relief, and people frequently did, and that's something that has raised the most hue and cry among certain sections of the public, saying, hey, look, you know, if the purpose of bankruptcy is to rehabilitate people financially and allow them a fresh start, you know, how's that supposed to happen? We have to say, okay, well, you know, we'll wipe out your $1,500 credit card debt, but not your $150,000 student loan debt. But that question is one for the policy nachos in D.C., because it's all federal. Bankruptcy
Right now, there is no relief for student loans and so forth. Of course, what we're talking about here is just opening a complaint, right? Which would be then being handled according to like every other complaint, and being investigated. You know, another one would have to come before the board for resolution.
Yes, sir. That's correct.
I prefer to wait on this if we could, to let Chris get some more information.
You have a problem with it?
No, we have nothing pending, so that would be fine with me.
We're talking about tabling this to the next meeting. That's fine. Let's reword policy 2.6 relative to the ethics education.
This is in your policy statements. Again, this is something that was deferred from last meeting. I think what we want to do is just vote to delete this particular policy, since we are now requiring 2 hours of state-specific ethics as opposed to 3 and 1. This was just a clarification for the rule that was put in the law originally in 2007.
So we just no longer need it.
Right.
Was there a reason it was deferred? Just out of curiosity.
Last meeting ran really long, so a lot of the executive committee.
We delete second paragraph, was it 2-6?
Got a motion of a second, any discussion? Signify by aye if you approve. Aye. Okay, and financial information. This is the budget, Mark.
That should be under operating results.
Okay, I don't see
It's under T operating. Tennessee.
that. Oh, Tim. Yeah, Mark, you want to provide the commentary here?
Well, the first page, what you have is year-to-date, they've provided me with the numbers for the second June closing for June 12. It looks like at this point, we're going to be putting $160,970 into our reserves additionally from 2012, bringing us to a reserve balance of $775,614 as of June 30th, 2012. There are really no significant changes to the numbers that I had provided last time.
He says the second closing, does that mean there might be a third, or is this the last closing, or you don't know?
They usually do a third, sometimes a fourth, before they give us the final numbers.
Kind of slow.
Sorry, saying I'm not going to respond to that, Casey.
No 12/13, June 13.
If you'll go to the next page, you have fiscal 13 actual as opposed to the fiscal 13 budget, and then you have numbers for August 13 compared to August of 12.
I don't recall. Is our 13 budget passed?
Yes, sir. We'll be working on the 14 budget between now and the January meeting.
Mark, I looked at these again last night. I did not see anything that was out of line or any question. So you got any comments or anything you need to point out to us? Not a lot you can do. I mean, 2 months, this is 2 months into the budget year. Obviously don't have a lot of revenue yet. The expense side, everything looks pretty much in line.
Yeah, there's really nothing outstanding on these, Casey. That I did want to point out that state regulatory fee, that $60,145 is being subtracted from our revenue. That is the total number of licensees for whom the statutory fee would have to be paid if it was assessed today. It will be assessed as of June 30th. I will tell you that the department has been through a performance audit, and they have been told that they've been incorrectly assessing indirect costs to the regulatory boards. So I'm not sure how that's going to affect our cost backs. I have a feeling it should greatly diminish them. The offset may be that the state regulatory fee may be increased so the department can recoup some of its costs.
I assume these computer-related items for the year were the iPad purchases. Is that?
The computer-related items.
Is that why that's up over last year?
That was up because we got new computers.
Y'all got them.
We had the old ones with one screen. They put everybody with the 2 screens.
Did the iPads get in this line?
These iPads were bought by the department,
Okay.
so they may be assessed in some way,
Okay, but not on this.
but not a direct line item. No.
Mark, on the projected June 13 numbers, it looks like you just used the budget amounts.
For now, I did, Bill. We're just 2 months into the year. I'll be able to give you a little bit more information in January.
But as we talked about when we this was brought for approval, the last couple of years we have spent $45,000 and $51,000 on travel, and yet we budget $90,000. Is that a plug number?
To a certain extent, it is. When I have extra, that's where I put it.
It's a WITTB bill.
Yeah, right.
What it takes to balance.
For the attorneys on the rim.
All y'all do is know
Again, as management prepares the 2014 budget, I would really encourage, I would like to vote for one once in a while, and to have the budget really reflect what we need and what we expect to have happen, and not to have it be, you know, rounded numbers of $90,000 for travel that is already has unnecessary, legitimate focus, but has been subjected the State Board of Accountancy to criticism in the past.
I will say this executive committee seems more committed to working with a budget process, so you'll be getting more information from me on the budget as we go before January. You'll be getting detailed information on where the numbers are coming from and how they're being computed and that type of thing.
Great. Thank you.
So is this, what we're not talking about, I know maybe Bill in prior meetings brought up the idea of reducing licensing fees, and we'll continue to build up a reserve down there, and then we'll be looking at that in connection with the.
Did you bring something, was that the last meeting or 2 meetings? Did y'all give us a breakdown of fees by state?
We did.
That was the last meeting, wasn't it? Or
I think it was the meeting before last.
We are,
I think the problem we got into was there's a tipping point, and it was going negative, positive.
with regard to the
Yeah.
budget or the fee.
I can't remember if it was the budget. It seems like we were running the math on that, and it was.
Well, I think we were in the middle, a little bit below middle with respect to fees on a national basis, or at least in the southeast region anyway. And because a lot of people have to pay 3 or 4 times what we're paying. But a lot of them don't have firm permits either, or member service permits. But I think what you might be referring to, there was one time, Trey, that the fees were reduced, and it was cut from, what was it, 60?
I just remember when we were talking about this in that one meeting, I was sitting there trying to do the math on the budget versus
it just didn't quite work out.
fees, and it seemed there was a, and maybe what we need to do is maybe if you showed us, but I don't remember if we did this or not, a $5 reduction in fees, you know.
Like I proposed.
Yeah.
Does that make sense?
Well, part of the issue is that we have for years run a surplus, and the surplus gets swept periodically, and it really results in an extra tax to our members. And one way to deal with that is to reduce our fees so that we don't run such a great surplus.
And we had...
Well, and this could get massive now if they do turn around and reduce our allocation from the state
Yes.
itself.
Before they increase the state regulatory fee.
Right. True.
Yeah, historically, there were some reasons why we did what we did to bring you up to today. One was that we did run a deficit one time after the fees were cut, and we were told that we couldn't do that, and we increased the fees. The second reason was that we had a desire to be independent, semi-independent, and we weren't sure what the cost was going to be to do that. So we kept the fees at the same level that they are right now, in anticipation of being able to do that. Then they got cold. We're not considering that now. And of course, the problem with the fees is that it takes about a year or two for it to kick in. So just bring everybody up to date.
So it seems that now's the time, though, to get that
Yeah,
back on
that would be
the
the time
table.
to do it.
Don?
Right, we had tabled the idea, as I remember, because I think I had to chair that meeting, soon when we were in the consultations on, because we had instructed Mark to try to see if we could get into the study group that was supposed to happen this summer as part of the independence study, and then to revisit at a later time reducing the amounts. And I don't know where, Mark maybe can speak to that, where we were on getting into the independence or semi-independent status moving forward. You know, some of our ideas of wanting to be independent with this current administration had gone away, and we've got better communication, and you know, we're doing things like the law says, and not that anybody trying not to.
Right.
Some of those initial push items, but there's still a lot of reasons to be semi-independent. So I think that was what we were waiting on, was this desire to be part of that study group this past summer. And I was waiting for we are.
I don't think we were included in the study group, as it turns out.
I think the appropriate thing to do would just come back with some proposals of what things would look like with a $5 reduction fee.
$5, $10.
Yeah, just so we
Okay.
get an idea of what that will do. Just now, I guess a lot of that does hinge on what the state ends up doing. If they take away and then they add back, or however that works, I don't know what they're going to end up doing.
And if I could just, something else for the community to consider. The last time I was over on the Hill for the GovOps committee, it was as part of the audit of the regulatory boards division, which this board is part of. There was one program that actually had run a deficit, and they faced some very pointed questions about, hey, you know, what did you guys do? How did you get here? Did it involve something you did, or cut fees or anything? But with the stated concern being, look, you know, we don't want you guys have to come hand in hand, and then taxpayers have to give you a bunch of money.
Right.
And so I think whatever is done ultimately should at least
Not open us up to additional
that.
scrutiny.
Yes, that.
I don't disagree with that either. I think that doing just a proposed, here's what it looks like, will give us a better idea of what
We can do that.
we need to take action on. Okay.
We will do that, Mr. Chairman, when we prepare the budget.
So that takes care of the financial information one.
Yes, sir.
Okay. Anybody have any issues with the financial information? No. Okay. And then the last thing is the evaluation of the executive director. You said this got tabled as well from the last executive meeting, is that correct?
Yes.
Well, I think that at a prior meeting, the previous executive committee gave their report to the board, but what was deferred was whether there was to be a recommendation regarding a pay adjustment. Do I recall that correctly?
That's what I recall.
And the point was that, and that it was agreed that in the future, all board members would participate in providing input on the executive director and not just the executive committee.
Which we did last time, is that?
No, non-executive committee members had no input in the evaluation.
I thought I had to do an email, or I was, did we not? I don't know if I sent it out to the whole board. We did not.
We sent it out, but no one sent it back.
Well, you sent out an information copy.
An information copy, yes.
The blank form wasn't sent out.
I don't think it was, Stan.
Because it was basically the details of what the then executive committee had individually prepared for the board information, but
yes, sir.
No further input was solicited.
I think there was a desire to retool the tool too, the evaluation tool. Because we had developed it with the board over a year, I think, of input. The board members here, the members here now were not a part of that, but we did submit that tool to everybody. Don had a special one that he had submitted. Anyway, it was a lot of input involved. But if it can be better designed, that's fine. We need to do it.
Well, I guess my question, what is the process? I mean, is it done on an annual basis on a certain date? And so far, has it just been done based on verbal input from the...
Well, here before now, the evaluations were not done. It was, I started the evaluations my first year, I believe, as chairman. And then this last one was the second evaluation. Before then, there was not a formal evaluation tool used to evaluate the executive director at all. I don't know that there was any evaluation communications had along the way before then. So,
what is the timing of that?
we typically adjust the timing. I think we would do it, usually we did it in January before the April or May meeting. It wasn't a set time.
I don't think it was.
Right.
It's been done in January, it's been done in July.
Okay.
When do we have to go to the legislature and ask for pay increases and things like that?
The FY14 budget should be prepared and passed at the January meeting so it can be in the department's hands and to Finance Administration prior to their submission of their budget.
So would it not make sense that we would do the evaluation process prior to that?
In July or October is what I would suggest.
Okay.
And this time, I think we did do it in
July.
The first time we did it, it had to be done when we wanted it at that time because it was timing. Timing was an issue. It had been put off for a period of time while we developed the tool to do the evaluation. My memory serves me right. As to the budget itself, now I requested an Attorney General's opinion, and Vic Alexander had requested one prior to me, and that opinion, the request was, my particular request had to do with being able to spend the budgeted funds for the, it was whether or not we control the salary of the executive director, and because that's the only salary that we control. And the opinion came back, as I recall, I don't have it with me, Mark has it in the file, so I'm sure, that once the budget is submitted, whatever the line items are, that is the budget, and we have the authority to spend within those line items, however we intend to allocate it to that.
But F&A has generally not approved it. In the current budget, as I recall, for 2013, operating under management recommended and the executive committee approved, or the budget that was approved, had a 5% across the board increase for everybody. Do I recall that correctly?
Yes, sir, that's correct.
And which would be considerably out of step with the salary adjustments given to other state employees.
Yes, that is correct. There was a 2.5? 2.6. There's a 2.6 salary adjustment as of July 1st this year.
That everybody
got. Yes, sir.
And the 5% was above and beyond that.
No, sir, that was included in the 5%.
Okay. But so there's what you're asking for, or the budget request was another 2.4.
Yes, sir.
You're saying the budget did not get approved?
No, it did get
It did get approved.
With the 5% or?
with the 5%, yes.
But we didn't approve a 5% in the last executive committee meeting, was it one before that? We approved 2.4, I believe. With,
Well, we haven't approved anything beyond what
Well-
the state has.
well, the executive committee recommended
Okay.
an approval. We approved it at the executive
Okay.
committee level to
But the board
submit
didn't.
to the board, correct?
Yeah, it was submitted, but there was no action taken on
Right, because the meeting went too long.
it. Yeah.
No, I don't know. I guess Casey, were you on the executive committee at that time?
No, I didn't.
I guess I was on. So I will try to address our decision, if you will. Mr. Crocker has worked under 3 chairmen now. And he has not, during that time frame, he has done everything that the board has asked him to do. When I first got on the board, when I was first appointed to the board, and as we matriculated through your tenure, if you will, I think there must have been a period of time where I was here for a full term and never seen a formal hearing. Had never sat in on one. And you guys who are new to the board, your first meeting.
That's all we know.
Right, it was a formal hearing. Along the way, we were criticized quite a bit because we were not closing our cases and so forth. Part of that was due to us. We also had a continuing revolving door of attorneys that was coming through and so forth. Mark worked through and with another chairman, and we were able to slow that process down. And now we've had Chris for
3 years.
3 years, okay. And it has been a great help not having to re-educate an attorney every time that we have a new one come in. That has been helpful in pursuing and closing the cases that we have. And we've done, I think, a great job in doing that. We determined along the way that most of the practitioners know that there is a state board of accountancy, but they really don't know anything about the state board until there's a negative contact, if you will. Everybody knows who the Tennessee Society is, but no one knows the state board and really get involved in what we do. So we asked, and we thought that it was a good idea after some discussion over a year or so, that we need to reach out to the practitioners to let them know what the state board does. And part of that also was the ethics component. And Mark was able to, has reached out quite a bit and talked to the practitioners throughout the state. They know who we are now. In the process of even filing a complaint, I was fortunate to attend a Tennessee Society Memphis chapter meeting with Mark, and Don Mills made a presentation, and I think it was a full room just because they were there to make the presentation. Not only on the ethics part, but they gave a lot of information about things that had happened in the past and the outcomes. And I thought it was a very useful thing to happen. Along the way, there was concerns about the travel, and this is as an aside to what I'm trying to get to now. And so we asked Mark to develop a report that shows where he was, the contacts that he made, and the dates. And he's done that. I guess it's in this executive director's report. I know it was in the previous one. Previous one, okay. And so the point I'm trying to get at is that he's done from the executive committee's standpoint, and from at least this prior chairman and the prior chairman, this prior chairman and the prior chairman before me, which would have been Vic, we all felt that Mark was doing a great job. And he wasn't on the executive committee when this was done, because he wasn't on the board at the time, but he is, what I'm trying to say is the chairmen in the executive committee felt that Mark was doing a great job. He was doing what we asked him to do. He was doing what the board wanted him to do. Now, there could be certainly some room for improvement from anybody, I presume, but based on what we asked him to do and the measurements by which he was being measured against, he did a great job. So if there are other things that we want him to do, I think we should put it on the table as a tool to measure him by, rather than say he didn't do this or he didn't do that, when we didn't know he was being measured by that.
Without that expectation.
Correct, without that expectation. So anyway, the point is, I'm still supportive of the increase that we we're recommending out of the executive committee to the board, and those are the reasons that I voted the way I voted. Presumably, the executive committee, and it was unanimous at the executive committee level. It was not. No, I'm sorry. You're right. Bill voted.
Well, it never came to the board. I wasn't on the executive committee.
Well, who voted?
Well, it was the executive committee's recommendation, but...
Well, I mean, it was a recommendation from the executive committee unanimously.
Yes, right.
Okay.
Right.
Mark was saying no, I don't remember.
At the last executive committee meeting, Ms. Stickle was the chair, and I believe that a 2% raise was recommended by the committee, but it never went to the full board.
She presided over one meeting.
Yes, sir.
And did this matter even come up? I didn't know that we had an executive committee meeting.
Yes, sir. This matter came up and the committee voted on it, but it never went to the full board because we deferred the matter because the meeting ran so long.
I thought you were there.
No,
executive meeting
do you recall that there was...
No, I wasn't there. I went to the executive committee.
Okay, no, I do not recall the ratification or the approval of the salary adjustment by the executive committee. I would not have voted for it.
And you did not, Mr. Bloffus. It was 3-1.
Okay. But that's really old history because that
Correct.
committee doesn't exist anymore.
Right.
And so
Correct.
the issue really needs to come back up here. Mr. Chairman, could I?
Absolutely.
With all due respect to Mr. Sawyer and the prior executive committee and their evaluation of the executive director, I do not believe the performance of the executive director is notable or exceptional to justify a salary adjustment. Based upon some information that I had gathered tonight, previously, the current compensation of the executive director is 58% higher than the next executive director of regulatory boards. It's 69% higher than the average of the executive directors. And it's 12% higher than the assistant commissioner who oversees the regulatory boards. So at least based upon that criteria, I think that our executive director is very well compensated. When he was first appointed, I was a big advocate of the compensation at that time. I just think that to recommend a salary adjustment beyond the 2.6 that he and everybody else has received, number one, is not justified, and secondly, regardless of the Attorney General opinion, I don't think it is a wise move from a collaborative cooperation standpoint with the current administration and the Department of Commerce and Insurance. And I would not support the salary adjustment as suggested.
At the 5%.
That adding 2.4%. On top of that, I don't think it would
Pass anyway.
No. Let's not. What I'm basically saying is
Don't
that
start
let's,
from hornet's nest.
yeah,
We really
let's,
need to do it.
yeah, let's don't get into a duel that we're not going to win.
I would tend to agree with that philosophy. I think we're just going to be starting something up that we don't need to stir up. think that's wise for this board to do that. I would be inclined to agree with Mr. Ballfuss on that point. And again, I think what you're going to get approved for is what the state rate is. So. Any other comment?
Well, I would just be curious as to what the other state boards are paying for the size of the practitioners that the executive director oversees.
Stan, I'm sure that we could find all kinds of examples of higher compensation, and we could find others with lower compensation. We're dealing just with our situation. And, you know, I don't think one size fits all.
I agree with that. But you can't make a decision in a vacuum either, which is the whole point you gathered today that you gathered. And so I'm just saying the same thing, though. What would be the comparison if it were to be done? So the decision, although it's being made, is not being made in a vacuum. You still have to have some information.
Well, even in the evaluation that was done by the executive committee previously, it was noted that we have a very strained relationship with the Department of Commerce and Insurance. And that, I think, is a major issue for the interest of who we represent, that we be viewed as very professional and collaborative, and that's the responsibility. The lead of that is the executive director. And I think until we can improve that relationship and be viewed positively by the Department of Commerce and Insurance, that should be an agenda item for not only for Mark, but for all of us on the board.
That was in the evaluation.
Well, and let's talk about the evaluation process, because Mark, again, on a day-to-day basis, none of us are here, so I have no idea, you know, administratively how things work and how the staff operates on a day-to-day basis. And I don't think that's a part, I mean, I don't know how we incorporated any of that piece into the evaluation tool.
Well, looking back at the tool, I can't remember if there's any specific thing there about relationships with the administration, but...
well, and not so much just with the administration, but I mean, just as an office, how do we...
Yeah, I have to go back and look at the tool, but
Okay.
I do know that the committee felt that the relationships with the administration needed to be improved. And if you look at the evaluation, it says so in the comment section. Typically, right?
It does. But based upon the reports that we get for every meeting, board meeting of the executive director, from the executive director, we get information about meetings attended or meetings they want to attend, an investigation in Arkansas, state holidays, future meeting dates, license counts, state board, again, a committee that Mark has been invited to join, a court appeal, and CPA exam performance. There's really nothing in here about the operations of the department, which is consistent with prior reports.
I would think then the tool should be tweaked to include what measurements and expectations we want to have in that regard. As the executive committee deliberates about, this, maybe I would suggest that at the very least, when we come back in January, that this tool here be revamped and add, or things that we want to see happen, be something that we measure, and then secondly, develop a template that we would like to see have the executive director report on operational issues.
I think that could be very good. We should also ask the executive directors for his goals and objectives, not only for his own performance, but for the department.
I think a key point here, none of us are here enough to know what really goes on operationally, and most of our interaction really is with Mark. To me, it's up to Mark to evaluate others and, supervise and evaluate them. If we're charged with evaluating Mark, I mean, I would like to receive this template or tool in blank form so I can look at it, give some thought to it, and know more about what the process is, or if we need to change the process. But one thought I had is that it would be helpful to me to know what Mark thinks about his own evaluation. In other words, let him do a self-evaluation that he will provide to us as insight into what he does when we're not here, and things that we ought to be giving credence to. And so I would hope that he would do a self-evaluation.
We also have the staff do evaluations on market. We haven't had one recently, but last year there was one.
What does Commerce and Insurance do with most of the executive directors as far as the evaluation process goes?
Well, this year, for the first time, they are evaluating the executive directors. Mr. Giannini has prepared those, but he's not shared them with any of us yet.
Okay. Are you part of that process?
I am.
Okay.
Because I am considered an executive director under the Division of Regulatory Boards.
Okay.
So he will do an evaluation of me, but the board controls.
We can take that evaluation
Yes.
as part of your overall evaluation.
Yes, you certainly can.
And that has occurred already?
No, he's prepared it,
okay,
but he hasn't discussed it with us. Yes, so I have no idea what it says.
Yeah, I would say one of my primary objectives is improving the relationship with Commerce and Insurance.
Certainly.
Doing whatever needs to be done in that role. And I think that's a positive step that they're taking, I think, to evaluate all executive directors, not just you. Because that gives us an indication of, this is that admin piece I think that I was getting at. Because none of us are here on a day-to-day basis. I couldn't begin to say everything's working like it should, everything's not working like it should. And I think that's a piece that has been missing from the evaluation process in the past. I would certainly say I think you've definitely done what we've asked you to do here. But there is a bigger aspect of the job that you manage people. We don't necessarily get to see you manage those people.
Certainly.
And, you know, it is helpful when doing your evaluation to have that up and down flow of review process. So.
Sure.
Okay. So do we have to vote on this salary issue?
No. Well, the recommendation from the previous one was to do so, so if we wanted to change it, I think we could do it. I don't know. What's Chris?
Well, and how, I guess my question, how does this work? Because we've got a budgeted number that's already been approved. Of course, your F&I is going to do what they're going to do.
But it's not just 5% total per mark. It's 5% for everybody in the department.
Right.
Or is that what we're proposing to vote on?
Well, it's already there, isn't it? I mean, this is where I'm getting confused.
No, we're only voting on the increase for the executive director. We don't control the salaries of any other staff.
So you're saying that because Mark is the supervisor of all the other personnel, that he can implement the 5% adjustment because the budget has been approved? Well, then how can?
I think why do we need to do anything?
That's what I'm asking,
Because
yes.
the previous committee doesn't exist anymore.
Right.
And that recommendation never got presented to the board. Seems to me it just went away.
It's our recollection is that all we did was approve the budget with a 5% across the board. We never got to the point that we said Mark was going to get a 5% this time. Now, we had a previous one that was not approved. The board did approve a 5% 2 years ago that was rejected by Commerce and Insurance. Then when we approved the budget, because we didn't know what the state was going to do, we knew they were going to get one this year, we approved 5% across the board for budget costs. Not on, as I remember, not on an individual basis for anybody, including mine.
That's correct.
So I don't think you need to do anything for my opinion.
But clarifying question, the 2.6 adjustment that was made to all state employees, was that as of June 30th or July 1st?
July 1st.
So it was really charged against our 2013 budget.
Yes, sir.
Yeah, well, yeah, I mean, the will of the executive committee is not to do it, that's all right.
Well, and Mark, I guess too, if you would share that evaluation, at least with the executive committee.
Sure.
From Mr. Giannini when that comes in. And then I guess we need to, I think it's important the board evaluates, and I think it's important that Commerce and Insurance evaluates, and we can compare those two as part of the review process.
Okay, there was some suggestions made, Mr. Chairman, and I don't know if we need to vote on those, but there were some actual items we were suggesting, and I saw Mark writing it down.
Okay.
So is that something that we want to see at the next meeting?
Are you talking about the evaluation?
Self-evaluation.
Self-evaluation, also retooling this document, that would be our charge.
Correct.
So, I mean, there's two things. What is it what actionable items do you want the board to do?
I think
What action items should Mark?
Well, the goal setting, I think, is important to go ahead and do that, and then forward that to the executive committee. Can we do that by email or not?
Yes.
We can do that by email.
Yeah.
I would say, I guess we have to give him a template to do the self-evaluation, or do you think?
What could you use a template?
Use the one that's already there.
I would give the liberty of modifying that or changing it
Right.
yourself.
To have some latitude
Yeah,
with
to
that.
have latitude there.
But that evaluation tool would be, input would be from the entire board, not just the executive.
Correct. So I guess we need to see the tool, yeah. I mean, that's something I'd like to have you
Email
know to me.
to us, that's what I'm saying.
And then, just talked about 5 different things. So,
I will
got a
send you.
list.
I will send you the blank evaluation forms for you all to look at and modify as you think needs to
Okay.
be done. I will do the same thing.
Okay.
I'll set my goals and objectives for you
Yeah.
and do a self-evaluation based on the current template
Yes.
or as changes as I see.
Do you expect to have the Commerce and Insurance evaluation anytime in the near future? You have no clue?
They've got to be turned in by the 31st of October, so I'm assuming he's going to have to discuss those with us before then.
Okay. I would assume just as soon as you get that, then
I'll send it out.
May I add a request that at one time we asked Mark to do a duties and responsibilities job description. Do you remember that?
I do, and I think I've still got that set.
I think it would be good to give that to the full board as well. So that, and I guess the objectives and expectations that you're going to be developing yourself probably needs to dovetail into that somehow. And if it doesn't, then it needs to be revised.
Okay. I have my marching orders.
you get plenty of orders.
Yeah.
All right, any more discussion? Okay. I think that ends it for the executive. Yeah, sorry, new business. Old business, new business.
This is a suggestion really for discussion, as to the meeting frequency or infrequency of the State Board of Accountancy. You meet 4 times a year. Somebody misses one of those, they go 6 months without any contact. I just think that in order for us to discharge our oversight and fulfill our responsibilities, we ought to at least consider moving it to 6 times a year. But I'm just putting it on the table for discussion. If everybody's happy with the 4 times a year, I can forego the excitement of 2 other meetings.
Yes, my comment would be, are we taking care of business with the 4 meetings? If we're not, then we need to meet more frequently.
And I think and primarily, I think that relates to our backlog caseload, for the attorney to tell us. And we have added special days, like yesterday, if need be, to discharge backlog. And I don't know the availability of the attorney
it's not so much the availability of the attorney per se, because the attorney can, you know, assuming sufficient notice, you know, whether it's Jesse or myself,
Right.
Doing things in advance, we can reorganize our schedules. It's availability of administrative law judges. That's always the sticking point when it comes to scheduling stuff, because we don't have any control over the amount of days that we have available to bid for. Now, I will share with the committee, and later if the full board wants to know it too, I can repeat it, but my two immediate bosses are lobbying and pleading with everything they have for additional days for our entire division to have either available or at least available to bid on. Because, you know, if you got the regulatory boards division with 24 programs of worth of oversight, now granted, most of them don't have formal hearings frequently like this program and other ones, but still yet, you know, you've got the Department of Revenue that makes claims, especially on APD's time, and so bottom line is that 2 days a month for us as a division to bid on, to spread out as among all those programs is really hard. And so I would like to communicate to the committee that we understand that that is one potential choke point for some of this backlog, and it's already been passed up the food chain, and we're doing everything we can to try and get some more days available with need be. And we should probably know within the next month or two, if not before, whether we're going to have those additional days available. Because typically, Administrative Procedures Division will get to turning over their calendar in October, 1st of October, and then we'll start letting all the divisions and everybody else know what is or might be available around the 1st to mid-November. So hopefully our request will be heeded, and maybe we have some more opportunities to do things in that regard. And as I understand it, this is again subject to a staff meeting next week, but I believe there's going to be some division of the litigation duties as between Mr. Joseph and myself. Some of the more meatier substantive cases, like the ones that we had yesterday, he will probably try those. And in terms of the CPE, PPT cases that were authorized to be heard by an administrative law judge sitting alone without the board, I would probably still be responsible for those. So that's as it stands, as I understand it right now, unless something changes. So.
Just remind us that at the July meeting, because of the hearing agenda, that we basically had almost no time for doing the normal business that the board handles.
I agree, and since we're at the discussion phase at this point, Mr. Bluffus, some sort of middle ground, if the committee and/or full board didn't decide, hey, maybe we should go 6 full meetings a year, maybe even make it 5, because with tax season and the obligations of the profession being what they are, you got the January meeting, and then we typically do what would be the April meeting the first week of May to not conflict with the Music City Marathon. And then if the board were inclined to add an additional meeting at some point in the second half of the year, maybe when the strenuous time demands aren't quite so urgent for the profession overall, that might be something to consider as well.
If that's special, if you did that, could that be targeted just for cases or where we don't have to do our normal business?
Sure.
They could be targeted for.
Yeah, I'd suggest we do something like that.
Which we've had special days.
Yeah.
Would that be?
Yes. I think it's a step in the direction so that when we do have our 4 meetings,
that it's on the business of the board.
We can devote it to the business of the board. That's really what I'm thinking.
It does have budget impact, so I presume that the budget can absorb it if we were to increase it up.
What? The board fees, the $50. $50 we get paid. No, considering $90,000 in the travel budget, I think that should not be a major issue. Can I prolong this?
Yes.
One of the other things that, again, maybe in the annual review process or some other way of oversight, we have information about all the meetings that the executive director and others attend, but we have the information, but we really don't approve it. We don't endorse it, and one suggestion is that I just don't think the Tennessee State Board of Accountancy needs to be represented at every NASBA meeting and every AICPA thing. We don't have to be on every committee. But if we could get some way of determining the priorities of these are the meetings that we need to be represented at, and so that, and again, that this is something that the board has oversight of, so that it's just not the executive director and the staff that's criticized about travel, but we share in that responsibility.
Provide some cover for what we believe is truly necessary travel.
Is the committee requesting like
A travel budget, perhaps? Is that
No, I mean,
with the priority listing?
We have the detail. The question is which one of these are A priority, B priority,
Right.
C priority,
Okay.
and that we.
Can you rank those for us, Mark?
Certainly. Because in your report today, you're asking for approval to go to a NASBA annual meeting, which seems to be appropriate, along with the two investigators. And so, and I would assume that would be on your A priority list.
Yes, sir, it would.
I'm done.
All right, any other issues? None? We adjourn.
Thank you for your indulgence.
To order, this is the Probable Cause Committee of the Tennessee State Board of Accountancy, October 19, 2012. Members of the committee are all present. Chris Whitaker, our staff attorney, will make a presentation to us on his report.
Thank you, Mr. Chairman. The members of the committee should have before you the draft proposed legal report for this board meeting. There are a total of 22 complaints listed on there for the board's consideration. The breakdown of the recommended disposition appears for the new members right underneath the memo to from subject date line. And then, as we discussed yesterday in the new board member orientation, the cases are presented anonymously by case number, and there's a summary of the issues in each complaint, and then a proposed recommendation. These recommendations are mine. They are based on the investigation, if any, my review of the file and any available evidence, and in some cases discussion with the executive director and or investigators. These are recommendations and the committee is not bound by them. And if there are any changes to be made, the committee can make those changes as they see fit. And if there are questions to be asked about any of these complaints, I'm happy to try to answer them as we go as best I can. Typically how we've done it, and Mr. Chairman, we're at your leisure on this, but the committee members will typically take a few minutes to review the report from beginning to end, and kind of write down questions as they go. And then once all the committee members have read the report, it can be opened up for discussion. If there are any item-specific questions, we can address those, and then either take a vote on the report as submitted, or if there are amendments as amended, or whatever the committee's pleasure is. So with that, I'll turn back over to you, Mr. Royce.
Thank you very much, Chris. If each of you would take the report that's in front of you, take a few minutes to review it. We have not previously had an opportunity to see it, so look over it, make your notes, and then we'll try to discuss each one of them. Some of them we could group, and as you go through, you'll notice some of them will be alike. Do we have any Texas cases in this particular batch?
We do. Let me see. I would say there are probably 5 or 6 in there. They are in the recommended letter of warning section, and so we'll come across those as you review the reports. About midway, or a little more than halfway through.
Particularly for the new members on board, we've had an anomaly of an influx of Texas cases based on some law changes they had in Texas where they're starting to inform us that we are handling all together instead of individually. But you'll notice that when you get into them, so if you take a few moments.
And typically, Mr. Chairman, these were mass cattle call administrative revocation hearings for, non-payment of fees for people who, for whatever reason didn't practice in Texas any longer. And, I don't think most of them understood at the time, A, that they had to close their license. And in some cases, depending on how far back it went, there might not have been a mechanism at all for them to close their license. So just something else to consider.
Thank you.
Mr. Chairman, I apologize for interrupting the reading, but the committee will look on item number 6. Let's see, 1, 2, the 4th sentence down, starting with if the respondent. I believe that's a typographical cut and paste error on my part, so that will be deleted, but I wanted to bring it to the committee's attention because it really doesn't make sense with the rest of the recommendation. Mr. Crocker was kind enough to point that out to me, so.
So what's being deleted? If
the respondent, that whole sentence.
Okay. And the failure to do so will stay in there.
The failure to do so. No, I think that probably needs to go too. because I think the first two sentences pretty much cover what's at issue here, and then the recommendation is what is to be recommended to them.
Thank you.
Thank you.
assessment grade.
Okay, I believe everybody has had an opportunity to read through the report, Chris. Take these one at a time, except where I think we can combine them on the Texas cases. Item 1, does anybody have any problems with the recommendation on it?
We don't have that on the iPad, is that correct?
No. No, we just, matter of fact, we just got it.
They just go back to sleep.
You just want to go back to sleep, that'd be fine. Yes, sir.
We only have a formal hearing if the respondent doesn't agree to the consent.
That is correct. It's authority to settle with consent order with voluntary revocation of license.
And the deal yesterday was that the respondent hadn't agreed.
They had opportunity to settle, but did not. So what we're saying here is that this respondent has a felony filing, at least one out there, and has the opportunity to settle. Moving along here, Wilson. Number 2, does anybody have any problems with?
Question.
Yes, sir.
So the recommendation's taken out off of the formal hearing?
No, actually, there is a separate status called litigation monitoring, which comes about when there's a complaint filed before the board, and typically it happens almost immediately if it's going to happen. There is civil litigation that's related to the substance of the complaint is being played out in civil court, and it's a case-by-case determination, and not every case that has civil litigation outstanding goes into lit monitoring, but a good number do, because there's some concern about the due process rights and other legal rights implicated that forcing for example, you force a CPA who's got a complaint with this board in a civil lawsuit to come in here and sign a consent order saying that they committed fraud. How's that going to impact their civil case? My guess is badly. Now, granted, there are cases where we don't go into lit monitoring and we just move forward because the interest of regulation protecting the public supersede that sometimes. But in this case, it was in litigation monitoring, and now the recommendation is that it should not be anymore. Just for a point of clarification, there is another lawsuit out there that's sort of within the relative universe of this, in that the respondent is suing his now former employer, who's mentioned in here, but it's for it's basically an employment contract disagreement. He's saying that, well, you didn't terminate me for cause, so you got to pay me out my stock options. And the employer is saying, no, we terminated you for cause, we don't have to pay you anything. And that's going to trial probably, if not late this year, maybe in January. But I don't, in my opinion, I don't really think any due process rights are implicated there because, for one thing, let's say the trial's in January, the earliest we could even get this respondent in for a formal hearing if we pushed it would be January. So I think it's extremely unlikely that he would even have to come in here before the board if he wanted to before his trial's over on that. But the key piece of litigation that's gone down has already happened, and it's covered in the report.
Why is the recommendation only 3 years for license suspension? I would think the embezzlement would be a pretty big deal. Obviously, it's a big deal.
It is, and it's serious. And again, this is a case-by-case determination, but sometimes you have to give folks at least some sort of carrot to compare to being beaten with a stick. Something to induce them to sign a consent order, agreeing them to discipline, as opposed to coming in here for a formal, which we'll do if need be. I mean, we saw it yesterday, and we did. But that's, you know, again, that's a recommendation, and if the committee and or full board feels that suspension should go up to 4 years, or it should be 5 of revocation, you know, I can certainly change it. But from a practical standpoint, if you're a respondent and you get a consent order and you are thrown the number 10 hammer of doom and get the max plus a giant civil penalty, there is less than no incentive to sign a consent order and settle it, and you'll probably just take your chances before the board and hopefully something better.
Which I'm not arguing at all. Obviously I'm new, but I would take embezzlement to be a pretty serious, obviously the most, you know, pretty much the almost unforgivable offense. And, you know, I guess in my opinion, it would be worth the chance of them saying, well, no, we'll just go for, you know, take the chance with the formal hearings, because, you know, we're protecting the integrity of our licensing for the state. And, you know, I think I would want to send a message to the public that we take, you know, embezzlement and fraud committed by our own licensees very serious. It's almost the maximum penalty there. I mean, that's just my opinion.
And something else that is an option, the board has, the committee and the full board have from time to time elected to make no settlement offer, and to say, you know what, because we think this is so egregious, we are not inclined to settle at all. You just need to come in here for a formal hearing and explain yourself before the board, and best of luck to you. That's happened before, and that's certainly an option here. If the committee and the board don't want to make a settlement offer, then it would just, the recommendation part would just be to refer this matter for a formal hearing at the earliest possible date.
I mean, my personal opinion is, you know, I value the license that I spend a lot of time getting, and I have a lot of clients that, you know, put a lot of trust in the fact that I've got the license. To me, it would almost be you can just commit an embezzlement or fraud against a client, or in that way that there's no settlement. It's the maximum penalty, you know, and that's what we're here for. Again, I'm not arguing with you. I'm just trying to understand. That's just my feelings on that. I mean, I take it pretty serious. You know, the trust the clients put in to me and this, you know, the certificate we have.
Sure. And again, I don't take it as argument, and I never have. If that is intended to be in the form of a motion to amend the recommendation, then we'll take that up with the chairman and maybe vote on it. If not, then we just want to move on and save amendments for later. That works as well.
Chris, let me ask a quick question on
Sure.
this one. I assume you have reviewed the information that's been passed on us as part of this complaint.
Yes.
And in your opinion, is this a strong enough case that's, from the information there, that, I mean, why do we need to offer an hearing?
Well, I'll put it this way. Looking at it from the eye of a formal hearing, and Mr. Roberts may a little bit better understand some of what I'm about to say, because the folks who did the investigative report on which we are relying are out of state, there may be some special evidentiary wrinkles that we have to deal with in a formal hearing. I don't think they're insurmountable, and if we needed to get the report in, I think we probably could. And if we have and it was a CPA, by the way, who prepared this report about the alleged embezzlement. So I put a lot of stock in that. If it were just somebody who didn't know what they were doing or didn't know what they were looking for, just some in-house insurance person who didn't have the expertise, that'd be one thing. But even potentially, we could have the gentleman who did this testify by telephone if he wasn't available to come up here from out of state. So,
But you think it's a strong case?
Don, you want to? I think it's a relatively strong case, and Mr. Mills has been involved with this from the beginning as well, and he might have some thoughts as well.
I think there's enough just the investigative report prepared by the CPA that really lays out item by item. I think there's also some things out on the periphery that I discovered that I have access to that will strengthen the case. So I would feel very comfortable.
Thank you, that's what I was looking for. Stephen, you had mentioned a question about 3 years. I had written down the same question myself, why 3? Is that something you'd like to see bumped to our maximum, just
for standards?
Yeah, obviously, it's almost from an outsider's view. I mean, this is my first meeting, but as I said earlier, I think that, it doesn't by, especially by a practitioner, I mean, it's a big deal. I mean, I don't know that there's really, I mean, I can't come up with a justification where there would ever be something less than the maximum on that. I mean, that's the ultimate.
So is that a recommendation that you want to make, approving the offer, and then the consent order, just like it's spelled out here, but changing that to 5? Is that what I'm hearing you trying to make the?
I'm actually just talking through it because I mean I don't know what if you scratch what's the you take away the settlement offer, what do you think goes to a formal hearing, and what's the I mean
basically your two options here. If you wanted to stay with a consent order in some fashion, I'd probably say civil penalty, and if you're going for the max, then revoke for the max 5 years, and then you have to come back in person if he wants to reapply. If you don't want to make a settlement offer at all, and you just want him to come in here and do a formal hearing and take his chances with the board and see how that turns out, then the consent order language would be removed entirely from the recommendation part, and it would just say remove from litigation monitoring or refer for a formal hearing at the earliest possible date. That would be how that would read. So,
but isn't the consent order just the opportunity to say, hey, I don't want to go through that?
Yes.
And that's all we're adding to it, giving him the option to settle it for 5 years and the $20,000.
Yes.
And I mean, there's no downside to offering that.
Because the 5 years would be the max which you could get at a formal anyway. Okay. And if he's willing to come up off 20 grand and be out of business, because that would also probably put his firm out of business too. Which it's not a large firm. I think it's he and one other CPA, but so if you were willing to sign something like that, then you would get probably, I'd say, 90% of what you would seek to get at a formal anyway, except maybe a higher civil penalty if you went to hearing. So I can do it either way. Up to the committee.
I have one other question before we do that.
Sure.
What was the reason behind the $20,000 figure for the penalty?
Well, up until yesterday, that was I'd say that would have been among the top 3 highest civil penalties that were authorized by this board. And so, to Mr. Eldridge's point about as serious as it gets, I wanted to put in a civil penalty that really reflected that. I make no comments or judgments either way as to whether the board's $110,000 civil penalty from yesterday is the harbinger of a new trend of much higher civil penalties for high-end disciplinary action, or whether it was a one-time thing based on the circumstances the board saw. And again, working as program counsel for the board, I'm here to work for you guys. So if there's some thought that even the 20,000 is too low, then that could be bumped up as well. So
we don't really have the background you do, so typically we get relied for the new people on the investigator and our counsel on setting penalties within parameters.
Are you still comfortable that the 20,000 is stiff enough?
Based on what happened yesterday, I just about have to say probably go at least 25. Mark, your thoughts, your opinion?
I'd stick with the 20.
Stick with the 20? Okay.
I think the 5-year suspension would be the kicker.
I moved it to 3 years to be changed to 5.
Okay, we've got a motion. We'll have second. Second. All in favor? Aye. Opposed, like sign.
I'm assuming that you wanted to say suspended or revoked? There's at least an arguable difference in that if there's a suspension, even though there's no requirement that the board reinstate after 5 years, a smart attorney might argue that there's at least some sort of thought that, hey, it's presumed that at the end of the 5-year suspension, they can come back and get reinstated, whereas revocation, that's as high as you go, and probably the presumption would be that unless they made some sort of affirmative showing why they should get their license back, then they probably wouldn't.
Mr. Bloss, would you like?
I would like to revoke this license as well as the 5 years.
And was the
Resecond.
Second. So, on the restated motion, all in favor say aye.
Aye.
Opposed, like sign. Motion carried. Let me go back so that I don't forget to do it. We agreed that number 1 was all right. We did not vote on it. Let me go ahead and ask for a motion on that.
So,
Second. Second. All in favor say aye.
Aye.
Opposed, like sign. Okay, looking down through 3, is there anything special on it anybody has a question about? What about 4? All right, those 3 are very similar in nature. Can we get a motion on those 3?
Motion.
Motion for approval in the second. All in favor, say aye.
Aye.
Opposed, like sign. And number 6 is a little bit different. Mark, do you need to speak to this one? I mean, Chris, is there anything special on that one?
No, it's pretty straightforward.
Okay.
Guy went to a jury trial, multiple felonies for theft, and, the sentence is what it says, and I don't know if he's out of prison yet, but the fact that he's already signed something for the revocation of his Georgia license,
Okay.
pretty serious, so, and the only thing I put in there was if he wanted to do something here like he did in Georgia, which is sign off without us having to do the hearing, if he agrees to be revoked, then we'd let him do that. And since he's in prison, he ain't gonna have any money anyway.
Okay. 7. All right, let's handle those 2 together if we can. 6 and 7. I have a motion for approval as presented.
Second.
Second over here. All in favor, say aye.
assuming on the 6, we strike out that, I guess we strike out that motion.
Yes,
Yes, sir.
with the striking the typo.
Right, striking the typo out. Okay, now 8 through 12, and 17 are Texas-related cases. Do I have a motion to approve those?
So moved.
Second. I have a motion and a second over here. All in favor say aye.
Aye.
Opposed, like sign. Okay, what about 13? All right, anybody with 14? 15? And 16? We've already approved 17. What about 18? 19? 20? Hearing none, I entertain a motion for approval of that one. Have a motion here.
Second.
Second. Well, you guys are helping out over there. All in favor say aye.
Aye.
Opposed, like sign.
That was part of orientation.
Yeah.
You said nod your head.
Yeah, nod your head a lot. Okay, 21 and 22 are together. Would you like to speak to this one? I, like some of the others mentioned, they've read it 2 or 3
I
times.
read it 3 times, so, I need some.
Why don't you explain the rationale behind it?
All right. It's a matter of a CPA and the name firm where that CPA is a partner. A couple years ago, they had an employee who was not a licensee, but somebody I would say pretty much had run of the office when it came in terms of handling client paperwork and things like that. And I'm using the words of the respondent counsel here, said that she basically for about 9 months before the end of her employment, this employee wigged out because her husband was dying of cancer, and she really started acting in a manner that she hadn't acted in her previous 5 years of employment in various ways, including the ones I mentioned. Not doing certain paperwork, making up other paperwork, shredding documents, really, really not great stuff. And the deal was, her having been at that firm for 5 years, she's pretty skilled at coming up with these documents to make them look, the ones that had to be signed by this partner, the CPA in that question, that they look like they should look. I mean, even down to IRS tax deposit numbers that really look the way they should. And if you do this every day, day in, day out, there probably wouldn't have much reason to question it. Well, toward the end of this, the year in question, this lady's husband is in his last throes of cancer, so she takes a leave of absence. The firm brings in somebody to replace this woman immediately when she notices the discrepancies and starts to put 2 and 2 together and takes it to the CPA, and his first reaction is, oh crap, we have a problem. And so his first call is to the client who was affected, who were eventually the complainants. The complainants are 2 individuals in their professional company. So when I say client, I mean the 2 guys in their company. From the get-go, they understood that because tax returns weren't filed for them for about 3 quarters, that there were going to be some IRS problems, taxes, penalties, interest, and what have you. They said, look, we're going to make this right. We will, we'll go with you to the IRS. We'll try and work it out best we can. And whatever bill they send you, just send it to us and we'll write a check. And that was before any lawyers were involved or anything else. That kind of got batted around for a little while, but eventually the clients retained an attorney and they went and filed a lawsuit. And, at the time, as I stated in here, at the time the board looked at this the first go around, pretty much all we had in front of us was the complaint. And if you go, under the old saying, anybody can file a lawsuit, anybody can. And you say kind of what you want in there as long as it's not proven false. But if the allegations in the lawsuit had ultimately been proven true at trial, I think this would look a lot different. Because when you're alleging fraud, embezzlement, mismanagement of funds, Tennessee Consumer Protection Act violations, if the complainants had been able to prove up all that at trial, I think we'd probably be pretty close to the case where we were on number 2 just now. But the great thing about our legal system is the truth usually comes out in the wash, if not always. All of the most severe allegations against both the CPA and the firm were tossed. No punitive damages awarded, compensatory damages, and a little bit for emotional suffering. That was the jury's call. Fine. And so we had some discussions subsequent to that with the Respondents Council, and both the attorney's concern and the named partner here concern is, look, and again, under the nature of settlement discussions, so understand if they came in here before a formal hearing, they probably wouldn't start out admitting anything, so as not to prejudice themselves, but they told us, look, we even told the other side and our former clients now that there was some level of negligence on our part, because the bottom line, buck stops with us, we're professionals. They trusted us to handle their business, and this happened, and so that is what it is. But I say we also have other CPAs that work for us, other non-licensee folks that work for us for years to think about, and that didn't have anything to do with this. They're not the ones that signed off on this lady's paperwork and caused our clients problems. And so basically what was communicated to us is if the board were amenable to some sort of resolution where the named partner would essentially fall on his sword and take the hit for himself, because this woman he directly supervised her, and so he feels more responsible than anyone for kind of how this happened. He's like, look, if I can take this on me and it's not going to kill me personally or financially, then I'll probably do it. That's up to the board, but so after that, Mark and I and Don had some discussions and kind of came up with what we came up with. In any given case, if we go to formal, there's downside risk for both sides. The big problem for this CPA and his firm is the if they come in here and the board even finds 1% responsibility that this goes to the firm, then every time they apply for state or federal work, they've got to note that on the application. And for at least 3 years, that probably means no government work for them, which would cause them about a 40% hit in their business, laying off employees, including some of your fellow professionals who didn't have anything to do with this. And so I think that's why they kind of approached this the way they did. And I don't know, like I said, if it were a matter of the serious things we were talking about in number 2, we wouldn't have come up with what we came up with, but just looking at the totality of the circumstances, that's kind of where Mark and I came down. And if there's something I haven't covered or that you have additional questions about, I'm happy to try and answer it as best I can. But, you know, yes, there's a regulation component too, but I think there's also got to be some kind of mercy and leniency and understanding for people who, when something does go bad and sideways, they try to do the right thing and try to make it right as best they can, because they can't turn back the clock and fix what happened. But they can fix how they deal with it going forward and how they address the situation to get it resolved. So,
you looked at all the records I seen from the court hearings and lawsuits, et cetera, and our own internal investigations. Is that?
We got a, basically what I had was a complaint and the jury verdict form, which came back. You know, all of the ins and outs of the pretrial stuff, A, I didn't have access to it, and B, in this case, I didn't really feel it was as relevant as maybe it would be if we were dealing more in the fraud and embezzlement theft range, because I put more than a little bit of stock in the fact that the judge and the jury who looked at this, who heard this civil case, who saw, you know, hundreds of pages and hours of testimony that we never saw and never will see, could not and did not find any intentional conduct on the part of the CPA or his firm. And the only way they got to assess damages against the firm, and again, Mr. Roberts will know about this, but the doctrine of respondeat superior, meaning the employer is liable for the actions of the employee, more or less. So they're saying, okay, you know, the employee did wrong, and from a practical standpoint, this lady doesn't have any money, so if they were going to assess, if the jury or the judge is going to assess damages, yeah, they could assess a worthless judgment against this lady, and they did, but to make sure that these folks actually get the money that the jury awarded them, I think the firm's probably going to end up writing a check.
So I guess my confusion on it is, while we're looking for revocation, when this is an employee that's falsified even the documents that have make them look proper, as you mentioned earlier, instead of, you know, something less like a suspension or you know, reprimand, whatever you want to call it, where, you know, we recognize there was something wrong with your firm, but you did exactly what you're supposed to. You called it, you turned it in, and you brought it to their attention.
No, and that's a good question. The recommendation part, it starts with formal hearing for revocation of license. That's standard form language that I use any time that I want to say, okay, we are referring this for a formal hearing, because the maximum punishment in a formal hearing includes revocation. So if I just, you know, said plain old formal hearing, or I didn't say formal hearing at all, then there would be an argument to be made, hey, look, the board didn't authorize a formal hearing in this matter. They authorized a settlement order, but nothing else. So
so that's required language, even though we're just looking at probation.
Yes, as I've understood it, and it's been communicated to me by my bosses, that has to be in there when we're going to put formal hearing language on the legal report. Now, the specific recommendation for this case is in the numbered line items 1, 2, 3, and 4. And yeah, I'm sure you guys have read it, but if accepted, and for the information of the committee, I got an email from counsel for these respondents this morning saying, look, you know, I just got your settlement offer yesterday. I've talked to my client about it this morning. He's talked to his partners and get back to me. I think it probably will be settled, but I did communicate to them, look, if the board approves the settlement offer along the lines of what we've talked about, it is a take it or leave it proposition. And that's the best there is, and that's the best you'll get. So, you can either take it or don't. But if the board approves it, I'm willing to go with it. But if your guy says, no, it's too much, then just take the chances. So, basically what he would have to do, the CPA, is 16 penalty hours of CP, doesn't count against his regular 80, relative to practice management, try to help him maybe make sure this doesn't happen again with a future employee. He's got to do that and provide his proof within 90 days after he signs a consent order. The CPA's license, he gets 2 years probation, and we came up with the 2 years because that was the amount of time, when you add the amount of time that the employee's course of conduct went on plus the time that it took the legal process to run its course, that was almost 2 years. So that's how we came up with that.
Is that public or private, the probation?
And it'll be public because...
Does that have impact on state contract?
For the firm, no, because the discipline that I've outlined here, and I'll get to number 4 in a minute of the line items, but none of this will be imposed against the firm's permit. And it is the firm itself which bids on the contract. So, it's not respondent CPA individual bidding on these contracts. It's respondent CPA firm that bids on these contracts. So when they go to answer that question in the last 3 or 5 years or how many years it is, has this firm ever been disciplined by any regulatory authority, they can truthfully answer no to that question because if this settlement went through, they have not.
So I have a question. In the lawsuit, where the jury award was given, was the firm named defendant in the lawsuit?
It was.
So it sounds like from reading this and hearing you talk, the reason why you're willing or recommending forego action on the firm was based on firm interpretation in this individual's willingness to take the fall for it.
In some part, yes.
If that wasn't the case, and there was no negative on the firm, would you still recommend a forego action against the firm?
I don't know that I would take it off the table, but what I would say is that the firm as a whole is probably a couple of degrees of separation removed from the actual wrongdoing that took place that caused the client's harm, if that makes any sense. I mean, yes, this respondent is a named partner, and he bears responsibility and some, level of clout, if you will, I don't know the right word, but within the firm, so as a representative of the firm. But, just in terms of, would the firm walk if this guy wasn't willing to take it all on himself? Probably not.
And also, if it wasn't for the idea that they're reported doing government work, and thereby potentially having to decrease their number of CPAs they're employed. I'd be lying to you if I said that wasn't a major consideration. And I try to come at it from this perspective, and the board is free to approach things this way or not. But when I came to work for the government, I told myself, look, any decision that I make, and by extension my clients make, doesn't happen in a vacuum and has real-world consequences for people's lives. And we've always got to be mindful of that. And to the extent that happens, in a case like this, when nobody, even the court and jury who saw this case, thinks that there's intentional misconduct or malfeasance involved, I just have a real hard time getting from there to, okay, let's do something that makes a bunch of people who went to school and did the right thing and have their licenses in good standing and do what this board requires, have them lose their job. I just have a problem with that. And if, that's me personally. I'm speaking for no one else. But I think this is my last question. Do you know if there's any, it's maybe outside the scope of this recommendation, but do you know that if there's a similar negative impact on the innocent individuals that are employed by the firm because the firm will have to report that they were a named defendant in a lawsuit in which a jury award was awarded against them?
other than potentially losing their jobs, probably not, because
But that's not a reportable event when they apply for government work?
when the individuals,
No, when the firm applies for government work, are they going to have to say?
are they gonna have to report the lawsuit?
Well, it
Yeah.
depends on the government that's soliciting a bid for work.
Yeah, there's typically a separate question, if there's going to be a question about, you know, if you've been an adverse named party in a lawsuit, have you paid out any judgments, whatever.
Okay.
So that is typically a separate question. They're usually not combined, and sometimes there's not even a lawsuit question on there, but sometimes there is. And that, to me, is, I don't want to say, not our problem is not what I mean, but that is outside the scope of this board's authority and ambit, because it's nothing you can do anything about. They had this firm, this partner, they had their day in court, and they got what they got. They had great counsel who represented them very well, and you know, even though it was much less serious than it could have been, there still was some finding. You know, whatever the fallout is from that, they will have to deal with that, but that is whatever they have to do. And I just think that for the firm purposes, for the reasons I stated, that it just seems a little bit like piling on. If it goes this way. Now, all bets are off. You know, if I take this settlement offer to their counsel and he says, no, I just can't do it, then the board will have to decide at a formal, based on all the evidence they see at that time, whether the firm itself bears any responsibility, and if so, what proportion, and if so, what discipline. But that's down the road.
I would say, as much as we'd like to be able to check a box on every single hearing we have that says this case is exactly like the other case, it's like the other, what I've learned over the past year is that every single case has its own unique circumstances and facts, and ultimately we get to decide kind of where those penalty functions fall, but very unique cases for sure.
Question I have,
Go ahead.
question I had was, if I'm understanding this correctly, the practitioner was basically, lack of better terms, conned into following suit by his employees. She went to great lengths to disguise the document, the fraudulent document. And kind of what I said, you know, earlier on previous cases, you know, we value fraud against, you know, committed by practitioners, but this practitioner did commit fraud. He was conned into, or, you know, tricked into doing it. He may have had some negligence, I guess, but, you know, I'm looking at, you know, just my own practice is, you know, how would I be able to prevent against someone, you know, putting a fake document in front of me that's looks like the real thing.
And it looks like it should.
Right. Forget that I trust the person or not, but I mean, I'm looking at it and say that looks right, and I sign it. Then I'm going to be held account. You know, then I'm going to be penalized, and you know, I don't have a problem with probation. You know, and I don't have a problem with the CPE and everything else, but you know, does it warrant a $15,000 fine in comparison to the previous case we talked about? That actually the practitioner knowingly committed a fraud and are embezzling money, and it's a $20,000 fine. I mean, I guess I don't. While there's some wrongdoing in this and some negligence, I don't know that it's the practitioner didn't knowingly, you know, commit an offense. I'm questioning whether or not that's too high of a fine or not. I'm not making a recommendation. I just kind of want to throw that out for discussion.
Well, it's a fair point, and part of the consideration for the $15,000 was, you know, okay, well, if you take into account everything that was ultimately awarded by the jury, keeping in mind that it's a little bit different set of facts and circumstances, and the litigation's for a little bit different purpose. This $15,000 is somewhere in the neighborhood of 10% of the jury verdict award. But you know, if you guys are saying, well, you know, $20,000 for number 2 with the intentional fraud and conduct, maybe we think it should be a little lower. Then maybe the fallback, you know, should be 10, because that, you know, if you're going down the food chain of seriousness from embezzlement to fraud to simple negligence, not even gross negligence, and you say, okay, possibly maybe half as bad. I mean, it's still something, and it's worthy of some sort of sanction, but certainly not as much as, you know, the 20 grand from earlier.
Yeah. I mean,
you know, it does put, you know, like I said, you know, we try to learn from every situation we hear about, but I mean, it puts fear in me that, you know, if someone doctors up a document and, you know, I'm doing my best to see if it's valid, I mean, then I get conned into thinking it's the right thing. Next thing you know, you know, it's a big concern. I mean, I think it's, you know, negligence should be punished, but I don't think it should be just, you know, there should be some mercy granted, I guess, for, you know, the cooperation that was involved. You know, we admitted we made a mistake, and let's fix the problem, as opposed to going to great lengths to cover it up, and, you know, which didn't happen. You know, so I mean, I think there should be some mercy, in my opinion, because.
Yeah. Mr. Mills, did you? Sorry. I want to ask Mr. Mills here if you looked at the documents as well.
I did.
What do you?
I don't agree with the fourth recommendation. I'm sorry. I think the board should consider some sort of action against the firm, not because of gross misconduct, gross negligence, anything else. There's just, this was not an isolated incident. From my review, of working papers and documents that I obtained, I think that the firm had a responsibility, and I've got several notices in here of where our law and rules, where the Code of Professional Conduct says, you know, you have to be responsible for your people. Now, I realize there was some fraud perpetrated within a non-employee. However, in my opinion, the lack of internal controls and supervision, which we attribute in our Code of Professional Conduct, were not met. I don't mean that this firm needs to be put out in past. I don't mean anything like that. These guys tried to do a good job, but they failed in internal control. They also failed in some of the documents that we talked about. When you have an alternative to a forged document and you did not take that, I think there's probably a reason for changing the way you do business within the firm. And I feel that the board's responsibility to the public is greater than that responsibility to the firm at this point.
Explain, what do you mean alternative to the forged document? I may not be understanding all the facts correctly.
I don't know how specific I can be, but I
Just try and get your point across while not going into
Not
it.
saying
Nothing to kill us all.
Okay, I'll try to give you an example. Let's say that one of your associates brings you a report, say of payroll tax deposits that were made, okay? And they have, you've remitted them to the IRS, and you've got the control numbers and everything, okay? Let's say that one of your controls could be that you simply go online to the IRS and verify that deposit was made, okay? Now, you're doing, let's say, 3 deposits a month, and at the end of the month, the 941 appears on your desk for signature. Why wouldn't you look at the IRS to see if those deposits were made as a checkup, as a backup? You know, I don't know.
But how many payroll returns do you do a year?
I guess.
Before I left my office coming down here, I reviewed probably 25 payroll returns. That, you know, I'd still be sitting at my desk checking, you know, along that line, checking deposits. That's why I have trusted people. And I think each one of us would share that we have people we rely on, that if they say they did it, here's the numbers, then that's.
Well, that's my point. When I was in practice, we didn't even have that as a backup. You know, you just had to do it. And so I guess as practitioners, I'm asking, do you feel that they need to clean up their act?
That was a due standard of care. And, you know, I mean, I agree with what y'all are saying. I think we have people that work where the world is controlled by 25-year-olds in our industry. So you have to depend on the new people, the mid-level people and your managers to do that work. And if that person was the one that breached the trust,
again, I think there's always a set of facts and circumstances that are different. Without hearing the exact details of the case, I don't know how we can make that
And don't get me wrong, this is not
determination.
egregious. This is not anything near what we're used to hearing. But it happened. You know, I just feel that the board needs to know, you know, we do have law and rules that say you have to be responsible for your people. And I know we've all trusted people in the past. You know, I think the very form of our practice is requiring that.
So based on what I was saying earlier, is that a different, you know, my point was, you know, somebody comes in and if I'm following my normal procedures and someone's gone to great lengths to you know, forge a document that looks exactly like the real one should, but it's a fraudulent document, was it more than that? More than just I got conned by a false document, or was it I was being just signing a will and being negligent in my procedures?
It's impossible for me to tell really their intent. I mean, there are all kinds of circumstances in this case. They're all small, you know. I guess to me, as, you know, could you evaluate as practitioners and say this was out of line, this was not?
But I think a bigger question in all of this is, will the firm learn from this? And I think ultimately they will, based on these, whatever you're proposing. I mean,
And something else to consider, and I did put this in here, CPA in question, 30-plus years practitioner, not a single complaint of any kind. The firm, however long it's been in practice, nothing for them either. And this CPA felt bad enough about this that he went to his firm and said, I will resign, step down and not be a partner anymore if you want me to, and they wouldn't take his resignation. And that means something, or it should. So,
Okay. Thank you, then.
One last question. Well, just going back to Stephen's earlier question about the $15,000, was there any consideration when coming up with that to the fact that that was the price we paid in order to get the firm kind of off the hook, so to speak? Or was it just merely based on the facts and circumstances against this one person, we think $15,000 is enough?
I would say that if there was an apportionment of responsibility here, the vast majority of it would probably go to the individual practitioner here anyway. But maybe not all of it, maybe for the reasons that Don said. But I think that is something that would probably only come out at a formal hearing, to be honest with you. And if we were splitting it up as amongst the firm, if the firm was to be assessed anything, it would be way smaller number. So, but I think 15,000 probably, and Mark, if I'm wrong, say so, takes into account what we believe is the full amount of total global responsibility. It just so happens that this practitioner is willing to take it on. Now, that's not saying that that's the right number, and based on this presentation and the questions you've asked and had answered, if that's what you have to go with, if you think it ought to be something different, then by all means say so, make a motion, and we'll vote it out and I'll change it.
Thank you. Anything else? Do we have any recommendations from any of the committee members on what we need to take to the board on the recommendation, either financial penalty or discipline? We're looking at 2-year probation, which, you know, sets the message out there was a problem. Penalty phase.
I move approval of the recommendation.
As presented.
As presented.
Do I have a second for that?
Or an alternative motion.
Died for lack of a second. We have a measure.
I'm torn, I guess, on the, I mean,
Whatever we do is going to the full board.
Right, I agree.
Since they're all sitting here, then.
They want to talk about it. Time out.
we want to get to the board meeting.
I don't have a problem. I would make a motion that we accept it as is, with the exception of changing the penalty from $15,000 to $10,000.
Second.
I have a second on that. Any discussion? All in favor say aye.
Aye.
Opposed, like sign. Motion carries as presented, reducing the penalty to $10,000. I think that concludes the committee report.
adjourned and play musical chairs.
Y'all need a break?
Worn out.
Are we live? This will start the actual board meeting today. If everybody would please review the minutes. Hopefully everybody's had a chance to look at them. There will be the previous meeting and the teleconference meeting, I believe, as well. And I'll entertain a motion as soon as y'all have a chance to review those.
Passed out earlier.
Yes. They were emailed.
No, I read. I move for approval.
I second that motion, sir.
Are we talking about both meetings?
Both meetings.
Both meetings, okay. So I have a proper motion and a proper second.
Chairman, some of the new members, we weren't here at the last meeting.
Right. It'd be hard for you to approve that. How do we handle that?
Can you split
He
these
just
into two
recuse
different
himself
votes?
from
You want to recuse yourself from voting?
Or you just abstain from voting.
On the first set of minutes.
Well, I think we're going to make them into two because y'all were there for the teleconference. So
Yeah, if
Yeah,
he's going to
I'll
vote
amend my
for the
motion
to the
teleconference.
first meeting.
Correct.
Okay. Okay, so I got a proper motion, proper second. Is there any discussion? Should we roll call that just for the ones that want to recuse or abstain, whatever? Okay. Mr. Roberts?
Abstain?
Abstain. Mr. Eldridge? Abstain. Approve?
Yes.
Yes. Yes for Watkins?
Yes.
Yes.
Sorry.
Yes.
Yes, Royston.
Abstain.
Abstain.
Okay, so I mean, did I get 4 abstains? Or okay. Motion passes. So, do I have a motion on the teleconference?
I move that as well.
Okay.
Second.
Probably second. Any discussion? Hearing no discussion, all those in favor signify by saying aye. Aye. Any nays? Hearing none. Motion passes. Executive Director's report.
Well, I really don't have anything to add unless you all have any questions.
We've been together a lot today.
Yeah. I would like to point out the proposed future meeting dates. Please look at those, make sure that you're in agreement with those. I'd also point out that I have been asked to serve on the AICPA State Board Committee, which is a subcommittee of the Board of Examiners. I have accepted that position pending this board's approval. The AICPA does reimburse for all travel expenses associated with their committee meetings. So that's an expense they bear, not this board.
Do we need to make a motion to that effect now?
If you would, I'd appreciate it.
Do I hear any motion?
So moved.
Second.
And an approval, or a motion and a second. Any discussion? Hearing none. All those in favor signify by saying aye. Aye. Any noes? Hearing none, motion passes.
Thank you. Unless there are other questions, Mr.
That's
Watkins.
it?
Yeah.
Okay, sorry, let me go back to my agenda here.
Just thinking about that, is there anything we need to talk about regarding that Edward Osborne deal or that's what we need to do before? Sure.
As well, some of you that are not new members know, we had a formal hearing a little while ago, back in July, I believe, for a CPA by the name of Edwin Osborne. Formal hearing, his license and firm permit were revoked for essentially serial noncompliance with licensure and CPA requirements, and also for practicing on an expired and or invalid permit and CPA license. As you may also know, there are certain appeal time periods of court decisions. Some of them are much shorter in nature and are appeals directly to this board. You know, motion for stay, motion for reconsideration. Those are typically filed, 7 to 14 days after the board's meeting where they make the decision. That did not happen in this case. However, there is also a right of appeal to Chancery Court or to request modification, reversal, or vacation, which is completely throwing out the board's decision. And that has to be done within 60 days of the formal hearing date. Mr. Osborne filed his appeal with Chancery Court on day 59. So it is timely. He filed pro se, didn't retain counsel to file, and I received a copy of that lawsuit the same day, I believe. And having never seen this particular set of facts and circumstances before, I talked to my supervisors, and we forwarded it to the Attorney General's office, who will ultimately be litigating this matter when it comes to it. There's a little bit of an expedited time frame for some of this stuff where it's probably going to get handled faster than your average civil case. But bottom line is, Mr. Osborne is requesting that his revocations be reversed and that the civil penalty not have to be paid. Good luck to him explaining on what grounds, but that's between him and anybody he might have to represent him. But what my responsibility is at this point, I have to prepare what's called the administrative record, which is a fancy way of saying I've got to get the transcript of the hearing and a copy of APD's file over to the Attorney General's office within 45 days. And once I get that to him, that's probably going to be the last of my involvement and or the board's involvement. About the only way we would see it again, and by we I mean board, is if the Chancellor somehow remanded for additional consideration. It has happened from time to time where Chancellor will say, okay, well, this is my opinion, and I remand to the board for them to reconsider in light of this, and maybe have to do something different, or maybe part of it gets tossed. It really depends on the ruling, so that's kind of where we are. No additional action of any kind is required at this time, and myself and my superiors are doing what we need to do to make sure that the AG's office has what they need to have in order to defend the board's decision in the court.
All that to say nothing. All right, Mark, do you want to introduce the folks from that?
Certainly. We have with us Brittany Henderson King and John Fields from NASBA. They are going to talk to us about NASBA's International Evaluation Services. Currently, we do not accept NASBA's International Evaluation Services in regard to evaluating foreign transcripts. And what we're asking is, after their presentation, if you all would consider adding them to our list of approved providers.
Good afternoon. We don't want to take up too much of your time by setting up our laptop and getting our presentation out, so we thought it'd be better just to provide you all with a copy. If you have any questions, I'm happy to answer them for you.
Thank you, John. You're not as fast as she is.
So we're going to flash it up on the wall for you.
Really quick, I just wanted to touch on the background of the industry. I don't know if you're really that familiar with international education evaluation, but prior to the 1970s, this was actually a service offered by our U.S. government. In the early 1970s, for whatever reason, they decided they didn't really want to do this anymore. So they reached out to the private sector and kind of upsprung the industry. So what you have are really international admissions professionals who started these credential evaluation agencies. They've traveled across the globe, they've done their research, they've done publications that help us today to determine who wants to get the international degrees. So you also have two organizations that a lot of your companies are members of. the National Association for Professional Evaluation Services, and the Academic Credential. Yeah, ICNL. I'm sorry. I never remember the last two. So basically, I think you have 7 providers right now that you accept, and both are either members of NACES or members of ICNL. In the beginning, or I don't know if it was how long ago, but a lot of the boards started to reach out to NASA and say, hey, why aren't you providing a service for us? You did the CPA examination services. We'd like your input on the international education evaluation. So due to the board's interest, we started doing that for you. Myself, I've had about 4 years experience almost. I started out doing this for international initiative with the graduate and undergraduate level, and I've actually been trained by NACES members as well. So we have the international education experience, and then we have the accounting experience on our team. We actually have former state board coordinators who are working and who are trained evaluators, and we process the CPA examination services applications within our NASA International Evaluation Services team. So not only do we evaluate your credentials, we process the CPA examination. There's been a lot of growth and some uncertainty within some of the jurisdictions. I know there's been a lot of rule changes for some of the states. So it's really our job to keep up to date on those and to work with the state boards to provide this service. Your typical Tennessee candidate who has international education, I think you're seeing an average about 2 to 3 per month, which is what we would see because you have really high expectations for your candidates. You have the 150 you said, the 30 in accounting or 24 upper division, and then maybe 24 in business with 12 upper. Yeah. So, it's our job to stay up to date on things like that. Your typical candidate who's going through your other seven evaluation services, it's going to take them about 4 to 8 weeks at best to get through this entire process. So first they have to reach out to the education provider. They have to send in all of their documentation. And if you actually look on their website, it's going to take them at least 4 weeks to get this process completed. Now that's because they're not only focused on professional license and examination, they're doing evaluations for undergraduate and graduate admissions, immigration, several different industries. So they are big companies, but it does take them a little bit longer to process their apps. So the candidate finally gets their report, then they have to send it into NASA. The evaluation company will also send in the report, but sometimes the candidates like to wait a little while. They have to go through the resource provider, get up to date on the education that they're missing. Then they have to go to domestic university to take another course, like an auditing or policy management. So the whole beginning to end process can take 4 to 8 weeks. With our service, we only do evaluations for the accounting boards. So we can get your education evaluation completed in less than 5 business days once we receive all of your documentation. So after we do that, we usually have a CPA app on file. We go ahead and process that application as well. And students find that they can get their NCS issued in less than 2 weeks. That really cuts down on the processing time of the candidates. Not only that, but we work with the boards. We customize our evaluation reports according to your needs. We work with the boards to get more information on their international education standards. Some of your boards accept course work from chartered accountants, some others do not. So it's our job to work with you to find out your standards, your policies, your regulations, so that we can create our customized report and do our evaluations according to your rules. We have 18 hours of call center support through our staff in Guam. So that's about 6 days a week. Candidates can reach out to us. Well, I'm trying to. I don't want to take up too much of your time. I know you all have a very busy agenda today. So.
I think my job here was, from the business side of matters, you heard a lot of points that Brittany touched on, was the commitment that management put into this. So obviously we went out and got one of the experts in the field by hiring Brittany Anderson King from one of the larger universities in the great state of Kentucky, and with her experience that she has in doing specifically financial evaluation in education. So NASA has put in the investment, if you will, to this business quite extensive, and some of the materials in there are kind of hard to get. So from a global perspective on the educational system that we have to deal with, we have to kind of put that together. In addition to that, we'll provide support for the technology infrastructure, the online application that's required for these candidates to be able to go in from wherever they are in the world, easily from any computer, go in, fill out their application, attach documents, do that kind of servicing and pay to us as an education provider. So it's kind of a homegrown business. I didn't do an introduction, by the way. My name is John Fields. I'm the director of the Master Project Management Office. And my involvement with that was from the beginning helping build a business plan for NASA to eventually build a business that we could launch to the state board and based on a lot of the requirements we had heard over the years in helping provide consistency to the accountancy profession, specifically with our expertise, just because of, as I mentioned, some of the differences in opinions, if you will, on the way this education is evaluated in our country. So one firm may have an opinion on that education equals as far as U.S. equivalency. In some cases, we know this happened. If they didn't like the answer, they've gone to another firm and received a different answer. So we're thinking we can help bring consistency to the industry, some fairness to the candidates, and certainly some security support to our servicing. We believe it's pretty important work. It is one of the huge strategic initiatives this year. I think those management meetings will hear the bishop and the senior executives talk about this as a long-needed service that's been asked by the state board for NASA to provide, and now we're at the point where we're trying to do that and hopefully
And we do take a more of a conservative approach in our evaluations. We require all the accounting and business courses, their subscription and their evaluating coursework. Some of your companies will say that a 3-year MBA degree is equal to a 4-year degree here in the U.S., while others take a more conservative approach to you and say that the 3 years is equal to 3 years of undergraduate study. Unless you come from a 13-year secondary system or you have a 1-year master's degree, something else where we can compare that to truly 4 years of study here in the U.S. and you have issues like that. But if you're interested in implementing this and using our service, it takes us about 5 business days to get you on board, and we ask that you work with us during that time. So if you don't like the evaluation format, if you'd like to see grades on there or a category breakdown of the courses, we're happy to provide that for you. If you'd like, you're more than welcome to come by our office at any time. I'd love to show you around, answer any questions that you might have. If you just want some information from us, regardless of whether or not you use our service, we're always here to answer your questions and provide you any information you need.
What's your service cost?
It's $200 to the candidate. That includes an evaluation, the course-by-course breakdown, it's a U.S. degree equivalency, you send a report to the board. So the report stays with the CPACE file, along with a copy of all of their transcripts and documentation that they've submitted. It's relatively in the ballpark of the other services. We have some that are as low as $185 and some that go up to $360. And that's for a good 4-week turnaround. We do everything in less than 5 business days. We don't offer expedited services because we need to take our time to do our own research to be sure that we have the right answer.
So the candidates choose whether or not they want to use you or not. We
Yes,
just provide you as
it's
a
up to the
preferred
candidate.
vendor.
Yeah. Anything else?
Thank you.
Thank you.
We appreciate your time.
Appreciate it.
Okay, moving on.
Mr. Chairman, if we
Yes.
could, if we could have a motion to accept the NASBA International Evaluation Services as one of our
I'd like to
providers.
make that motion, please.
I'll second that motion. Motion's made, properly seconded. Any conversation?
Yes, could you just explain to me again how this works? The candidate actually picks up the cost of this?
Yes, the candidate, yes.
What you're asking here is just to recognize them per
As one of our vendors. Yes, sir. As an option.
Any more comments? Okay, all those in favor signify by saying aye. Aye. Any nays? Hearing none, the motion passes. Thank you. Jennifer, do you have anything on the NASDAQ committee report?
Quick, I don't think Mark gave an update at the July meeting. I wasn't here. Just really quickly, the committee had a face-to-face meeting in May. It was at the Dallas airport. I wasn't approved for travel, but I did participate by conference call. It was a good meeting. The NASDAQ president, Kim Bishop, attended, Vice President Ed Barnicott attended, and the Executive Vice President and CEO, Colleen Conrad, they all attended. So it was a good and lively committee meeting. Basically, to remind you where we were, the committee had sent out a survey to all boards, trying to figure out characteristics of state boards. And one of the subcommittees of the committee right now, they compiled all the information. We received responses from 41 state boards. And they compiled those characteristics. I think they made reports at the 2012 Executive Directors meeting and also at the 2 regional NASDAQ meetings that happened this summer. They gave a summary of what those survey results were. And now that subcommittee is analyzing the data. And basically what they're doing is they're distinguishing the data that was provided by the consolidated agency boards and then those unconsolidated agency boards. So trying to see where the data came from, and then they are classifying the data to get some distinguishing measures. And I think the way they're trying to is breaking it down into the measures that are for administrative efficiencies and the measures that show effectiveness in protecting the public from harm. And kind of where they're going with this is they're trying to put together the committee as a toolkit. And this is a toolkit that will help state boards in becoming more effective and relevant. And they're using all this data to try to get what needs to be part of that toolkit. Since May, I've participated in a couple of subcommittee conference calls, and what the subcommittee that I've been working on, what we did was put together a paper that summarizes the duties and responsibilities that make state boards effective. We actually put together a draft that was presented in July to the full committee, then they approved that. It's still internal, so I can't present it yet, but the committee is working on making that final and putting that together with this toolkit to try to help state boards, in their analysis, figure out how to be effective and relevant and all of that good stuff. I found out I was reappointed to that committee for this year, and the committee actually has changed, the name's changing. It's going to be Board Effectiveness and Legislative Support Committee. I think that Mr. Johnson, the legislative,
Carlos Johnson?
No, not Carlos Johnson, but they hired, NASDAQ hired.
John
Johnson.
John Johnson.
John Johnson, they hired him, and he's focusing on, he's in charge of legislatures, helping boards deal effectively with legislatures. I don't have his right title, but he basically will be working with this committee going forward. So that's all in my report.
Moving into the board committees, licensing.
We had a good meeting today. We had 2 items that we have recommendations for the board. The first item, Landon Lawrence, he's appealing the voiding of a successful exam score relative to the 200-day rule. Basically, under TCA 62-1-106C1, it allows the candidate to begin sitting for the exam and complete their 150-hour education requirement within 200 days of beginning to sit for the CPA exam. This candidate began sitting for the exam. He hadn't finished his education requirement, and he took 2 portions of the exam and didn't finish his education within the 200 days. He's slated to finish within 54 days of that time period. And basically, the committee considered the information that was presented before us. It was choice of wanting to do a study abroad and the classes that he wanted to take as to why he didn't fall in that 200 days. And the statute allows the board to give exception under good cause. And the committee decided that this choice, this decision to study abroad and miss the 200 deadline was not good cause. It was more discretionary than good cause. And it's making a recommendation that we not grant this exception to the 200-day rule. That was one item. You want me to present each item?
You could just present them all.
Together? Okay. The second item was the University of Tennessee Municipal Technical Advisory Service, MTAS. They are asking, they have exams that they require the municipality's chief financial officers in certain circumstances have to take. There are 11 exams. And they're asking that under Rule 0020-5-.048 that they get CPE credit for successfully completing these exams. It would be 5 hours of credit. And we reviewed the documentations and had a discussion and determined that these exams did in fact meet the requirement of this rule to allow successful credit. The rule actually sets forth a couple exams and then sets similar types of exams. And we considered the documents and we looked at the other exceptions that have been granted in the past by the board and decided that it would be appropriate to make the recommendation that they be granted this request. Oh, and then Kathy presented audit reports. Do you want to give a quick?
I'll give a really quick one. The audit's over, that's the best part. We had 484 candidates. Of those, 96.4 were compliant with either straightforward compliance, compliance, carryover compliance, by taking late courses, or compliance with penalties. We basically had no one that wasn't, we had no person non-compliant because we turned them over to complaint, so that may fall into a different category. You know, you can do a statistics what you want to. But we're very pleased that we have such a high compliance rate that people are getting their education and it's all again and
I guess we need a motion on the committee's recommendations, or do we have to vote?
I have a question. It just jumped out at me on tab 2. I know we voted to recommend doing this. I agree with that, but the times 5, the multiplier times 5 at the time. I don't know that we. Is that
Their request was to get 5 hours. Wasn't that? No, it wasn't.
That's what I just. It says the time of the exam times 5 can be used to calculate hours acceptable for CPE. Each of the 11 exams are 1 hour in length, and so basically, if we approved it, it would be 5. If they pass one of the exams, you would get 5 hours of CPE credit. That was the only. I don't know that we picked up on that. The way I understood it was like
For each of the exams, it would be 5 hours for each.
there is one caveat that's already in the rule, because when they test off, only one licensing period, they can only use 40 hours. You can only teach how to test out 50% of the 80 hours.
Say that one time.
You can only
Test out. Okay.
or teach out for those of you who are instructors at universities or whatever, or even short courses. Get 50% of the 80 hours in a licensing period. And this is the premise of the 5 hours for 1 hour of exam is based on the fact that you probably had to do a little study ahead of time before you went to the exam.
Not arguing against it. I just don't know that we really picked up.
We didn't discuss that in full, but I guess our recommendation was to approve it, but we can let the board.
I just want to point that out for discussion purposes.
Do I have a motion on the recommendations from the board? Did you have one for acceptance?
I move that we accept the committee's recommendation.
Second.
I'll second.
Any discussion?
Now, again, I'm not against that. I just want to point that out. Just FYI.
Any discussion? Hearing no discussion, please vote aye in the affirmative if you're in favor.
Aye.
Any nays? Hearing none, the ayes have it. Those are approved. Thank you, Joe. Law and rules, Troy?
Laws and Rules Committee had a brief meeting, and we more or less were discussing the language for proposed rule changes. I think the first was in our January 2012. Considered that. It is mainly regards the establishing a retired license status. The next item will be 2 tiers of that license status, and then we the third line item was licensees of over 65 in retired status and keep their law certificate. Fourth line item, which I think is all. There's expiration of applications for the initial license and then the expiration of CPA term scores. More or less, we were just approving the wording, which is like I say, is over. It's your iPad has the proposed rules and changes. So if you want to, we did accept that's it. I think though we did add if they did sign the CPA to sign retired, but correct? I think
Yes.
it's only changed.
Yes, sir.
And we did have, so they did. Retired status size, CPA, we did sign retired. So those top 5 items on that page that were approved with that addition. And then as you go down the page, we did talk about the language for proposed rule changes first considered our October 2012 board meeting. And that was, might not be, it was replacement of the word elapsed license with expired license. And we did change the rule number. It was changed to rule number 0020-5-036. So we corrected that one.
Yes, sir.
That was accepted that point. And then we had below that, we had more or less the word stating that the board has no jurisdiction over fee disputes between a client and somebody that does license. That was approved also. I think at the end of our meeting, we went through this line list. First time was we do require and we did accept the rule of making hearing in our January 2013 when we did meet to approve the word change. And something that it brief was our meeting.
That was key today. One brief meeting, yes. Okay, do I have a motion to accept the recommendations of the law and rules committee? I have a proper motion. Proper second. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, it passes. The executive committee, we talked about a whole lot of issues. Were any of them votable issues? And most everybody was here, so I won't rehash everything, but primarily discussed the evaluation of the executive director. Anything I'm leaving out? Is that we reviewed Rule 0020, which was really 50303, right? Chose to do nothing with that, right? We left it blank, didn't we? Right. We approved a proposal to print the new law and rule books. We
talked about the default on student loans. I think the attorney was going to give some more information in relation to that topic. We reviewed the financial information, approved the financial statements through this point of the year, through July? August, sorry, through August, and approved that as well. And then we talked about the evaluation of the executive director. Am I missing that?
Discuss the reword policy on ethics education.
Yes. Okay. You want to make that motion?
Sure. Policy Roman numeral 2.6 regarding ethics education is an old standard, an old policy requiring 1 year for.
It was 4 years, 4 hours of ethics, one
Yes.
state specific.
And we changed our rules pertaining to the state-specific ethics and ethics requirement period. So we recommended that the whole policy be deleted since it's no longer relevant.
Right.
If you would turn to, I think it's page 63.
Of course, that's not the same thing on your iPad.
Of course not. Section 5, page 2.
The rules.
You know what, that's not accurate. This was the,
I can't put the reason right away.
That was in the policy statement, Stan.
Yes, it was. It's a policy, it's not a. Policy statements here. The rule of the policy read, in order to comply with the in order to comply with the ethics CPE requirements, active CPA is required to take 1 hour of board-approved state-specific ethics CPE and 3 hours of general ethics CPE from vendors who would normally qualify under the rules pertaining to continuing education under the authority of Rule 002-5-.03, sub 1 and B. And as administrative history, original policy was approved on January 12, 2007. And the executive committee is recommending that that be deleted based on our new ethics requirement.
motion.
I move that that be deleted, as recommended by the executive committee.
Second. We've got a motion and a proper second. Any discussion? Hearing none. All those in favor, vote by saying aye.
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 I'm sorry, I directed you to vote aye. If you're in favor, vote aye. Are there any nays to the motion? Hearing none, that motion passes. I do want to point out that our assistant commissioner here is here for the meeting, Mr. Bill Giannini, so welcome.
I'm here for you guys.
Would you like to address the board?
Good to see you all.
And our last report of the day will be the legal report. So,
Thank you, Mr. Chairman. I've already distributed a legal report that was evaluated and voted on by the Probable Cause Committee. There are 22 items on this report, and the Probable Cause Committee did make a couple of amendments to the recommendations. Those are incorporated in the handouts that went to the board members who were not on the Probable Cause Committee, and I'm assuming that the ones who were made notes as to those amendments. So, and I believe that most of the other board members were here in the audience during the deliberation. So, if anyone needs to take a minute to read through this, more than welcome to do so. At the conclusion, I'll take any questions, and then the board can vote to accept the report as written or as amended by the Probable Cause Committee, or if there are additional amendments that need to be made, they can be made and voted upon at that time. So,
Chris.
back over to you, Mr. Chairman.
Mr. Chairman, Chris, if I recall sitting through the meeting, the last item number 122, the penalty was reduced to 10,000?
Yes, sir, that's correct.
The one I have doesn't have this marked through, so.
Okay.
Yeah, mine does, for some
Okay.
reason.
Okay, just wanted to see if it was just me or everything.
Just you.
Just me.
It's not me, it's you.
Yeah, I got those.
Does the board want to take time, or did you hear enough about these cases sitting through the committee?
It was.
I just don't want to make anybody rehash all this, because we were all pretty much here.
All the changes that we had made in the committee were over here on the printed copy.
Okay.
We just verified the cases that were changed. And they're true.
Okay.
Mr. Chairman, I heard the lively discussion while it was going on, so although I didn't have the document before me, I read it, and I don't have any questions.
Is there a motion in that?
As chairman of the committee, I make a motion to accept our recommendations.
Okay. I have a motion, do I have a second? Second. Okay, any discussion? Hearing none, all those in favor, signify by saying aye. Aye. Any nays? Hearing none, that motion passes. With that, Mr. Director, I don't know if there's anything you want to add.
There is one item of old business, the instructor requirements for state-specific ethics courses. That's on your iPad under Teacher Qualifications, TNSBA SSE, and towards the bottom. These are the qualifications that we came up with, that we feel someone who's teaching a state-specific ethics course should have. This is pursuant to a request from a gentleman who was not a CPA who wanted to teach the CPE for monetary compensation.
Only question I have is on the number 4, was there proof of teaching experience? Are you referring to just teaching experience, period? Or?
Any teaching experience now.
Would this apply just to our course or all the courses that we include, such as professor, I think, gives one that does his PSCA course, others, just our course?
I think when this was handed to us, it was our course he was inquiring about.
But we need to make it very clear, because we approve courses that we don't control who teaches.
Exactly. So this is for our course only.
So this is instructors using our own internal course.
Yes, sir.
Mark, would it be wise to have some clause in here that if a person's been under some kind of disciplinary action, that they would not be eligible to teach ethics? Or probation, or what?
Certainly, that would be appropriate. So they've had a disciplinary action in the past 5 years.
Or current probation?
Just upon initially looking at this, I just had a couple of things I thought maybe the board might consider. Have you ever taught the course outside of the realm of the court staff? And was that in the intent initially to provide that course to anyone who wanted to teach it? Because I think my initial, if this person had come to me, I would have thought we may have gone back and said, well, in order to teach a course, you either have to go through an organization that is qualified to do that, or you would provide your own content, have it approved through the normal system. So there would have been 2 avenues already, and now it looks like maybe we're creating another avenue for offering this.
Yeah, I'm not sure. Okay, I know we can use personal use in here to transfer.
Okay, so
course we're creating is not copyrighted by any stretch of the imagination. It is to educate the CPAs across the state of Tennessee. So if TSCPA wanted to use our course, as far as I'm concerned, you're welcome to it. Assuming that the board will be in agreement with that.
Yeah, I think our goal is to have uniform communication.
Education.
And maybe down the road, that's the best option, right?
Well, and to that end, you brought this point up to Mark earlier, I think, that is there a way that we can provide this course in an online setting to where it's our course, our people? I mean, we go out and do this stuff for free if we work with people, so does it make sense at this point to develop some web-based CPE that could be taken from your desk, for which we control the content, we control the message, we can tailor it to whatever issues we're having in the particular year with the profession. I don't know. That's just something to think about. We've got a lot of people that offer these types of courses. Okay. All right, Wendy, did you get your questions answered?
Yes.
You have anything to add?
No, sir.
Well, we're not even.
This is something that the board instructed us to come up with.
Okay, the rule, okay. So we'll need a motion, I guess, to adopt this rule.
Yes, sir.
With the amendment, didn't you add something?
That if the person asking to teach the course had had a disciplinary action in the past 5 years or is currently on probation, suspension, or revocation, they would not be allowed to teach.
I have one other question. I think it's going back to Mr. Sawyer's point. What teaching experience, I mean, it seems a touch bit vague. I mean, should we clarify that a little bit to see exactly what we're talking about? Does it matter if we're intending it to be a specific type of experience?
I don't think we were intending it to be any particular type of experience. We just wanted someone to have some experience in the arena of being an instructor.
But not necessarily like CPE instruction.
Oh, no.
Taught my kids how to count. Is that, I mean, I'm just looking for the loophole.
I'm still working. Hey, we're working on that. Follow-up?
Follow-up. So, I guess I'm afraid that it might be getting a little convoluted. I mean, so we don't, for other ethics courses or other CPE for that matter, there aren't certain provisions necessarily this stringent or to this level. So, are we creating something that's confusing or hard to understand? We've already approved the content, but is there any other situation in which we specifically have instructor requirements?
This is only on our course that somebody's teaching. We're not trying to apply this to anything except the course we're offering. And I assume by these, they're trying to control the quality of the presentation of our course. Our product. If you're going to use our course, these are our rules. Is the whole idea behind it, as long as we sell it that way.
The TSCPA and AICPA has that same ability by choosing who their presenters are.
Well, picking up on what Wendy's asking, it seems like perhaps number 1 and number 2 are a little redundant. Not totally, but a little bit redundant. It is a very stringent set of rules for the person teaching this one class.
The reason the second one was put in is we were hoping that we could add people, currently involved as opposed to being inactive or retired for 12 years. Because it's, this course is a fluid course. This PowerPoint changes every month or two as things continually change. We have better case studies to put in to get points across. It's not concrete. Excuse me, it's not the same thing every day.
Could you do that by calling number one currently active license and taking out number two?
But, if I may, but if you make them have to have an active license, you may lose some good instructors or professors who are currently holding inactive licenses who are teaching in universities because they are not required to have an active license.
Well, if they're inactive, are they keeping up with the CPE?
They can be.
Okay.
Which is why we put in the proof of 80 hours of approved CPE.
Okay, so what you're saying is that if they're inactive and they choose to continue their CPE,
then they would be qualified.
then they'd be qualified to teach?
Yes, sir.
Okay.
It really wouldn't make sense to get 80
And the attending at least one presentation of the course itself.
We thought that would be useful to see how the course was presented from the staff's viewpoint. It's at the board's discretion as to whether or not that stays. The interact.
All they have to do is just attend one time in their career, I guess, and they make that qualification. I mean, I don't think something, most everybody's seen the course, attended or participated. If we do a web version, we would want to adapt the language to include that.
Okay.
Is it once approved and they're just approved from that on?
Yes.
We got to go to the decision this particular person got a 60-day, and they can't go there, so it's not approved. And I don't know how many people will pass in the future.
Okay. Any more follow-ups to the follow-ups? Okay. Any other discussion? Can I have a motion? Do we have a motion? I'm sorry. I got lost in the day.
I don't think we have a motion, Mr. Chairman.
Can we please, someone make a motion? Proposed rule change.
I move that we accept the proposed rule change as read by Mark with the one amendment suggested by Mr. Elder.
Second.
All right. Have a proper motion, have a proper second. Any discussion? Okay. All those in favor signify by saying aye.
Aye.
Any nays? Hearing none, the motion carries. Mark, is that it?
That's it, Mr. Chairman, as far as I know.
Have a motion to adjourn?
So moved.
A second. You gonna make that motion? Have a second? All those in favor signify by saying aye.
You might want to take the orientation.